say people find themselves in court.
Good morning, Mr. Knopf.
Good morning.
Is Brian Edward Knopf your true name?
Yes, it is.
All right. I do see that it looks like you gave Ms. Pimentel permission to put an X on the signature line on the explanation of rights and court procedure form. Is that to let me know that you did in fact go over those rights with her and that you do understand what's set forth there?
That's true.
All right. All right. Ms. Pimentel.
We will acknowledge receipt of the complaint, waive formal reading, and enter a plea of not guilty.
Not guilty, please
Hello?
shall. Mr. Denisilo, we're handling a different matter. If you could please just wait.
I'm sorry.
All right. Sorry about that, Mr. Knopf.
No problem.
Not guilty, please will enter. The court has previously had the opportunity to review the police reports. I did have one question for Ms. Yell with regard to the carrying a concealed pistol. My memory of the reports were that the officer was not certain if the firearm was loaded or not. Is that addressed later in the report that I missed?
I am not sure. I would look into that right now.
Okay.
It looks like it was not loaded.
All right. If the firearm was not loaded, then I do not have a basis for probable cause for that charge. Unless there is some basis under the statute that allows. My reading is it is a loaded firearm in a vehicle.
Just reviewing the statute right now.
Mhm.
I think that's my reading as well. It looks like if it was unloaded, it just can't be left alone in the vehicle.
Correct, which there's no indication of that.
Correct.
Does the city have a motion?
City will be moving to dismiss cause number 4A0273545.
Which leaves the driving while license suspended third degree, is that correct?
That's correct.
And are we proceeding to arraignment then on that charge alone?
Yes, we already have, so we just need to set conditions.
All right. All right, so with that, what is the city's request?
City is requesting standard conditions.
There's no objection.
Give me just a moment here.
And I was in a parking lot at PCC grocery as well. I wasn't actively
Mr.
driving.
Knopf, Mr. Knopf, at this point in time, it might be in your best interest not to talk about the facts in the case, except with your attorney. All right, Mr. Knopf, I am going to release you on your personal recognizance on the following conditions. You need to notify the court in person or in writing of any change of address, have no new criminal law violations for which there is probable cause, make an appointment with your attorney, make it to that appointment, because they can't help you if you're not talking to them, right?
Right. I just want to clarify. So is
Mr.
it
Hold
considered?
on,
Okay.
hang on. I'll give you a moment to talk, all right?
Okay.
Have no new criminal law violations, make an appointment with your attorney, make it to that appointment, make it to your court dates, only use your true legal name and date of birth if contacted by law enforcement, and do not drive unless you are validly licensed and insured. It sounds like you were about to ask me a question about the interpretation of the law, which is something I will not be able to answer for you because I am to be an impartial jurist. I don't advise one side or the other. It sounded
No, that's not it. I was just going to ask you if the allegation of driving without with a suspended license is it criminal or traffic?
It is a criminal charge. It is a I don't remember, is it a misdemeanor?
The simple misdemeanor.
Yeah, maximum possible penalty of 90 days in jail, $1,000 fine, and 2 years of probation.
Okay, thank you.
All right, so the other charge has been the carrying concealed pistol without a permit has been dismissed at this time. It is a dismissal without prejudice. If the city feels that it does have a basis for going forward, they are free to refile. All
Okay,
right.
I understand. Thank you.
Yeah, but at this point in time, the only case you have currently pending is the driving while license suspended third degree. Okay.
Absolutely. Thank you. I appreciate that.
All right. I'm going to set this matter for pretrial on June 6th at 2:30 in person at the Bothell Municipal Court. Is there any reason you would not be able to attend that hearing?
There's no reason I can't make that.
All right. And so that'll be your next court date. Your trial will be in the July trial term, but your next court date will be June 6th at 2:30. All right.
I understand. Thank you.
All right.
Have a
With
good
that,
day.
yep, you too. Take care.
Yep. Thanks. Bye.
All ayes. 14A District Court for County of Washington, State of Michigan, is now back in session. The Honorable Judge Day 765.
May be seated. Court calls the case of the People versus Annalise Peral. Or Peral, excuse me.
This is the public under Natalie Kate for Miss Farrell, who is a plaintiff.
Need a new printer. All right, what are we doing?
Your Honor, we are respectfully requesting a 2-week adjournment in this matter for discovery with Miss Farrell. May 20th at 1 p.m.
This matter is adjourned May 20th, 2024, 1 p.m. Bond continued. Thank you.
Thank you.
So what was the delay? Never mind, I know. Court calls case People versus Jason Hare.
Now, is that about the people? This is the public defender Natalie Kate for Mr. Farrell, who is approaching.
Your name, sir?
Jason Harris.
All right. What are we doing?
Thank you, Your Honor. As to the pretrial, we are requesting a 2-week adjournment in order for the prosecution to check with the victim as to potential offer in this case.
May 20th, 2024, 1 p.m. Okay, bond continued. Thank you.
Your Honor, if I may address bond briefly.
Sure.
It is my understanding if communicating with Ms. Veloso that I believe she does have the complaint witness here who would like to give a statement. She may have worked with her for information. And Your Honor, that is correct. The complainant or the victim is here.
And what is their wishing a change in the bond conditions?
As to no contact.
Oh, okay. All right. Where is she? Sir, I'll have to ask you to have a seat. Hello. I'm very well. Your name? Yes, ma'am.
It's okay. I would like to request for a sexual contact with Mr. Harris.
For something other than,
Well, we have 3 children. Jason has been the primary caregiver in the morning time when I go to work in the morning. Having a hard time getting reliable childcare, so I can go to work to pick them up and take them to school. I have used up all my personal time to make sure that my children are able to go back and forth to school because of this no contact order. So,
well,
benefit the children to get back and forth to school and maintain my employment.
well, I don't know what that means, but I have consensual contact for childcare. Is that not your understanding? Oops.
No, Your Honor, my understanding is that third-party contact would be allowed for child care, but there was still a no contact order as well as the address.
Well, I didn't do the arraignment. I don't know what third party, yes, if you read that as one sentence, third party consensual contact for childcare.
If I may, Your Honor.
You already have. Go ahead.
How that has been working out is Mr. Heron's godparents as well as his mother have been often needing to go between picking up the children so they can have parenting time with that, and that is his understanding of the condition as it was set and what he had been doing at this time. He's requesting it to be set as they have contact with the complainant.
Well, as soon as, well, I'm trying to figure out what this means. Do the people have a position on this?
Assistant prosecuting attorney working for us on behalf of the people. Our notes reflect that there is consensual contact allowed for the purpose of child care. However, the bond form indicates that there's third party contact. I think that so long as the record is clear that consensual contact is allowed for the purpose of child care, that would satisfy both parties.
Where did his understanding of that condition come from?
I believe a in the bond form, Your Honor, that third party contact is allowed for child care.
Where do you have it? Who did this arraignment? Hillary. Third, okay, I see the bond form and it indicates third party consensual contact regarding 3 children. So ma'am, your understanding, so what's been happening with the children? Because I'm going to tell you how I interpret this and what this means, but go ahead.
So I've been having to take the children on my part to my family's house. Because I understood that there was no contact between Jason and Max, so that was
Right.
contact. For the very long week, about a week, to find reliable childcare. So in order to not have a burden to find reliable childcare, I was asking that Jason have contact to take the children for me,
To do what?
that he would take the children for me to take them to school.
Okay. So I hear you. I'm just trying to figure out how would you see that working? Because you're on hogs, right? So how would you see that child care exchange happening, I guess?
Well, you would have to come to the house.
Well, which is the other provision. Third party consensual contact regarding children. I just don't. So what were the people suggesting?
Our
Because-
original request was not for a third party, it was to use like the My Family Wizard app or text conversation with regard to child care in the form of consensual contact. I think that if this were modified to allow for consensual contact, that with regard to child care purposes only, that would satisfy the victim as well as the defendant.
But then I would have to lift the no go to. Because from what I understand, what she's indicating, that's where he would go to pick up the children. So you're asking me to get rid of 2 conditions. The people's request for the third party contact was for communication really regarding children, correct? Is that?
Your Honor, our initial request was not for third party contact. It was to have direct contact through written exchanges with regard to child care. I believe where the third party came in was in the child exchange. So as to avoid in-person contact
Got it.
through custody exchange.
Got it. Okay. here's, and ma'am, so that you understand what I'm trying to think this through because of what you told me. I don't, in theory, have a problem with what you're requesting. It's just how to make that happen because I'm not going to lift the no go to provision, right? So it's how would that be accomplished? Maybe I'll ask you this. Maybe I'll ask you the hard question. Hurts your brain too. Okay. Okay. So you, so explain that to me. I'm just trying to think. You leave at 4:30. You then take, how old are the children?
6 and 2.
Okay.
Take them to my sister's house.
You take them to your sister's house. And then he shows up at your sister's house to take them to school, or what happens then, I guess?
She would have to take them if she's able to watch them, and that's not been consistent. That's the issue. I don't have a reliable child care.
Got it.
He was quite dependent on the child. I don't have anybody else. I have a mother who's disabled. I have a father. Jason's my support.
So you would envision this being at 4:30 in the morning, the children go there, or tell me what you're envisioning, because then I can.
I'm visiting, getting up for work and being in my car and out the door when Jason gets to the house. So there's very bad contact. That's what I'm doing.
Is your schedule in terms of your work consistent? I mean, is it the 4:30 every day, or is that how it operates for you? Okay, so, and again, help me here because I remember those days for me, but I usually, so the 3 are there. You leave at 4:30. The children would go with him, correct? Okay. And then how's that flip around on the other side? Oh, you pick, okay, so then, because your day would have ended, you can go and get them from school. So it would really be on those days, well, it would be one time per day, really, that. Council approach, please. Okay, man. So here's what I was thinking, and you tell me if this is gonna be too tight. That I would allow basically a half an hour window is my thought of him being able to be at the address, get the kids and go. Is that too tight a time frame or?
Pick up the kids and get the house, get elsewhere.
Is that what he would be doing? I thought that's what you told me. Okay, and then he's at the house until time to go to school. Okay, I don't know. I heard that differently. I thought he was coming there to get the kids to pick them up to then go someplace else. Gotcha. So if you're out at 4:30, kids go to school at 8:30. They're at Carpenter. Okay, so. Boy. Either side have any, I had given that half hour because I thought he was picking them up, taking them someplace and then getting them to school. But when I look at the address and they're at Carpenter, that makes no sense, right? So is there going to be a problem with having a window of time that the defendant could be at the address for the purposes of childcare to then take the kids to school? So okay, so how's that exchange? Mm. You would go to what house? The Hawks? But that's where you are.
Maybe Jason can bring the child to the school.
Yeah, dear goodness. And let me do this. Let me pass the matter just a bit if you've got time. Let me get through some things here and then let's try to the details because he would be there at that point. But let me ask this. At the point that the other two go to school, what happens to the 2-year-old?
That's fair. He's always been there.
So even under the arrangement that you had, he was with dad. And where's dad take the 2-year-old?
My understanding, he has been staying with his mother, and that's usually where you take your 2-year-old.
Okay. So what happens is, or what you would see happening, but somehow and or another, the 2-year-old has to be returned to your care for the evening. How far? Your mom's down in Nipsey. Yeah.
We work 2 separate shifts. So there's, when she comes at 3:30, I work at 6. I can leave when she comes to go to work. And when I get off of work
Hold on, you gotta back that up for me. You went fast. It makes sense to you, but I gotta follow in my head.
So.
She works you work 4:32.
4:30 and 2:30.
Okay,
Get home, yeah, about 3 o'clock.
got it.
I work 6 p.m. to 2:30 a.m. So we never had childcare that because we work 2 separate
Shifts. Got it. So as you're coming off of work, the idea would be that you would then arrive at some point to then take care of the children as she leaves. Then she's gonna pick child up, the 2 of the children from school, right? And then somehow or another, then has to get the 2-year-old. That's the way it always was with me. The 2-year-old always does the problem.
I can pick the children up from school and return them home.
Say again.
She gets home. Sometimes they work 10-hour shifts. She gets home. The time-
She gets home, but if she gets,
I think-
okay, so at the residence and then go, because you've got to get yourself ready to get to work. Got it. So let me ask this, because it isn't complicated enough. School's going to end soon. What then? Because
I don't get my care like what you do until she comes home. That's how it works.
okay, so got it. Okay. Here's what I'm gonna do. Because really, yeah, we're operating with the school schedule, but we're really operating with the work schedule on childcare. So I'm gonna keep, and counsel for defendant will draft an order satisfactory to the people, and then if you guys get into a dispute as to language, I'll get with the language. Two periods of time, because that'll take you through the summer, or if this case goes beyond that, it will be able to operate this way. But it's really gonna be operating off of the work shifts. So that there's a window in the morning that they can have contact at the Hawk Street address. And then also a window, I guess it's the afternoon, that also that contact can occur. Everybody follow me? So I'm just looking at 2 windows of time where that exchange can happen, and then they can also get themselves to work. All right. And it won't matter in a certain respect whether then the children are in school or not. I mean, Carpenter's right around the corner anyway. So it won't matter, because he decides to pick the children up and bring them there, as long as he does that within the window, then fine. Make some sense? Okay. Since you brought this to me and made my head hurt, counsel for defendant will prepare the order. And like I said, I'll work on that. Ma'am, will that, you think, work for you? Not a problem. All right, thank you. I've got exactly 2 cases. Court calls the case of people versus Messiah Wadlington. Also, just on that last matter, on that order, I want that third party consensual, I want that, delete that language.
Yes, Your Honor.
Okay, because I don't know what that means, and nobody does, it seems. All right, go ahead.
This is probably better to have a paper as well.
Every day in the USA, people find themselves in court.
Michigan versus Craig Newby. Can I get appearances?
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
Good morning, Your Honor. Maggie McDonald on behalf of Mr. Newby, who was present in court this morning, P80744.
Sir, can you tell me your name?
Craig Newby.
All right, so this is the time and date set for probable cause conference. Can you tell me what is the status of discovery?
Your Honor, I have just been tended discovery by Ms. Johnson in our email, so we have not reviewed anything yet. It's just been sent over to us.
Tell me your last name one more time.
McDonald, MAC.
All right, so discovery's been tendered, but you've not reviewed it.
Yes.
All right, and we have a preliminary exam currently set on this matter, Mr. Newby, on May 13th, so next Monday at 10 a.m. Is that likely to occur?
Your Honor, I cannot, I would say at this point, probably unlikely to occur on that date. We have not reviewed anything. I do not know the status of what we would do with an exam. I would ask that the PCC be reset if possible.
Okay.
Because I have not really discovered it. A week should be sufficient. We can just reset this. For a
All
week.
right, well, let's pick both dates. So if I set a PCC, that PCC would be May 13th. It would just take place at the examination. So May
Yeah.
13th, next Monday, we would have an adjourned PCC at 10 a.m.
That is fine, Your Honor.
That's good for the people.
All right, and that can appear via Zoom. And then the following week, May 20th, I have one exam slot left at 11 a.m.
I can do that, Judge.
Yeah, we can set that and then we can determine that next week at the hearing.
All right, so the exam will be 5:20 at 11 a.m. in person at the 23rd District Court. Any other matters?
Your Honor, yes, the court, we would like to address bond at this time. I have spoken with the prosecutor regarding this in our, we did submit a motion to the court.
I did not receive a motion. When was it submitted?
30th, Your Honor.
I do not have a bond motion in my file. Did you get a copy of that, Ms. Johnson?
No, Judge.
Okay,
I did address it with her, so I'm happy to allocute or.
all right, you can
make a motion.
allocute.
Your Honor, in this case, Mr. Newby's bond is set at $300,000 cash.
100,000. Oh,
It's-
$300,000
it says
cash.
$300,000 cash set by, a different judge in this case. This is Mr. Newby's first ever contact with the criminal justice system. He has had no history of anything, up until he's 30 years old. He has retained counsel since being incarcerated last week. He is taking this very seriously. His family is here and they support him. He does own his own mechanics business, CJS Truck and Trailer, so he's very hardworking.
I would ask that this court please reduce that bond. Just something that's more manageable for him. Obviously, I'd ask for a personal, but a smaller cash amount of 10% would be sufficient so we can better assist his attorneys in his defense and he can get back out to work. He does have support. And again, I can't stress the fact that he's not had any contact with the criminal justice system. This is his first ever offense in 30 years. So we would ask that this be loaned so we can assist us in this process.
All right. Ms. Johnson, what's your position on bond?
Judge, I will leave it to the discretion of the court. I will just apprise the court that the allegations in this case are that the defendant communicated with someone who was acting as a 15-year-old, agreed to meet up with this 15-year-old, and did show up at the house to meet up with the 15-year-old to engage in sexual activity.
I'm not inclined to reduce bond at this time, but I will request a DSU report, and we'll have that next Monday.
Okay, I was gonna say, if we can bring this motion up again, we would have.
Well,
an objection to
I'd like to read the
Heather.
brief. I would like to read the brief that I don't have. And I'd also like to see what they have to say downtown. So we'll request a DSU report. We get those back promptly, so we should have that by next Monday.
Yes, Your Honor,
And it's
and
PCC.
there a better way to file, because our staff contacted you guys, I believe it was faxed over.
There's
Or emailed, I don't know how, I want to make sure, because I have a copy and we were pretty diligent with getting this out as fast as we could.
Well, I don't doubt that you sent it. If it came in on Thursday, it might be in my inbox in the back. It's Monday morning. So I just haven't, I haven't seen it. But if there is an online portal on the
We can revisit this on Monday, I just.
All right.
Pretty adamant to.
All right, so we'll see everybody next Monday at 10 a.m. I've requested a DSU report, so we'll address bond again at that time, once I've had a chance to review defense's motion as well as the report from downtown.
Wouldn't even consider a 10%.
I will not, no,
Okay, thank you, Your Honor.
thank you.
Every day in the USA, people find themselves in court.
CR 2056, now called William O'Neill Walker. Is that you, sir?
Yes, sir.
Present with your attorney and the state's attorney. You were charged here with an indictment handed up on November 8, 2023, charging you with the second-degree felony of aggravated assault with a deadly weapon. What are we here for today?
Your Honor, I think it was initially set for an announcement. It's also, there's a writ that I filed, so I think we're having, I would assume the writ's been issued over here on the relief request.
And Your Honor, previously in cause number 22-41124, that was the case that was dismissed earlier this morning because it was re-indicted as 23 DCCR 2056. But in that cause number, the court revoked the defendant's bond because he had been contacting the victim and numerous times violating the order of his conditions of bond. And the state would ask
bond earlier.
Yes, Your Honor.
You're saying.
The state would just ask that would, the court would also order that in 23 DCCR 2056, because I think it shows $100,000 bond on there, but that was just because it was re-indicted from the other cause number, which had a no bond on there.
So he presently has a $100,000 bond.
I thought it was originally $100,000, wasn't it?
On the
Originally set back in 2022.
I believe so, Your Honor. Then you put a no bond on the
50. I think it was 50 originally. What we said. On the and 22 on what?
When I first arrested.
What was the 22?
Wasn't so deal with that. Two bonds.
Right, that was 50,000.
Yes, sir.
Was there another bond also?
No,
Just one $50,000?
right.
He made a $50,000 bond that was revoked and then he was being held without bond.
And so he's been re-indicted and rearranged and it's set at 100,000 now.
Correct.
Well, we would be. I think the writ was filed at a time when there was no bond, and since then that case is dismissed, and I suppose now it's been re-indicted at the $100,000 bond. So actually, I don't have. Guess we wouldn't really be here on the writ if it's $100,000 bond. You make that, or make the proceeding posted?
Yeah, I can post it.
Okay.
Yes, sir.
So we would just request that.
Well, you can't have any, if you make this bond, you can't have any contact with the victim.
That's understood.
Or
Waiting finish.
things would happen that would be severe to you. Because we want to freeze the action until the case can work itself out.
Yes, sir.
And that means the action is not frozen if somebody tries to get in contact with parties.
And Your Honor, the state would just request that no bond on the other be ordered on this one. The only thing that's changed was re-indicted and a different deadly weapon was alleged. Do have the victim here, and again, she was contacted numerous times by the defendant while he was on bond on the other case, the 21.
What was the original bond?
50.
50, and then
he revoked it and held him without bond.
He's going to be residing out of state, I believe. Is that correct?
Yeah, like I was at first.
And this case was also set for trial today as well, Your Honor.
And I requested a speedy trial. So we're ready to try it whenever the court is.
Already trial.
Whenever the court is.
are y'all ready today?
Yes, sir.
I'm ready.
You're ready today?
Yes, sir.
Who did we send to drug impact?
We sent Mr. Ham and Mr. Franklin over to drug.
Your Honor, just to be clear, I think they're gonna be retrying a case with Buddy Reynolds and Chris Cadena over there in drug court. There's
They
another one
did
there.
have a case set, but they said in case that falls through to send one, it was Mr. Ham and Mr. Franklin there.
But they're gonna be trying that drug case, I'm pretty sure.
We can be ready next week again, Your Honor. Or whenever.
Well, do I have a trial docket next week too?
Yeah.
Do I? Okay.
Yes, sir. I haven't worked it up yet, but we do have.
Okay, so it was 50,000 originally. Now it's been
100,000 under the, as it was re-indicted. Yes, sir.
okay. And where are you going to be residing?
In Mississippi, where I'm from.
Where, what's the address?
Yeah, can't she?
What
Is it
city?
3024 Marion?
That's my home address, yes, sir.
Is that where you're going to be?
Yes, sir, that's where I'll be.
Okay.
What county is it?
Hines.
Orange County, Mississippi.
Yeah.
If somebody's shaking their, well, look, somebody's over there shaking their head. Why don't you talk to those people? What are they on? What's that all about?
That's just-
The victim, Your Honor, and again, just very concerned that if the defendant was allowed to be out, that again, the underlying nature of this case, he alleged to have rammed her vehicle off the road.
Yeah,
Got out and he's assaulted her. She's very nervous about that, as well as the defendant now, the only offer is a pen time offer, and it's been that way. The state has concerns about him being a flight risk and not coming back from Mississippi, knowing that there is no probation offer on the case.
Well, we always have the GPS device. I suppose somebody can just cut that off and run if they were so inclined, but I don't think Mr. Walker's inclined. He doesn't have any criminal.
Put the lady on. If that's what you're asking to do. Let's sing here now. Y'all have a seat.
They would call Miss Robbie Gilmore.
Come forward, please. And raise your right hand. Do you solemnly swear or affirm any statement you make will be the truth, the whole truth, and nothing but the truth, so help you God? All right, just have a seat right over there, please. Thank you. Why don't y'all turn the lectern, please? Thanks for just this hearing. Thank you. Go ahead.
Please state your name for the record. And Miss Gilmore, are you familiar with the defendant, Mr. William Walker? And how are you familiar with him? And previously, he's accused of, did he ram your vehicle off the road and then began to assault you?
Mr. Walker left. We were apart. He was in Mississippi. He watched my doorbell camera, saw me leave in an outfit that was inappropriate in his opinion. Drove the 6 hours from Mississippi. Waited outside my apartment for me to be alone in the car. Well, let me rewind. At first, when I was at dinner with my friend, who was a lieutenant of police for this Beaumont Police Department, called and threatened him on the phone because I was going to have dinner with this man. Waited for me to return home from that. Approached my car with a brick, which he hit my car 2 or 3 times. I don't remember exactly. So what howled and loud that my children thought he had shot me in this parking lot. I backed out. I was in my car. He got in his own car, followed me to the gas station where I was on the phone with 911, trying to give them an address. He got out of the car, coming at me again. I got back in my car. Mr. Walker chased me from 105 and Major Drive all the way to behind Academy on like Concord or something, ramming my car from behind, from both sides, numerous times. I finally went through a fence, into another side of a fence, and into a tree when my car stopped. He then pulled me from that vehicle, took a board from the fence that I had gone through, and beat the living hell out of me until the police got there. He screamed at me the entire time, "Where's Andre now?" The man that I was at dinner with.
Hold on. Did you go to the hospital?
Yes, sir.
What injuries did you sustain?
I had a bowel obstruction, and from hitting the steering wheel so many times, that's not correct. It's a bowel interception, to be medically correct, where when your intestine goes inside the other part, but essentially it doesn't work. And I was physically, people gasped when they saw me for months after. My face was,
Yeah.
my vision's worse.
Is there any photographs of her condition by any chance?
I have someone on the phone. Oh, my car.
I don't have them printed out, Your Honor. Yes, there was several photographs with showing bruising and contusions all over her face, lots of bruising. They're
Yeah, okay, show them on video. Just plug it in, show them. It's what?
A reduction there.
There it
It's an asset that we reduced.
is. Trademark, that's what Rick says then.
We considered 100, so we're happy with that. This would actually be a hearing in the hospital.
Since it's already diamond, it's the standard that 100,000. It's the same chart that you just.
That's usually the name of that, but that was our point on the field against me, so I would like you to. Without that position, we might have to go.
Is jury out there? Ready? Tell them. We're gonna need.
I'm gonna be brief, Your Honor, I'm not.
Oh, a little while. Tell them we're having a hearing that needs to be disposed of, and we'll be there as soon as possible. Please, Dennis, thank you. Did you say you have something on the phone? Can you just, somehow, we got a time issue, so let's see what we can do about moving this along. You're showing me a.
This is, this picture,
Okay, and what is, these are 4 photographs in a montage, right?
The approach, Your Honor?
And what is this?
that,
What is this
so that.
what is it showing?
The injuries. This
To
is-
you?
Yes, sir. Yes, sir.
From-
From Mr. Walker, from the attack, from him hitting me.
On October 31st of 2022.
May I see those?
Yeah. We can make somehow get a copy of that, please.
Yes, sir.
For the record. Call that State's Exhibit 9.
Yes, sir.
For this hearing. There's 4 different photographs there.
Yes, sir.
And
What is the before?
Hmm?
What is the
Don't shout out of the crowd.
Pictures in front of the top of this. And then the 3
Ma'am,
bottom.
Yes, sir.
You're here, you're under oath. What, there's 4 different
There are 4
photographs?
photos. The first one, this is before, that night before, this, these are.
When you say this, that,
That, I'm
I mean,
sorry.
I don't see what you're talking, I don't follow you at all.
Okay,
What?
this is my face
The one at
before
the
there was
top.
attack, yes, sir, at the top. This, is a few days later after the attack.
Wait, which is on the right side,
On the-
middle right side of the
Yes,
image.
sir. These are both from a few days
When
after.
you say these,
Both pictures, the right and the left in the middle.
okay, and
Um,
at the bottom,
that's immediately after the attack at the hospital.
okay, and what's it again at the top?
That's just a before, that's just a before picture.
Oh,
Yes,
But it looks
sir.
like there's something on your right eye, right?
Well, it's a mole, I still have it right now.
Oh,
Yes,
oh,
sir,
okay.
it's just the way I was made. But I have pictures of, my car and my other pictures of my face, I do apologize.
From the event.
Yes, sir. Yes.
Let's move along. But obviously you had damage to the vehicle is what you're
I mean,
saying.
my car was totaled, yes,
Oh.
sir. I went through a fence and into a tree.
Y'all don't have any, y'all don't have photographs of this?
Compressed on a disc, I'm
Yes, sir.
compressing them right now.
Oh,
Yes, it takes a little while.
I don't even know what that means. Compressed on a disc. I mean, put on a disc with a bunch of other stuff, I presume.
Yes, sir. And the way they save it allows you to save more stuff onto a disk, but it's,
Okay, so,
yes, sir.
you can take your seat, go forward, please.
And Ms. Gilmore, do you feel as though the defendant should be allowed a bond in this case?
No.
And why is that?
Mr. Walker contacted me.
When?
After the attack. And he was very well aware that he should not contact me. He never stopped contacting me. His own phone number, from text app phone numbers, the contacting me, the making
Was he
Facebook.
contacting you? Let's get it clear,
con-
because it's in a void here of time. Was he contacting you after this event and after the court ordered him not to?
Yes, sir. After the court ordered, I had a restraining order against him for one, an emergency protective order was put at the scene. He then, he made bond, and the condition of his bond, from what I understand, was that there was no contacting me at all. And,
That's a standard bond condition in this county.
he called me, he texted me, he videoed me. I have videos, I have Snapchat, I have, it ranged from loving me to hating me, to wanting to kill me, to wanting to marry me. You never know what version of William Walker you may encounter.
But wait, what did you read? Were those texts, or did you say they're texts?
There are some, yeah.
Do you have a text where he, after he was placed on bond, not to have contact with you, threatening to kill you?
I do not have that. No.
I believe we entered last time, Your Honor, at the last hearing, we entered the list of phone calls. I know there were probably
It was 700.
over 100 that we entered as an exhibit.
There was I know there was an extraordinary amount, which the
I mean,
bewildering.
not only just the call, the driving by my ex-husband's house where my children live, having his family contact me, people I work with. I'm a
What are
lot
they,
of listeners.
what's being said to?
It ran, his father offered me money to drop these charges, which I didn't, the charges in the state. His girlfriends, numerous of them have called, text, made threats.
The girlfriends?
Yes. It's, I mean, following me, in a car. For one, Mr. Walker.
Wait, who's following you?
Mr. Walker. I mean, not now, he's been in jail since October, but previous to that. The context never, numerous times, Mr. Walker made a Facebook profile with my entire nude body and put it out for the world to see. Just harassment to no end. I shower with a gun now, like that's my life. I even when he's in jail, I think he's smart enough to calling somebody and letting him out. He's a very charismatic person. He was supposed to reside in Jefferson County with the condition of his bond last time, and he never resided in Jefferson County. He enrolled in college in Mississippi, as a matter of fact.
Do you know that?
As far as I'm aware, Your Honor, yes, he went back to Mississippi, but
Did I order him to stay in Jefferson County?
I'm not certain on that.
I need to be alerted from the state if they're aware of bond conditions, because I'm like, bondsmen generally don't follow me.
I don't believe at the last hearing that you did order that. I believe you said if he did get out eventually that he would be allowed to go there, but would have to obviously give the correct address to the bondsman where they could get a hold of him.
Where else you want to add?
Ms. Gilmore, do you believe that you would be in danger if the defendant was allowed out on bond?
Myself, my children, anybody that is affiliated with me, yes, I absolutely believe that.
Pass the witness, Your Honor.
The offense is alleged to have occurred back in October, is that right? The alleged offense?
The offense occurred October 31st, like the Friday from the night.
2022.
2022? Right.
Yes, sir.
So over 2 years ago,
No, not 2 years.
No.
October
So only a year
22nd,
and a half.
a year and a half, okay, year and a half. And so how long was he out on bond?
He went to jail in October of 23, so he was out for 1 year. That's 1 year of torture.
So he's out for a year. And during that year, how many occurrences did you have with him during that year?
If I did not speak to Mr. Walker, if I didn't ignore his calls, texts, it only got worse. There was not a day that the man, oh, that's it. There were a few days, about 3, maybe that he didn't contact me, but otherwise every day, call, text, Snapchats.
So you were aware when he was released from jail that there was an order prohibiting him from contacting you? And so who did you notify that he was contacting you?
The district attorney.
When?
The bond.
When did you notify the district attorney that there were improper communications?
But did you contact the DA or the bond person? Because those are different. Oh.
When did you notify the bond person or the district attorney's office? Well, how long after he was released from jail?
Days.
Couple of days, then a week? And did you continue to notify them during that period?
Yes.
How often would you notify?
Probably once a week until I just gave up.
Who did you contact at the district attorney's office? You left messages for Mr. Boyd weekly for how
Well,
long?
not weekly for Mr. Boyd. I'm talking about the bond's office.
Who at the district attorney's office did you contact, if anyone? How often did you contact Mr. Boyd? How often would you say you contacted him? Every week for a year, or every other week, or every month, or how? I'm sorry?
I do not know. Several times I contacted them. I'm not sure.
What time period? Did you contact the DA's office?
Sir, I'm not sure.
Well, was it
But I know
in,
that I did contact them.
was it in November, December?
You're not sure?
I'm not sure.
Was it a week ago? I mean, when was it? When did
I
you?
said I'm not sure, so I'm still not sure. It doesn't matter how many times you ask.
Wait. Was it what is this? Was it recently? It's a week though.
That I've contacted him
The
right
DAs?
now?
Yes, ma'am.
No, sir, I haven't. I mean, I contacted them last week to see if we were still set for trial this.
When did you go to Mississippi to visit Mr. Walker?
I don't remember exact dates, but I have nothing to lie about. So yes, I did go to Mississippi to visit Mr. Walker.
The question was when?
But
Do
sometime
you remember,
after.
do you remember what month it was? Was it summertime or wintertime? Was it hot or cold? Let's start with that. Did you wear a jacket?
Do you know? Do you know? Okay, she
You
doesn't.
don't know which month it was?
Was it after he was charged with this
Yes,
event?
sir.
Okay, go ahead.
Which month?
Do you know?
I don't know.
She doesn't know. Move along.
Well, I think it's relevant, Your Honor.
She doesn't know. It was,
It was
I got a
after the
trial.
contact order,
I've
that's
got,
what I know.
hold on, everybody. I've got
What was,
60 people waiting outside to pick a jury. Let's move this along. Her answer is consistent. She doesn't remember. We can sit here until the end of time. She doesn't remember is her answer in the record. Ask your next question.
were you forced to go there?
Was there a gun to my head? No, but did this man threaten to kill my children if I didn't comply with him? Yes. And do I believe him? Yes.
So your
Yes.
testimony is you went to Mississippi to visit Mr. Boyd because he was threatening to kill your children?
Well, no, I said I went to visit Mr. Walker. Mr. Boyd doesn't reside.
I'm sorry, Mr. Walker. Right?
That is what I said, yes.
She's listening to the question.
Good. he forced you to do that? Or was it voluntary?
You have children?
I'm
No,
sorry, I'm
just
not being
answer,
questioned.
ma'am,
Yeah.
not rhetorical. Answer the question, the yes or no, or give an answer.
I'll go.
Don't answer, don't ask it
Sir,
with a,
I apologize.
don't answer with a question. Go ahead. Go ahead.
Physically, he did not force me, but he had already nearly murdered me for not answering, for simply not complying with his phone calls, his demand. The man is insane.
So
So
you're,
when he tells me he will murder the people that I grew in my body, I believe him with every fiber of my being, and I would have done anything that he asked me to do as long as he was out of jail.
so he
At
threat,
that time, I still reported the things that he was doing and asked the people that are supposed to help me to help him.
so you told the police that he had threatened to kill your children and you were going to Mississippi. You notified the authorities of that?
I notified them that he called me repeatedly. He never called.
Yeah, let's not question if you like. When you're testifying that he threatened your children to kill your children and that's why he went to Mississippi, did you notify the authorities before you went to Mississippi that he threatened to kill your children? How long were you in Mississippi with him?
A day.
One day and then you came back? I'm sorry?
Not very long, enough time to drive there and drive back. So,
Did you have relations with him?
yes,
Did you had sex with him?
yes, I did.
So you were so terrified that he made you have sex with him? Is that why, was it a sexual assault? Did he sexually assault you in Mississippi? Or was it consensual?
Out of fear, it was out of fear. So you can define abuse how you will.
So the only reason you had sex with him is he put you in fear for your safety and your life in Mississippi?
Yes, there's no. I can't explain. to
Ma'am,
you
it's
that
a simple question, yes or no? I'm asking you, did you have sex with him? Because,
Sex with that man.
let me
yes, I
finish
did.
my question.
Hold on, don't shout.
Did you
at
have
that
sex
lady.
with him?
Hold on.
She's
Don't
not
sh-
being
Yeah,
responsible.
I know, but where does it say you can shout at a witness? Be professional if others aren't. Thank you.
You had consensual sex with him, or did he force you to have sex because you were afraid of him, out of fear?
It was forced out of fear. Everything
Okay,
I did
okay.
out of it, I tried
So-
out of fear for myself or for my children.
So he sexually assaulted you in Mississippi. Did you report that to the authorities in Mississippi that you were sexually assaulted by the defendant?
No.
I passed the question.
Anything else?
Just
Go ahead.
Ms. Gilmore, you had contacted our office about the defendant trying to contact you, is that correct? At that time, were you able to show that was actually from his phone number?
No, and until about a month before he was arrested, so it was in September of 2023. Mr. Walker used an app, he's intelligent, and he did not use his own phone number, so I didn't have any proof that it was him because it was not traceable.
And did I advise you that we'd need some kind of proof that it actually went back to the defendant from his phone number?
Yes, sir.
And were you ultimately able to provide me with some phone records showing that him calling from that number, sending messages, and ended up someone sending a video of you nude to your ex-husband? Okay. And also at the last hearing, you went to Mississippi with the defendant after he had the no contact order, is that correct? Did you advise that if you didn't go, he would continue contacting you, like you were able to show the approximately 100 plus times that he had? I passed the word.
Fine. Anything else in this lady? Okay, you may be seated. What else?
Another brother from the state.
What's everybody, what were you asking?
Your Honor, my understanding, I guess since this was a reading, but this has an
This
extra,
thing's
actually is a
bounced around.
red hearing, it's the state
Okay.
attempting to have
I'm
a
trying to
bond.
figure out the bond is the bounce from 100 to no bond to what is it now?
100. When he was re-indicted, evidently.
or 50. It was 50,
No
then no
bond.
bond, then 100, right?
When he was rearranged, it was probably set, the magistrate at the jail said it. So that's where we are. So this isn't actually a writ, this is them moving to pull the bond that was set on the re-indicted case. I guess it's their motion.
Yes. What, any arguments?
Your Honor, the state just believes the interest of the safety of the victim. We would ask that, again, the defendant be continued with a no bond, and we're ready to try this case. If you want to set it next week, we're ready to go, Your Honor.
I would just say, I think to be continued, it would be continued at $100,000 bond. I mean, it seems what the state is asking, that bond be terminated and go back to a no bond status, since he does have a $100,000 bond now. We just request the court to leave that in place. And with the additional admonishments of the no contact, perhaps the GPS monitor. And then we're ready for trial, whenever the court wants to say it. Obviously, I think the court might infer, from this hearing that we think that we have a decent case, at least for probation perhaps from the jury. It is a 10-year cap, which he's refused. And obviously he is eligible, he's not a convicted felon, so we're eligible for the jury to consider probation, recommend probation in the case. And that's what we're in.
Would you say it was a 10-year cap? What was?
That's the plea offer. It's a 10-year cap, which he's refused, but
Oh,
I will be asking the jury to recommend probation. I would go to the jury for punishment because he is eligible for jury probation.
What bothers us for is after the defendant was placed on a bond with the conditions of bond, which are normal and customary, and also are placed on the or in the website and are the general rules that all defendants must adhere to. And one of those is do not contact the victim. And according to the evidence, 762 calls is ridiculous. I mean, that is very questionable on stability of mind. I've lived my whole life and I use the phone, and I've never called anybody 762 times. I don't think, maybe my wife over the length of our marriage, if you add all that up, yeah, but not in a short period of time over this. This is and the facts of this case are, let's see, ramming. This is all found. This is all occurring what at midnight or so. So when everybody ought to be at home, they're out. Somebody's out ramming vehicles, and the defendant. And let's see. After the wreck, according to the probable cause affidavit here in the file, this case, after the wreck, the defendant took the complainant's phone through it while she was attempting to speak with 911 dispatch, then proceeded to strike her several times in and about her face and head area. And she's shown the court severe bruises of her face that she says occurred because of the defendant's strikes. And so he's using, he's indicted here for the second-degree felony of aggravated assault by ramming a vehicle with his vehicle. So we're using a 4,000-pound missile as a weapon, which caused the vehicle of the victim to careen off the road, strike a fence, and according to the grand jury, in a manner of which use and intended use was capable of causing serious bodily injury or death in the commission of the assault. This is just like something right out of a movie of sorts. I mean, it's bizarre behavior. And so the defendant is on bond, then the bond becomes no bond after information comes about of the defendant harassing the victim while on bond. Is that a fair statement? Okay. All right. Here's what the court's gonna do. Oh, okay. And so why is there $100,000 now? That's current bond. I thought there was a bond that was 100,000 that then was revoked on, that there was no bond on the new case.
I believe it was $50,000, Your Honor, the bond on 22-41124, and that was.
Who said the bond at 100,000? Me?
Or
Another,
I think the magistrate did on that 20, that was the re-indicted case.
with a new, okay. Well, the court again uses the public safety report that the court has in the file here, and it's made a part of the record, which shows that the defendant, I don't see a criminal history, do you?
No, Your Honor.
Okay. Well, that's a point for him, but you go right into the criminal world with a big bang here in what's happening over this bizarre activity over romantic relations. I mean, go figure. That's really, if you look at the definition of romance, it's not, threatening behavior, ramming vehicles, punching girls, and calling them 762 times. Romance just doesn't fit that definition at all. That's bizarre behavior. And so it's $100,000 now, and the situation is you got to pay a price for committing violations while on bond, and your bond, I mean, you were ordered on a bond, the same conditions or on a general bond. I would add conditions of bond, but is it $100,000? Is that the final amount? Is that what the bond is right now?
Yes, Your Honor, on this.
Does the magistrate set that?
Yes, sir.
On the new indictment.
Well, did the magistrate have a hearing with this evidence? I don't think so.
I don't believe so.
Your bond is $150,000. And you have you shall have no contact with the victim. And I want this is, you're in Jackson, you're gonna live in Jackson, Mississippi. I don't want you in the same state. I don't, it says Jackson, Mississippi, right?
Yes, sir.
I don't want you in the same state with the victim. You're living in Texas, ma'am? Yeah, I don't want you coming into Texas until you come into court.
Other than a court date.
Yes, sir. That's all I'm.
No contact
Yes,
with
sir.
her. I want you under the GPS device, so I know where you are.
Yes,
Your
sir.
phone, I want to be able to search your phone at any time. Bring your phone in, and I want to be able to search to see if you attempt to make any phone calls.
Yes,
Now,
sir.
I know you could make some phone calls on somebody else's phone, but if she is harassed, you're the lead suspect. I don't care what the situation is. From what I know now, your bizarre behavior while on bond causes you to be the center of my attention now, which is what you don't want. So you're on hyper alert with me, and
But Your Honor, if I might, since he's coming from out of state, would it be a day before court and a day after court to be in Texas?
it just
Or
comes,
or just
no,
one day?
no, he comes in on the day of the
Day
hearing.
of court, okay.
And this is Beaumont, which is 30 miles from the border, and
Okay.
he can live in Louisiana
Louisiana.
overnight if that's what it has to take.
You understand?
But I don't want him in this state except for this hearing. Do you understand that?
Yes, sir. You got to stay.
All right, and if everybody's ready, let's move this trial so we can get this thing tried in like a month.
Yes, sir.
All right.
Okay? Not a year, not 6 months, a month.
I'm
Everybody
ready.
get ready.
Ready.
All right.
I filed a request for a speedy trial.
Okay, you got it. Thank you.
All right, that's all.
Okay, so John, you.
Yes, sir.
Every day in the USA, people find themselves in court.
Thank you.
Okay. Ready.
Ready. Which, where's Mr. Harrell?
I'm sure he's on.
Is he in custody? I thought he was in custody.
You don't have to be in custody.
Brian Harrell? Hello, Brian Harrell. No answer in the courtroom.
Not in the county jail.
I asked the bailiff to call into the hall for Brian Harrell.
He didn't respond.
See if he's in the hall.
So changed my mouse.
There is no response to that name called here in the courtroom and no response to the name into the hall. Defendant has failed to appear. And these are two cases, 22-39126, 39129. What response, please?
Aggravated robbery, $40,000. It's 10,000.
Oh, Judge, he just got indicted also on a new aggravated robbery too. We just busted something a week ago, it looks like. Yes, they did.
Well, he hasn't made an appearance though on that yet. So he wasn't set to appear today. But what's the new case?
Aggravated robbery.
A separate one or a re-indictment?
The second one.
What's his bond on? Do you know?
I don't even show that here.
Actually, my judge, it's been received, our office hadn't been indicted yet, it's been
Yeah.
received, so we haven't actually filed yet, but it is received.
Oh, so
So,
we'll keep that a secret
no.
so no one will know.
I showed it.
Well, this is trial docket day, and defendant has failed to appear for trial. His bonds are revoked, warrants are issued for his arrest, no bonds at this time because this is trial day. And I think he insisted on getting a trial.
Yes, sir.
He was, we had a big hearing on that not long ago. Okay. 5 is now called the State of Texas versus Corey Cormier. Mr. Cormier is present with Mr. Dusler, his attorney. And does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, sir, this indictment, and you were Corey Cormier. This indictment alleges that on or about May 30th, 2023, in Jefferson County, Texas, you committed a state jail felony of illegally publishing or threatening to publish intimate visual matters of another person. Do you understand what you're charged with?
Yes, sir.
This is a state jail felony, which means you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. You understand? Agreement's been reached. You would be pleading guilty, placed on deferred or unadjudicated probation, which will be up to 5 years in length, fined $500. Is that your understanding of the plan?
Yes.
If I follow this, you have no right of appeal. Do you understand? How do you plead to this? Guilty or not guilty? You pleading guilty voluntarily. That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1 here. Did you sign that voluntarily? Did you understand it? Discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is way.
It is, Your Honor.
If nothing further to add, I'm going to find, sir, you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here, but find you guilty beyond a reasonable doubt. But I am going to defer any finding of guilt, place you on deferred or unadjudicated probation for 5 years. You must pay a fine of $500. There will be terms and conditions of probation which are normal and customary for this type of offense. Please make sure you follow them. If you fail to, your probation can be revoked and can be found guilty and sentenced up to the full range of punishments. You understand what has happened today? Thank you. That was all. And then Zane Ball is 6 and
Zane Ball is going to be refiled as a misdemeanor, Judge. We just had to move it.
Ryan,
We've already done it, Judge.
Zane Ball, you're gonna do that as a misdemeanor?
It's gonna be a refile, Judge.
There's not a lesser included on it?
No, not the way that it's played right now.
What's it gonna be pleaded to?
To something assault.
There's not a simple assault off of this indictment of aggravated assault?
The way it's pled, so they listed, at least in part, listed serious bodily injury, which is not. One, didn't happen, there was no serious bodily injury, but two, the way that there's too many, I think there's too many elements for it to be reduced just directly down. Oh, and I already sent him home because Lacey and I talked and we said, but if you need it back up here, I can get it back up here. But
well, I mean, if there's no objection to the way it's done and it's, but I would think assault. Okay.
Yeah. I thought that's what Mr. Boyd brought up to it.
Yeah, but I mean, we can do it here and just, there's no reason to refile it if it's a lesser included offense. And then I have jurisdiction over misdemeanor. I don't know what y'all, but I mean, that's a way of saving the problem, saving time and all, and why do an indictment? But y'all want, we got time and wherewithal to do the extra work, but if that's what you want to do, if that's what y'all are committed to, hey, I got other things to do.
Okay. Thanks. Appreciate it.
It makes no sense at all, but okay.
Thank you, Judge.
Probation.
Might be on a ship.
Well, could be, but I would expect him to be out there. He wasn't. I don't have a phone number or anything like that. He's been in
Brian,
custody.
can we find out where he is?
He's on probation, I believe 3 cases, so I'd be surprised if there's not somebody.
He's in our county jail. Let's just ship that.
Judge, I don't show him as being in jail. Well, he might be out. He might be out.
Your computer there directly from the jail shows that he's there. Dennis, who gets his information directly from the jail, shows he's not.
Dennis supposed to take him out of
You
jail.
can't make this up. Really, this is like a Twilight Zone episode here. All right.
Judge, let's go check it back again. Sometimes they don't answer their name.
All right.
But I went out to see him last night, Judge, and they said he was not in custody, and I said, did he bond out? They said, we don't know. There was some,
I
there
think,
was,
you know,
so
I really
I
think they're
kinda-
supposed to know. They've had custody of them and generally, I don't know where they are is not a real good answer to give to the community or out there. I think that's just kind of a, maybe they were caught at a bad time or something. I can't imagine. Yeah,
I'm sure
there's an
they're
inmate,
terrible.
we really know where they are. Now we know.
Oh, he's
Judge, can I have a few minutes to talk to him since I couldn't talk to him yesterday?
You're Brian, are you Brian Navy? Thank God you're here. We weren't sure where on the planet you might have been, but we know we're happy to know that you're here and you're safe. Okay, all right. The state of Texas versus Ryan Andrew Latino. You and Mr. Latino?
Yes, sir, I am.
Present with your attorney, Ryan Kimbler, and the state's attorney. Does the defendant make a formal reading of the indictment on the arraignment here? Can we proceed in summary?
Yes.
In summary, the indictment alleges that on or about September 1st of last year, 2023, in Jefferson County, Texas, you committed the third-degree felony of stalking. Do you understand what you were charged with here, sir?
Yes, sir, I do.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir, I do.
An agreement's been reached, you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. There's a batterers intervention program that would be BIPP, which is what it's referred to.
Yes, sir.
Which would be a term of probation as well as other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir, it is.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
I do, yes, sir.
How do you plead to this indictment? Guilty or not guilty, sir?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of what this alleges?
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. I'm going to ask you if you signed this document, understood it, and are the contents all true and correct?
Yes, sir.
Yes.
Yes, sir.
Okay, State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God. Down in front. Quiet down. Thank you. State's Exhibit 1 is made a part of the record without objection. And you understood what I said?
Yes, sir.
Okay. Pre-sentence report is waived.
So
If nothing further, I'm going to make the following findings, sir. You are pleading guilty today voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to defer in finding you guilty, place you on deferred or unadjudicated probation for 10 years. You do well.
Yes, sir.
And it's shortened in a third.
Yes,
Which
sir.
would be
I
what,
understand.
3 1/3 years.
Yes, sir.
And I do that all the time.
Yes, sir, I appreciate it.
Maybe 2.5.
Anything else you want to add on the?
Yes, I
on the-
went over this with him. I want to make sure I'm clear on the record. I think this is part of what I explained to him.
Yeah, and it's all, it's in your hands. You do well and you'll get rewarded. You know, there will be terms and conditions of probation. There are a lot of terms, but these are all the generally the same terms and conditions of probation that all probationers have. You will complete the batterers intervention program. That is always part of a case involving family violence. And a good program from Family Services here who do a great job. I'm on the board there, and they're the lead organization in helping people do things. Now, you had some question you wanted to ask? Go ahead.
No, I didn't have a question. I am actually grateful for the jail time I've served. I'm happy to take accountability for my actions.
Good, that's, well, I don't hear that a lot, and that's a good thing, because it always helps to express that. I think most people hopefully think that, but a lot don't.
That's
And,
about my case.
yeah, well, it ought to be, right?
Well, I mean, you know what I'm saying. I think you know what I'm saying.
So you're not first.
Kids are first. I'm
Good for you.
I mean, am I
Good
being
for
clear
you.
here?
Yeah, yeah, good for you.
Okay.
Good for you.
I
A
didn't
lot
have
of
a
people
dad,
come in
so-
here and they're far away, number one in their life. They're the primary interest of their life is themselves. Now, I'm not saying that they're not important. You have self-importance, but there are other. You have a place in life. You remember, there's a great book written by a great man, Gail Sayers. He wrote a great book that became a great movie. That was an award winning movie, Brian Song, about his friend and fellow football player, Brian Piccolo. And it's called I Am Third. He said, my creator is first, others are second. I am third. And that's why Sayers is just truly a great human being, because he was able to express those thoughts that really all people, I think, good, wonderful people should think that they're not number one, that they're serving others, which is a humble thing, a life to walk through. But this is something that I know what you're saying. You're charged with this serious offense. Fix it.
Yes, sir.
And move on and be the very best you can be.
Yes, sir.
Okay, I'm sure you can do that.
Thank you, sir.
Yes, sir. Good luck. You were here with your attorney and the state's attorney. I'm looking at what I have to look at is the indictment, which alleges that you intentionally and knowingly caused the death of an individual, namely Curtis Crawford, by shooting Curtis Crawford with a firearm. This probable cause affidavit reflects that at 3:07 a.m. Police were dispatched to the Point North Apartments in Beaumont in reference to a shooting, and found an unresponsive male in the parking lot. Man named Curtis Crawford. He was pronounced deceased by EMS at the scene. God bless you. Video surveillance from inside the apartment reveals that he and an unknown subject arrived and exited the vehicle. Once out of the vehicle, he is gunned down by two subjects who appear to be waiting for him. The other subject in the victim's vehicle was later identified as Janisha Lindbergh. Through the investigation, a cell phone search was conducted on her phone, which contained evidence showing that she was involved in the murder. That really that's not really clear to me what that is. And then it goes on to state, based on the facts, then that a complaint should be accepted and a warrant for her arrest for murder. So that's about what I have, along with the public safety report that says she has no criminal history. What does the state?
When the original bond hearing, Your Honor, the court reviewed the text messages and heard evidence regarding, again, the defendant working along with the co-defendant to kind of.
He was lured to.
Yes, Your Honor.
The same.
And so the court at that time, based on the lack of defendant's criminal history, reduced it to 500,000. We then had another hearing for a motion to reduce bond, at which time the court said that there were no other changed circumstances as to why the court would reduce it. However, there was not the new public safety report that was in at the time, and the court had held off at that time on making its ruling because of that. Okay, go ahead.
Your Honor, I believe we could make a bond of 250, and we would ask the court to reduce it to.
Okay. Stay.
Your Honor, there's another defendant out there that had also participated in the shooting that we're not aware of. Again, I'm not sure, Ms. Limerick, if she's able to get out, could potentially work with this individual as well to commit more crimes. That it just unknown. That person is out there, the other shooter, that only she knows who that individual is.
All right, stand by.
That we had been communicating with each other about that's just getting that potentially set up. So.
Well, okay, what I'm gonna do is reset this for 2 weeks and see where this is going.
Thank you, Your Honor.
Okay, we'll
Yes, sir.
revisit in 2 weeks. Agreeable for everybody?
Yes, sir.
Okay, hopefully things happen that are in her best interest. Next is Charlie Price. I don't see Charlie Ezef, come on up. We'll do Ezef.
No. Can I please raise your right hand? Swear or affirm to.
Charlie Ezef, that's you?
No.
Who's Carly Ezef? Okay. I thought you said 23 CR 1680 is called Carly Ezef. Present, your attorney, Mr. LeBlanc, the state's attorney, does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 18th, 23 in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle while intoxicated with a child passenger. Do you understand what you're charged with? If convicted, you face confinement in the state jail for any term not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in the state jail. Is that you understand?
Well, Your Honor, there was no.
And then there's suspended and you're placed on probation.
And yes, Your Honor, I believe the defense was wanting less than the normal 5 years, but obviously the state is seeking the 5 years that the court normally.
Every defendant wants less than the maximum probation period, but the court sets that. It's my domain, not y'all's. But you would be sentenced to, the deal is that you would be sentenced to 2 years. That would be suspended and you would be placed on probation, which can be up to 5 years in length. Do you understand?
Yes.
If I follow this agreement, you have no right of appeal. Do you understand? There is no minimum jail time on that either, is there?
No, Your Honor.
Which is odd. Because a first felony gets 3 days. I mean, a first
Second.
That wasn't good.
well, it started when David's phone started ringing.
Yeah.
There you go. Thank you. Lights dimmed, everyone. If I follow this, you have no right of appeal. Do you understand?
Yes.
How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection. Among other things, the state you were mentally competent to enter your guilty plea, which is freely and voluntarily made. Know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up the rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help me God. Is all of that so? Yes.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Presented for vote late. Yes, sir. I'm going to follow this agreement and find you pleading guilty today voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. A state jail felony. You were hereby sentenced to confinement in the state jail for 2 years in accordance with this plea agreement. Also in accordance with the agreement, I am suspending and placing this confinement and you on probation for 5 years. Again, you do well, and I that's what I do. You do well. I shorten it. I shorten probations every day in a third. So 5 years, a third.
Well, and on this one, Your Honor, since it's DWI, I don't think that it can be shortened on that.
I don't know.
On the
I thought I
DWI
can.
with the child passenger item.
Can you find that real quickly?
Yes.
Like, is there a fine on this?
There is not a fine.
No.
Yes, Your Honor, I believe that you cannot shorten it for that or the sexual.
Those two cannot be shortened.
I knew sexual offenses you couldn't.
It includes DWIs as well, yeah.
4 years.
I'm sorry.
4 years. Okay. It will be for a term of 4 years.
Yes, sir.
The length of probation will be 4. Okay, thank you. And then 19-32214 is now called the state of Texas versus Alicia Williams. And that is you. It's just one case, correct?
Yes, sir.
You are on probation now. And this is cause number 19-32214. A motion to revoke probation had been filed last year in June. Does the defendant waive a formal reading of this? Can we proceed in this motion to revoke probation? Can we proceed in summary?
Yes, sir.
In summary, this motion alleges that on December 19th, 2022, you were sentenced to 10 years in prison, probated for 6 years for illegal possession or transfer of food stamp benefits. Is that true? It's a third-degree felony. Yeah, okay. I have something marked on failing to report on several occasions to the probation office last year in a hearing dated November 6th of 2023. What happened in that? I've got it marked, but
Failure to appear.
I think she has.
no, she pleaded true on that day, so she had to be here.
Judge, was that on a motion for to revoke unadjudicated?
No, motion to revoke probation. She has another case.
This was,
That's not what we're here for.
this was
though,
a
right?
ridge. Yes, I think you're looking at the wrong motion, Judge, for
Stand
if you,
by.
for the 23 event.
2214, that's it. Filed on 6/16. Hello? Yeah,
I'm looking, Judge.
this was filed on January 16th last year.
Judge, 1 second.
I thought it was this one.
What's that?
This is what I'm looking at.
This doesn't even have
Same thing?
file this. No,
That's the
different.
one. Yeah, that's the one I think we want.
So I'm pulling it up, Judge, see if I can figure out where.
Why is that? That is like a charge.
Yeah.
That's the right one, right? This is like, you can just use my time.
Hold on, we gotta have a file stamp. File stamp, yeah. Hey, we got a problem. When this, okay, they say that there's a newer motion to revoke probation. Does anybody have one that's file stamp? That was filed, we had a hearing on that in November, and that was filed in June of last year, what I have.
No, sir, I don't have anything in our system, in honesty, the last motion that I showed was from June 17th. Nothing's been filed since then.
That's what I have.
Anybody, anything, where did you get that? That's on file stamp, that's not file stamp.
I got that when I printed the discovery off of the discovery wheel page. Now I gave her copies of that.
Yeah, I mean, I've got correspondence with that.
Sonny,
Miss Helena.
what do you,
back in
you're the
last
one
year.
signing all these. What does it show?
I'm going to see which page.
It wasn't all blurred, so we don't have it.
Let me see this. Again, please. Thank you. So she put true, but number one only, failing to report on November 16th. But that's not reflected. Something happened during that hearing. I guess we stopped it or something.
What was the original judgment for, Judge? Was it an unadjudicated probation or was it unadjudicated?
It was deferred in 19, then it was converted in 22 to flat, to a straight probation.
Okay, so I've got I'm looking at the 11/22 motion to revoke. That's the one where it was converted. And then there was another one in 16 or.
6/16 of 23 is the newest motion. She pleaded truth, but see, there's nothing in writing here. What must have happened is we started the hearing and then stopped it for some reason.
Judge, I think, so I know for a fact you held it in advance in 11/23. And I think the reason that there's not a new motion, although I've got that and I thought I filed it, but I think the reason that it wasn't was because you held it in advance and she had already pled true on the underlying allegations in that motion.
What I've got in my hand is not the same copy. The
No.
first page is not the same copy.
No.
But there's no file stamp.
And I don't think that's ever been filed.
Well, the question then becomes, what are we doing?
You didn't adjudicate on the previous motion that you're looking at right there.
For whatever reason.
You held it in advance, I believe, so that it could be determined
Yeah,
if
but
she.
that's not noted anywhere. That's not the way it works. It gets noted on the file when there's an event where I make a ruling.
So here's what I've got, Judge. On 11/6 of 23, you held this in advance. And I believe the reason was because you wanted her to come up with restitution money.
Okay, but hold on, she's in a blue jumpsuit. What's she doing in jail?
She failed to appear.
Right, so it was
Last
reset.
month.
It was reset for 3/27/24 for a status, and she did not appear.
And I think, my mother said we did. Right, her mother had passed around that time.
Yeah, what's that mean? I mean, that's the ebb and flow of the life cycle. That doesn't have any, yeah, if the funeral or something is on this date, I always allow the case to be reset up, but that wasn't why she wouldn't have gotten arrested because she was at a funeral for an important person. We don't do that. It's not what we do. Something else is happening. Probation officer, where are we on this?
Well, since Alicia was released last year in November,
Okay,
she has not, she only came to office once, and this was January. And haven't did anything since being from custody. Failures of reports.
okay, yeah, that's the deal. Okay. Well, what I'd like. So we get this straight.
Yes.
Can you give me another updated memo? Here, administrative hearing memo for me the other day. The last thing I have is April 19th. So some events have occurred subsequent to that affect this probation. I'd like to know where she is on it. And is there a way I can ask you to fast track that and then get it over to the district attorney to file as soon as possible? But it sounds like we've got some more problems here, but for whatever reason, the data is not in this file, and that I don't even have it. Just doesn't make any sense at all. I want to review this though.
Anything I get not.
Well, it depends on what this, it depends on what we know about it. But if she's not reporting, why? Yeah, when was the last time she reported?
January.
Yeah, okay. Well, that's kind of a problem. We can't do anything else. They have to report her. They're not really on probation. They're not on supervision. You're on supervision, which is not the way the law works. All right, that's what we're gonna do.
Thank you.
I want to review this though, next Monday, please, just a review of the status of where things are, so that this lady doesn't get lost in them. Because it looks like there's a plan of disposition, right?
There is, Judge.
I mean, are you agreed to this?
Yes, sir. Just based on the circumstances.
And there's still restitution owed, right?
There is. Oh, she has. Okay. Then that's wrong, Judge. My writing there.
Sir?
Then my writing there is wrong because I wrote in the restitution amount.
Look. I can see the file. Look, we're gonna fix this mess. There are other items in this motion to revoke probation held on 6/16/23. Let's bring this motion back up and deal with the issues that were not addressed to find what is here in this four corners of this motion that can be moved in satisfaction of the plan that y'all have.
And actually, that's gonna change.
Judge, I didn't know she had paid restitution, but if she has paid the full amount of restitution, I'm willing to do the minimum, the 2 years. I think that's fair.
Well, then change it. What about that?
You got your
Or
pen?
do y'all wanna wait around for a few weeks?
No, we fine with the two.
Okay, then we recall 19-32214, and this is the state of Texas versus Alicia Jean Williams. Raise your right hand, and you say, God bless you, your other right hand. There you go. Okay, good. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In 19-32214, there was a motion that you pleaded to one count that is number one, but there are other allegations in this motion that were not addressed. And this was filed last June of 2023. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
In summary, this alleges, ma'am, that on December 19th, 2022, in this court, you were sentenced to 10 years in prison, probated for 6 years for illegal possession or transfer of food stamp benefits, third-degree felony. Is all of that correct? All right. Number three states you failed to provide verification of attending rehabilitation, treatment, residential programs, and counseling as directed by the probation office, as you have failed to comply with the program guidelines of moral reclamation therapy in violation of condition 12 of your probation order. Is that true?
True.
Four seems to be kind of a repeat of that. Five states you failed to provide verification of performing community service hours as required. Is that true? And there is an unnumbered, and what we're going to do is I'm going to amend this and call that number 6. It's referred to as special condition violation. Call it number 6. It was unnumbered. It just says special condition violation. You were ordered to serve a 15-day jail sanction. You failed to turn yourself in on April 14th, 2023. Is that true? I'm amending that on this day to number that unnumbered violation as number 6. Any objection?
No.
So are you pleading true then to allegations 3, 5, and 6 of this motion to revoke probation dated 6/16/23? Are you pleading true voluntarily, knowingly, intelligently, and because those are true? You understand by a knowing and voluntary plea of true to a violation of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced in this case no less than 2 years. Knowing that, do you insist on pleading true today? I find you were pleading true voluntarily. You understand and appreciate the consequence of pleading true. There's an agreement that's been reached where you would be revoked and sentenced to 2 years in prison. Is that your understanding of the agreement? If I follow this, you have no right of appeal of your case. You understand?
Right.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Is everything true and correct? State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. This re-verifies that you were giving up all rights of appeal if I follow this agreement. I'm going to do that. You understand? Yes. Okay. All right, I'm going to make the following findings that the defendant has pleaded true to allegations 3, 5, and specially numbered 6, special condition violation of this motion to revoke probation in 19-32214, which was filed on June 16th, 2023. And she has pleaded to voluntarily, knowingly, and intelligently to those violations, and that is enough to grant this motion to revoke probation, to grant it by a preponderance of the evidence greater. It is so granted. Your probation is revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. Do you understand what has happened today? Yes. You will be given a credit, of course, for all time lawfully served in accordance with that. Anything else, Langston? No. Okay, thank you. That is all. Wonderful.
Thank you, Judge.
For that one.
Yeah. I'm glad we got it worked out then.
Don Zucker on the court comment. Yes, sir. Come on up. Who's this?
Miss Della Rosa.
That's also a plea, Judge.
Okay, we'll get her out and then let's. Here's a. Record Green's file. Okay. Mr. Laird. It's not here. We're gonna number the following, Brian Harrell first.
Judge, he didn't show up.
Oh, he did?
No,
That's
sir.
right, he
So-
did fail to show
The
up.
box picture.
Yeah. Okay, I have Peyton Smith then is going to be number 1. Laura.
That is a short guilt innocence case, but I've got punishment. I'm prepared to prove up all the other cases.
I'm gonna send that one then over to drug impact.
Okay.
Okay.
This is, may I ask?
I'm not gonna be able to get to it because of what's ahead of it. So let's.
If I may remind Your Honor, we had asked that you admonished him. I do think that if he hears it from you, what his exposure is, that it may resolve in a plea.
I don't know how I can do better than Mr. Frank.
Your Honor, it always makes a difference coming from the court. I don't normally ask that.
I know you
but
don't.
I think in this case, it makes sense.
Judge, given the history, his attempts to get him with the case, continue communication issues, I would ask.
Okay, bring out Luis Laura, please. Laura, thank you. Here, here. I'm gonna give you these boxes. That's not on this one. 4 cases, correct? Everyone?
Yes, Your Honor.
Here, or these other trial dockets. There are 4 cases here, Mr. Law, and we're going to send this case over today over to the Drug Impact Court where Judge Thorne presides, so we can get this thing tried. I know you've been wanting to get it done. 22-41033, just to ensure that you know where you are on this. This is the indictment filed on November 9th of 2022, and it alleges that you committed failure to comply with sex offender registration on or about October 7th, 2022, because of your conviction of indecency with a child earlier. You were required to you were required to file and comply with sex offender registration in a regular fashion. This states you did not do that. So that's a 3rd-degree felony. Paragraph 2 of the indictment alleges that you have a prior 3rd-degree felony conviction out of Guadalupe County for illegal possession of marijuana in 2010. Paragraph 3 goes on to allege that after that 2010 in Guadalupe County conviction was final, you committed the offense of illegal possession of a controlled substance. It doesn't say what it is, but it's a 3rd-degree felony, and you were convicted next door in the 252nd District Court. So if all of this was true, you're looking at and proven true. If you were found guilty of this 3rd-degree felony of failing to comply with sex offender registration, and these 2 prior convictions were proven true, you were looking at no less than 25 years in prison, up to 99 years, or life imprisonment as a habitual felony offender, according to the indictment. In 23 CR 394, this alleges that you committed the state jail felony of illegal possession of a controlled substance, namely cocaine, on or about August 24th, 2022. This was filed on May 17th of 2023. It also alleges 3 prior convictions, 2 3rd-degree felonies in 2010 of illegal possession of a controlled substance in August of 2010, and indecency with a child October 7th, 2010, out of Guadalupe County and Webb County, Texas, respectively. Also, there's a 3rd conviction in 2018 out of the court next door in the illegal possession of controlled substance. So if you were convicted of this state jail felony, as I understand, if these prior convictions were proven true, you would be punished as though you were a 2nd-degree felon. So that would be no less than 2, no more than 20 years confinement in prison and a fine up to $10,000. On October 10th of last year, you were indicted in 23 CR 1773 for once again failing to comply with sex offender registration requirements. This states that on or about September 22nd, 2023, you failed to follow the requirements under law, and you didn't register properly for the previous indecency of the child conviction. If convicted, that's a 3rd-degree felony. And paragraphs 2 and 3 allege those 2010 and 2018 prior convictions out of Guadalupe County and the 252nd District Court of Jefferson County that we talked about. So this 3rd-degree felony turns into habitual felon status. So you're looking at no less than 25 years up to 99 years or life imprisonment in that case. Finally, 24 CR 445 was indicted on February of this year, a couple of months ago. And this alleges that on or about October 24th, 2023, you committed the third-degree felony of illegal possession of cocaine. And that becomes a third-degree felony because it is alleged that it is within 1,000 feet of, it's in a school zone in Port Arthur. So if convicted of that, that's a third-degree felony. And then this indictment as well alleges the 2010 and 2018 prior convictions out of Guadalupe County and the 252nd District Court of Jefferson County that we had earlier talked about. So if found guilty of this, you face a third habitual felon status of confinement, no less than 25 years up to 99 years imprisonment or life imprisonment. So do you understand what you're facing on these full cases? That's what's important. Okay. Yeah, and we're going to send this over to today over to the drug impact. Okay. Thank you.
Thank you, Judge.
Your Honor, if you're sending that there, am I also remaining your number 2 case here as well? Because I have the 2, 3, and 4 on your current docket.
Yeah, that's going to go. And number 5 is Lori on James Smith. Number 6 is Don Zabi and Sam with Ryan Matuska. So yeah, we've got to.
So I'll worry about that.
Unless that gets disposed of.
Yes, sir.
Let me know. Thank you. Is that you, sir?
Yes, 2 cases.
And 234682. Were these 2 probations?
They're both motions to revoke probation. He's gonna have pleads of true. We do not have an agreement.
All right. You were Donald Demetrius Guillory present with your attorney and the state's attorney. Mr. Goose, does the defendant waive formal readings of these 2 first amended motions to revoke unadjudicated probation? Can we proceed in summary?
Yes, sir.
In 234489 and 34682, sir. These first amended motions to revoke unadjudicated probation filed in each of these cases similarly allege that on March 8th, 2021, in this court, you were placed on 5 years deferred or unadjudicated probation in each case for unauthorized use of a motor vehicle. So thanks, state jail felony, correct? State jail felony in each case. Is that right, sir? Okay, raise your right hand. Do you solemnly swear or affirm that all statements you make today during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? And again, all of that is correct so far that we've talked about. Yes, sir. Right. That's okay. Take them up collectively. Sense looks like there are 11 violations alleged in 34489 12. No, 10 rather, in 34602. But you can't make this up. I mean, they're all. They're different. Just enough to have to go through each of these individually. because What are the odds?
It's up to the court, but I think.
Which ones are we gonna be pleading to? The officer?
True, 1, 5, and 6, I think. That would be
You're
sufficient.
talking about
The new one.
at number 8 and 7, the substantive offense failing to ID fugitive intent, giving false information on June 26th of this year, January 26th of this year. committing the offense of illegal possession of marijuana, number 9, number 8 respectively, on or about January 26, 24 in Tarrant County. Or March 17th, 2023 in Denton County, Texas, committing the offense of unauthorized use of a motor vehicle. That's number 1 in each case. That would resolve it all. Yes, sir. Number 1 states in each case, sir, that you committed the offense of unauthorized use of a motor vehicle on or about March 17th, 2023 in Denton County, Texas, while on this court's probation. Is that true or untrue?
Yes, Your Honor.
Are you pleading true in each of these cases to allegation number 1, voluntarily, knowingly, intelligently, and because the allegation is true in each case? Do you understand by a knowing and voluntary plea true to 1 or more violations of probation? That is enough to grant the motions to revoke probation. Your probations can be revoked, and you can be found guilty and sentenced to no less than 180 days up to 2 years in the state jail in each case. Knowing that, do you insist on pleading true to that? I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true in each case. There is no agreement, correct? Summary of March 17th, 2023. There it is. You kind of busted that curfew, didn't you, on that at 1:55 in the morning? On Friday, March 17th, according to the police, they pulled into the racetrack, which is, I guess, a fuel and a convenience store kind of thing, on Loop 88 in Denton, Texas. Denton County observed a great conduct horizontally across vertical parking spaces. They ran the license plate on the vehicle and it came back that it was a stolen vehicle. You got out of the car. You were the only person in the vehicle. You said you didn't know why it was being reported as stolen. You bought the car 2 days ago for $300 from somebody named Bo. And you did not have insurance for the vehicle, like you're supposed to. You had a bill of sale, but it wasn't on you. It was at home. Victim was the vehicle was actually stolen from an apartment complex 2 days ago.
Yes.
With a spare key that was missing from the other vehicle. All right, that's a summary of that. All right, there is no agreement here.
That's correct.
So you were looking at, no less than 180 days up to 2 years in the state jail.
Your Honor, he has not done well on.
How much
probation.
time? I see 186 days.
He's not done well on probation. He realizes that, the court will probably revoke him. And what he's asking for.
Can I see our censure? Go ahead.
What he is asking for is to give him some consideration for acknowledging his responsibility and letting some time off of an accident. He's asked me to request 1244 time. I told him I didn't think it was likely, but at his request, I would ask him to consider that or something less than the maximum. Because of his acceptance of responsibility.
Having trouble there, little buddy?
Yes, sir.
Yeah, what's state saying on this?
Your Honor, we'd ask for 2 years state jail. Defendant still owes roughly $9,242 in restitution and 66 cents. Like you said, he's continued again to violate his probation over and over again to state. Again, he's gonna ask for the maximum time since he owes that much restitution. Still.
All right, so, you, and one or more others were stealing vehicles around this town, weren't you? I see one of them here that you were placed on probation for. One of them was at the Lamar University, from a Lamar University student. How far did you go in school? For what? High school, okay. Did you go, did you further your education? Others are trying to, and you stole from them. I know when I was in school, I had 3 jobs and it just was hard. I couldn't afford to lose anything. I barely had anything. I was just trying to get an education. Were you placed on probation after these 2 stolen vehicle cases, unauthorized use of motor vehicle cases? What did you tell the court about how you would do while on probation?
So I'm gonna do the best I can to be successful.
You stated, quotes, very well, good, great, awesome. Well, you went out and committed another stolen car. You went and stole another car. Didn't count. Same thing. Kind of puts court in a bad position, doesn't it?
Let's see.
What are you asking for, Don? Yeah.
He just asked it for some consideration for acknowledging his responsibility.
Yeah, thank you very much. Anything you want to say, sir?
We just like to say that please, do not judge me off the chapter that you walked in.
I can't hear you.
Please do not judge me off the chapter that you walked in.
Say that again.
Please do not judge me off the chapter that you walked in, like in my life, like my decisions that I made in the past life.
Well, I mean, that's your life. Those are your choices that you have made. That's part of your life. It wasn't like somebody else jumped into your body and committed choices. You made conscious choices while you were on probation, knowing that we had made a serious production of the wrongdoing, and you went out and did the same thing. Well, motor vehicles are generally the second most expensive item people ever buy. And so it has, under the law, it has a seriousness. And especially somebody who's trying to get an education. I mean, they're living day to day. I mean, that's just cold. All right, if nothing further, I'm going to find there is sufficient evidence supporting these first amended motions to revoke probation in each of these cases, to grant them by a preponderance of the evidence or greater as allegation true. Allegation one in each case has been proven true, that you committed a similar offense of unauthorized use of a motor vehicle while on probation in Denton County, Texas, on or about March 17th, 2023. You have pleaded true to that voluntarily, knowingly, intelligently. There was sufficient evidence supporting your plea of true from state, well, State's Exhibit 1 shows that you understand and appreciate and take responsibility for pleading true to another violation while on probation. That is enough to grant this motion to revoke probation in each case. And these first amended motions to revoke unadjudicated probation are granted. Your deferred or unadjudicated probations in each case are revoked. Earlier in this case, in each of these cases, you pleaded guilty voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. And you are hereby sentenced to confinement in the state jail for 18 months in each of these cases. These sentences shall run concurrently. There is restitution owed in each of these cases. Can you tell me on probation exactly what they are, because they will be rendered on the judgment in this case? It's only fair. I mean, you still owe. You would owe restitution in 34489 of $400. How much is $400 to the individual who had been named in the probation order as the recipient will be the beneficiary of that order. Camden Dortch is his name, and it's reflected in the first amended motion to revoke probation and the documents there. In 34682, restitution was originally $9,288.66. Is it still that?
It's $8,872.66.
That is the amount, $8,872.66 would be rendered on the judgment in that case to Riley Daigle, who is the victim in that particular case, according to the probation orders and the indictment in that case. Those will be placed in the judgments. Do you understand what has happened today, sir? Yes.
Yes.
Anything else?
No.
Oh, yeah, go ahead. You were sentenced to a year and a half on each of these cases. Those shall run concurrent. Plus you have restitution in each case. Oh. I wish that would have worked out better. For your case and the state of Texas versus Angela Ashe. The defendant is currently on probation here for the third-degree felony of assault on a peace officer, and this was from a hearing on her disposition in 2021. She was placed on 10 years deferred or unadjudicated probation. Subsequent to that, and in November of last year, a few months ago, the defendant, there were, in this defendant's case, a motion to revoke unadjudicated probation was filed, which states violations of assault on a peace officer in November. And again, reminding everyone that she was placed on probation for assault on a peace officer, failing to report to the probation office properly, providing a urine sample showing methamphetamine in her system, and failing to complete the anger management program for violations. Upon suggestion, the defendant was evaluated by Dr. Edgar Pond, licensed psychiatrist here in Jefferson County, Texas, for competency. So, based upon Article 46B.021 of the Texas Code of Criminal Procedure, on a suggestion, the defendant may be incompetent to stand trial. The court may appoint one or more disinterested experts to examine the defendant on the issue of competency, and that was done pursuant to Article 46B.021. And 46B.022 provides for the qualification and the appointment of proper experts, as Dr. Ed Pond was, and he prepared a report, and it is being received under Article 46B.025, an expert's report stating an opinion on the defendant's competency or incompetence to stand trial shall be provided, and he has done that and declares the defendant to be incompetent. There is no request for a jury trial. The court was going to ask if the parties have anything in addition to what is in the four corners of this report dated April 25th, 2024, that the court is going to mark and label as exhibit number 1 in this cause number 35717.
State has nothing further, Judge. And no objections to the committee's matter.
No objection.
All right, then the report is made a part of the record without objection. Again, it states in summary that the defendant is not competent to proceed to a resolution of her legal issues. She is mentally ill and does require psychiatric inpatient treatment intervention for restoration of competence. So we will follow the orders of the expert, Dr. Rapon. Under Article 46B.073 of the Texas Code of Criminal Procedure, this provides for the provisions of commitment for restoration of competency. The defendant is not released on bond under this circumstances of this case, and will order that the defendant be committed to an inpatient, a proper inpatient facility for treatment, with the hope that she receives sufficient satisfactory treatment for her competency to be restored. And this will be for a period of not more than 120 days under 46B.073, since this is involving an offense punishable as a felony. Anything else to add by the parties on this? Okay, written order will be prepared. And if necessary, an extension of this order under 46B.080 of the Texas Code of Criminal Procedure will be executed if experts deem that the order should be extended for treatment purposes and in the best interest of the defendant. Anything else?
No, yeah.
That was all. Oh, Priscilla George, is that you? You're Ms. George? And you were here with your attorney and the state's attorney and probation officer. From the probation office is present. Okay, Mr. Schlander, there's what we have here, and Ms. George, a motion to revoke unadjudicated probation filed on January 3rd of this year. It states that you were placed on 5 years deferred or unadjudicated probation on January 20th of 2022. So that's been, what, 2 years, over 2 years, for the state jail felony of theft. And that you have violated your probation by committing an offense of trespassing on or about October 2nd, 2023 in Logan County, Illinois. Failing to provide verification and performing community service hours as required. Failing to pay courtesy fees as directed. Failing to report to the Harris County Probation Office in person. Is that where courtesy supervision is, in Houston?
It was, yes, sir.
Failing to I'm not sure that's written right. Failing to not to remain, failed not to remain. Okay. Wouldn't it be failing to remain in Texas as directed by being in Logan County on October of 23 without valid permission and a permit?
In count 5, we would ask to abandon the words not to.
Or just take out the word not, right? Otherwise it reads failed remained. There's not a
Right.
preposition.
Yeah, just abandon the word not.
All right, any objection? Then
No objections.
that's corrected there. So obviously just an error. And then failing to report to the probation courtesy mailing portion of your probation for the months of February, March, April, May, June, July, August 2022, April, June, and August 2023. A lot of sporadic failing to report there. Anyway, these are 6 violations. And was there any restitution?
Yes, sir.
How much was restitution?
$8,000.
How much has been paid?
A total of $23. That's what I'm proud of the rest of the
In over 2 years?
Yes, sir. He's made payments, Your Honor, and 23's been applied.
Only $23 has been applied to restitution because you've got fines, court assessed fees, probation fees, and then restitution is another one of the fees. But restitution is, when it comes to theft, if you can't pay anything, you have to pay restitution. That's the only way you fix a theft. When something is lost or mischief or damage, is when you take something of value, then you give the value back. That's how you can fix it. If you break somebody's arm, you can't unbreak them. That's kind of hard to fix. But when it's money or value, if something is lost, paying it back can replace the harm done. Anyway, there is no bond on this. Go ahead.
Yeah, we're asking for a set of bonds. So voluntary surrender 2 weeks ago. So been in jail now for 2 weeks.
I wasn't aware that these charges in Logan County were going forward. I was under the impression they were not from talking to people there. She's a mother of two small autistic children that she's the primary caretaker of, and really has no one to watch them. We're asking court to let her get out, at least to get some arrangements made before we come back for the final hearing on the MTRP.
I'm a little fuzzy on something. Where does she live when she's not in jail?
My parents.
Okay,
What's
hold on. There's only 7 billion people on the planet. You're gonna have to be a little more specific.
Houston.
In Houston. Oh, okay, right down the road. All right,
Cypress could just.
not in Logan County, Illinois.
No.
Okay, somebody says, according to this, you were up there for some reason without permission, sis. What's that, Ryan? And then the keys things failing to report. If there's one thing you have to do, if you can't do anything else, you got to report, or else you're not being supervised. If you're not reporting and connecting, then you're on your own reporting, which is not the way it works. And that's what number 4 states, that you failed to report in person, but you're failing to report to Jefferson County online. And here's the thing is that at any time, I want, for good reason, probably not even a good reason, but you ought to have a good reason for anything. You shouldn't be acting on whim. But I can say, you're going to be reporting to Jefferson County from now on. You don't have to be, I allow you to report if you're living in Harris County, but I don't have to. And this isn't the way it's headed. I don't like what I'm reading. There shouldn't be any violations, but I'm seeing 6 alleged violations. How hard would it be to start reporting in Jefferson County from now on? Well, you're asking for it. You're asking for it. But what's this thing about this? Do you have any information about the trespassing?
Judge, it was our probation department has received a number of requests from federal law enforcement in Illinois wanting information about our offenses down here because there is some sort of ongoing investigation involving this probation related to that trespass offense. I think the trespass was just the state level offense.
Okay. Now, that's absolute total news to me. On the last one, but I ought to be the first one to know about it since she's under my direct supervision. But what the heck is that all about?
Pertaining to, I believe, scrap metal theft in multiple states.
All right, what are you, Mr. Shillander, what are you proposing?
Actually, do it so bond, the family can vote the bond. I don't think she's a flat risk. I think she'll come back. I think she'll report like she's supposed to. And then I'm not sure all of these, that they can prove all these allegations. I'm not sure we're going to plead true to them, but asking the court to at least let her out to make some arrangements for these
What
small.
about the failings to report? Failings to report in person, failings to report online. That's kind of, if there's nothing else you can do, you got to do that, or else I can't trust you. I mean, other things or issues, but this is clear. Failure is not an option on those. I mean, there's not a halfway on it. You either get it done, you either report or you don't. And this says you hadn't reported by mail for 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. You hadn't 11 times so far. You hadn't reported by mail to us. Then 1, 2, 3, 4 times you haven't reported directly monthly in Harris County. I'm not sure. You need to be reporting in Harris County from now on. I think it's best we keep a closer eye on it. Because order is an order, and there are 5,000 people on probation at any given time, and That is the bar that has to be jumped over. And it's not being done. The other stuff is, yeah, some kind of ongoing, but. How, do you know how many, community service hours
She's not completed any, Your Honor.
hello?
They had a
Wait,
hearing.
tell me that's wrong. It's been over 2 years. 2 years and 3 months and not one community service hour?
No.
When can you be ready for a hearing?
Judge, I can be ready for a hearing on all the administrative violations soon, but I would need a little bit of time to reach out to the Illinois
That's
law
okay.
enforcement to.
These administrative hearings are important.
I agree.
And they're the other, I'm not gonna wait on the feds to go forward. I don't need to. These are important. These are the essence of supervision. I'd rather move forward on these.
But I mean,
When can we be ready here?
2 weeks.
You got it. I'm gonna under these circumstances, there's not a bond that I'm gonna allow when there's these clear issues that you're not you're not even showing up. We don't know where you are. You're not showing up, and you have to do that. How can I trust you on a bond? Make a promise. I'm sorry, you've got 6 violations here. This isn't a debate. We're gonna have a hearing on it. We're gonna have a hearing but those are important. You can't, those are the most important. That's what probation is supervision, and you're not being supervised. You're on your own supervision, which is the tail wagging the dog. You're not working it right. And all probationers are, I'm gonna treat them the same. Everybody gets over the bar. You're not. You're one of the few who aren't. So, did you say 2 or 3 weeks?
I said 2. It'll be on a Friday.
Sir?
Will it be on a Friday?
Yeah, we'll try to make it.
Well, I just can't do it next Friday.
Okay, that's
not
okay.
next Friday.
We'll try to put it on a Friday. We after next, maybe? A little over 2 weeks. Okay, thank you. And we'll hold the motion for bond. Due to we gotta get this resolved. It's not like you're not reporting to your bondsman. You're not reporting to after the court has ordered you and you're on supervision. These need to be cleared up before I can trust you. Oh, that is all. Thank you. Versus Justin Young, is that you, sir?
Yes, sir.
Present with your attorney, Mr. Smith, and the state's attorney. There is a motion to revoke probation that's pending that was filed on March 1st, 2024 in this case. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Judge.
In summary, this motion alleges that and raise your right hand, sir, do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this states that on August 12th, 2015, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison, probated for 10 years for operating a motor vehicle while intoxicated, a 3rd-degree felony because of prior convictions. Is all of that true?
Yes, sir.
Allegation 1 states you committed the offense of public intoxication on or about January 25th, 2024 in Jefferson County, Texas. Is that true or untrue?
Sir.
Number 2 states you were at a location other than your residence at approximately 12:43 a.m. on or about January 25th, 2024 in violation of your probation order. Is that true?
Yes, sir.
Are you pleading true to allegations 1 and 2 here voluntarily, knowingly, intelligently, and because those are true?
Yes, sir.
You understand by a plea of truth voluntarily and knowingly made to 1 or more violations of probation, that is enough to grant the motion to revoke probation. Your probation can be revoked. You can be sentenced to no less than 2, no more than 10 years of confinement in prison. Knowing that, do you insist on pleading true to that?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Pre-sentence report. Do you happen to have a copy of that in probation? Please don't. Let me look this with them. There is no agreement here, right?
That's correct.
Okay, go ahead.
Your Honor, as the record reflects, my client was placed on probation in August of 2015. My client tells me that since that time, early on in the probation he was placed, he did several programs relating to his alcoholism. He tells me that he has not had a problem with probation since that time. This is the first time that he tells me this is the first time that he has been before the court on any violation. He freely admits that on January 25th, he did fall off the wagon. He was coming home from work and with a friend, and the friend stopped at a bar, and he initially stayed out in the car, but then he went in and then he drank, and that's why it was so late, because he was coming back from work, which he had permission to do from the probation office as far as curfew. He has a very good job to work with who?
Fusion Mechanical. Fusion Mechanical.
And
How much do you
they
make?
have
How much
acquired.
do you make an hour?
$36.75.
You really want to flirt with that trouble, losing that?
No, sir.
What is that in a year? With overtime, it's $100,000.
Yes.
It's six figures.
Yes.
That's a fortune to most people.
Yes.
You want to flirt with that, with this, doing this?
No, sir.
Okay. And you can't say that this type of behavior is minimal, because it's the essence of what you're in trouble with in the first place. Okay, okay. What are we doing about this problem that there's like the sirens or calling? You're being beckoned by the call of the sirens.
Well, he's valued by his employer. That he tells me that they have acquired his family. He has a job waiting for him, the same job that he
I'm
had
not
waiting
talking
for
about
him.
that. That's all.
He
that-
did
that-
fall off the wagon on that day.
What I'm saying with is you have so much to lose
Yeah.
over a drink. I mean, but you're grown up, you're making a conscious choice like we all have to make, but we're held accountable to our choices. This one is, failure is not an option. I mean, you start drinking. And for me, there's no violation as long as I don't drink to an excess, but you can't, not more. You only can sniff it.
He's been in jail now for about 27 days.
Here.
20 days.
How's that working out? Number one, two things. The world continues to revolve without you. And number two, you can't be getting paid for being in jail, right?
No, sir.
Well, the boat's leaving and everybody's waving on the stern and you're just standing at the dock. Going, see you later. Maybe. See y'all when y'all get back. That's really, I mean, I'd want to be on the boat.
Yeah.
What's probation office say? He's been on probation. Yeah, we're talking about going on 9 years now. How's he been doing up to now?
Fairly compliant up until now.
Ma'am?
Fairly compliant up until now. He completed Alcoholics Anonymous in 2016, and he did DWI intervention in 2018.
Okay, what else do we need on him to do? I mean, other than go 10 years in prison, what other things, what do we do about this event? What do you think?
I think 30 days progressive sanction jail term.
What's Stacey have to say?
Yes, Your Honor, leave it up to the court. As you said, he's been on here for quite a while. Seems to be his only real mess up, but some kind of a jail. Yes, sir. It certainly ties into the original offense, and
for many people, it's not as much a big deal. For you, though, it's the essence of what you're on probation for. All right, I'm going to find that there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater. as allegations one and true have been proven true, as you have pleaded true voluntarily, knowingly, intelligently, which is sufficient to revoke your probation and sentence you to no less than 2 nor more than 10 years confinement in prison. But I'm going to defer any actions at this time. Hold this in abeyance. And we're going to review this in 60 days, but how long have you been? You're going to stay in jail a total of 30 days. And I don't know where you are on that right now.
It's 20 days, right?
All right, 10 more days, and then hopefully you won't lose your work, but you need to be putting forth a 110% effort on work, family, whatever that is, again, putting the needs of others in place of your ridiculous priorities of going back to what got you in trouble the first time. Okay. I don't need to talk about it. We all know. Fix this. And really, you want to flirt with 6-figure job that are hard to find. They're out there, but it takes responsible people to handle them. And then you do well and doors open up. And do you have a family?
Yes. Yes, sir.
Oh, children?
Yes, sir.
You do this, they get hurt. You wouldn't want that, would you?
No, sir.
Well, but you know that's what happens. And you gotta start. You gotta live more selflessly. Or anything else?
Oh, yeah.
That is all.
Thank you.
And those will be amended term 30 days. You got 10 more, get released and do better. Okay. You were David Lionel Jackson the fourth.
Yes, sir. Yes, Your Honor.
Okay, well, there's a third and then there's a junior and a senior, right?
Yes, Your Honor.
Yeah, I'm a junior and that means a lot of people with your name in your family, huh? Are they all fine people? Uh-oh, you're looking over there. Well, sometimes they can be something, but the point being, are you doing your part to uphold the good name of Jackson? Are you trying? Do you want to be good?
Yes, Your Honor.
Good. That's the first step. You set the bar and then get over it. And here we have what is unusual, a fourth amended motion to revoke unadjudicated probation. And you've been on probation since 21, I believe. And you were here in this case with Mr. Gertz, your attorney. Does the defendant waive a formal reading of this? Can we proceed in summary?
He will.
In summary, and Mr. Jackson, raise your right hand. You solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God. Lawyer. In summary, this motion states that on October 14th, 2021, in this court, you were placed on deferred or unadjudicated probation for evading arrest or detention for 7 years period of probation. Is that true?
Yes.
That's a 3rd-degree felony. Let me see where we go. Second. Second. On the first one, there was a first amended and the defendant pleaded to number 5 and three. 2 and 3, which were, and that was back in
And I believe 5 is.
February of and 5.
Yes, sir.
He pleaded true to committing the offense of failure to identify fugitive false information, failing to avoid injurious or vicious habits by possessing a firearm, and finally providing a urine sample showing the presence of marijuana. So that was back in 2023. So I ordered 30 days county jail on weekends, placed him back. Then there was a second amended file in April, a third amended in August, and a fourth amended. So 7 through 14 to deal with. Number 7. What are we doing today?
We've got an agreed plea deal. We don't need, I mean, you can go with the previous ones that we've already pled true to, or we don't need to. I mean, we'll wait.
Let's find out what's done, where we are. It helps me make a decision. 7 states you were observed by Sergeant Sean Schroeder to be intoxicated on an unknown substance on or about while checking into the county jail on April 7th, 2023. Is that true or untrue?
True.
8. On April 18th and April 19th of 2023, you were at a location other than your home, namely 1455 Wooten Road. Well, I'm not sure if Wooten Road is your home or not. Is that your home? No, you were at Wooten. What's that? What was that location? Do you know?
Going off the highway now.
What was going on there?
I was going through a living situation. And
You were what?
I was going through a situation when I was kind of trying to find somewhere to stay, and I actually got.
Who was there? Somebody you knew?
Yes.
Who are they related to you?
A friend.
Girlfriend? A friend?
Yes. Yes, sir.
Okay. 7 states you failed to report to the probation office on or about June 7th and July 12th of 2023. Looks like 2 months you failed to report. Was that true?
Yes, sir.
10, you failed to immediately report to the probation office a change of address and phone number. Did you move? Last year?
Oh, yes, Your Honor.
And it says you didn't report the change like you're supposed to. Is that true?
Yes, Your Honor.
Where were you now where were you recently until you went to jail?
In my grandmother's house.
And where?
My grandmother's house, 2280 East Lucas.
Here in Beaumont.
Yes, Your Honor.
Okay. 11, you failed to provide verification of attending and successfully completing drug rehabilitation orient program, the DROP program. Is that true?
Yes, Your Honor.
You failed to pay assessed fees. You're not too far behind there. 13, you failed to report to the probation office on October 17th, 2023. Is that true?
Yes, Your Honor.
And 14, you failed to immediately report a change of address. Again? Have you moved again since the previous change? You're moving around according to the probation office and not telling anybody. Awesome. So are you pleading true to 7, 9, 10, 11, and 13, the ones you've admitted to in this 4th amended motion to revoke unadjudicated probation?
Yes.
Or are you making those pleas voluntarily, pleas of truth voluntarily, knowingly, intelligently, and because they are true?
Yes, Your Honor.
Do you understand that a knowing and voluntary plea of true to one or more violations of probation is enough to grant the motion to revoke probation? Your probation can be revoked. You can now be found guilty, sentenced, well, to no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, Your Honor.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. We hardly ever get a 4th amendment motion to revoke probation. Generally, they never get past 1 because people fix it or they're revoked. Much less a 2nd, 3rd, and now 4th. Huh. Sounds like you've had more than your fair share of chances. What do you think about going to prison for 10 years? I can tell you what I think about it. It wouldn't be nice. Well, I mean, that's, this is a result of the choices that you are making. Right? These are choices. Right, wrong. Okay, and we're held accountable for our choices.
Right.
We're rewarded for good choices, punished for bad. What do you think we ought to do?
Judge, we have an agreed deal.
I thought you kept saying unagreed. That's not what's going on. It's agreed,
It's a
right?
agreed deal.
Okay. What,
It's written, it's all on the,
it's all on the pad somewhere? Let's see.
out in the nether regions.
See if David line now. Okay, there's an agreement that's been reached where probation would be revoked. Then you would be found guilty, sentenced to 3 years in prison. Is that your understanding of the agreement?
Yes, Your Honor.
If I follow that, then you would, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
What happened here? What happened? How'd you fail?
I've been going through a lot of some.
Welcome to everybody's world.
Well, I'm not making no excuses.
I know, but is this fixable though?
Yes, Your Honor, it's this.
Okay. Fix it. Because the next, things get worse in criminal law. Subsequent misbehavior gets higher punishment. Okay. I'm kind of disappointed. I was hoping you'd have done, been successful. I'll show you what's marked as State's Exhibit 1 here. Almost missed that council line there. So, did you sign that document?
I did something.
Down at the bottom there. Is that your signature? Okay, yeah. State's Exhibit 1, understand it, discuss it with your attorney. Is everything true and correct here?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence.
We have no
Without objection, admitted. This states that you were waiving and giving up all rights of appeal if I follow this agreement. I'm going to do that. Reluctantly, I wish it would have been better. I'm going to find that there is sufficient evidence supporting this fourth amended motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegations 7, 9, 10, 11, and 13 are all proven true. Your probation is revoked earlier. In this case, you pleaded guilty to this third-degree felony of evading arrest or detention. You pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that hearing back on October 14th, 2021, to find you guilty beyond a reasonable doubt. But I deferred any finding of guilt and placed you on deferred or unadjudicated probation. And now I am revoking that deferred or unadjudicated probation due to these violations today. In this fourth amended motion to revoke unadjudicated probation proven true. Your deferred or unadjudicated probation is revoked. You are hereby now found guilty beyond a reasonable doubt based upon the hearing that we placed you on deferred or unadjudicated probation for, and State's Exhibit 1 admitted that found that there was sufficient evidence to find you guilty beyond a reasonable doubt. I now so find you are hereby found guilty of this third-degree felony, and I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will be given credit for all time, of course you will. You have served in accordance with it. Okay. That is all. And that.
Thank you, Judge.
There is a motion to revoke unadjudicated probation here, Mr. Navy, and raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God. Okay. Lower your hand. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Your Honor.
40535. In summary, this motion alleges that on June 5th of 2023, you were sentenced to 10 years deferred or unadjudicated probation for robbery, a second-degree felony. Is that true? One states you failed to report to the probation office since your release on June 23rd of 2023. Is that right?
That's correct, Judge.
You never reported? Is that true? Well, today is May, almost a year later, and you've never reported. Okay. Is that true then? Allegation one. No.
That's it, Judge.
That's
enough.
Are you pleading true to allegation one voluntarily, knowingly, intelligently, and because it is true?
I am.
Do you understand by a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant the motion to revoke probation by a preponderance of the evidence of greater? Your probation can be revoked. You can now be found guilty and sentenced to no less than 2 nor more than 20 years confinement in prison. Knowing that, you insist on pleading true today?
I do.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement's been reached here where whatever sentence shall not exceed a cap of 8 years in prison.
Yes, sir.
Is that right?
Yes, yes, sir.
So you're looking at no less than 2 nor more than 8 years in prison. You can be placed on. You could be found guilty and then placed on regular probation. And then I guess I can find enough to revoke but continue your probation on deferred. I don't think those are your 3 options, correct, everybody?
Yes, sir.
Yes, sir.
If I follow this agreement again, you have no rights of appeal of your case. Do you understand?
Yes, Your Honor.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents all true and correct?
They are not.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states whatever I decide here, you have given up all rights of appeal, motion for new trial, arrest of judgment. Anyway, whatever the court does, you're kind of throwing it on the mercy of the court here. And with a cap of 8 years. All right, State's Exhibit 1 is made a part of the record for all purposes. Let's see, I'm looking at your pre-sentence report again, and you have, as far as felonies, in 2010, theft in Smith County, probation was revoked and you were sentenced to 6 months in the state jail. In 2013, you received 2 years in the state jail for a theft, 18 months for theft in 3 cases on June 13th of 2016. Then you received another theft, 2 years state jail. In 2018, that was revoked in 20, and you received 20 months in the state jail. There was a second case, you received 20 months from a probation violation on that day. In Harris County, in 2018, 8 months state jail. Well, in this case, you were originally indicted for aggravated robbery, which was later reduced to the 2nd-degree felony of robbery, not aggravated. It was part of another theft. How many theft-related convictions do you have, sir? I'm looking at 1, 2, 3, 4, 5, 6, 7, 8 felonies. 1, 2, 3, 4. Misdemeanors. Okay. Go ahead. What's they saying?
Judge recommended the 8 years. I think he's got plenty of criminal history and not reporting. He's just not trying to do anything to better himself or make any type of amends to society. So we just ask for the 8 years.
Okay, David Grove on behalf of the defendant, and the defendant next state.
Would you like to tell the judge what you think the judge should sentence?
Yes, Judge, I have no found drug addiction. And
For how long?
20 years.
Well, why haven't you handled that responsibly? You've had 20 years to do something about it.
Yes, sir. It's been the bane of my existence, Your Honor. It's been a struggle for me. And the last time I was before you, I asked for your help and you sent me to safety. I was clean 2 years.
And then we fell backwards, didn't we?
I got clean, yes, sir, and I have a relapse situation. But I know there's goodness and greatness in me, and I'm not gonna do a lot better than I'm doing. And I'm very sorry, obviously, for the things I've done. But I'm not gonna do that.
I believe that there's greatness in most folks who aren't sociopathic.
Yes.
But it's all in the choices that you make.
Absolutely.
It doesn't matter what the capability is if you don't act upon that capability and make it the right choice. And that's what we learn from mistakes, but here we've got double digits of the same kind of mistake.
Judge, in addition, when Mr. Navy was released on probation this last time, he thought he would be able to live with his mother and have her support him. That did not work out. He also has a brother who has stage 4 cancer, which that further complicated things. But it's not an excuse, but that just.
How did that complicate things?
It didn't complicate things in
No, it
that
doesn't.
way.
Everybody
No, sir.
has health issues, yeah.
What happened was, when I was grateful for the probation, but I have no
I gave,
support.
I believed in you.
I have no support in the world. I have none. My mother has her own issues.
What about
with
yourself?
The hole I've dug for myself is just so huge.
Orphans have to rely on themselves, but
Yes,
they
sir.
make the
Yes, sir.
right
Yes, sir.
choices.
I'm absolutely blind.
Oh, all right,
I'm
well,
absolutely
you admit it, that's, a lot of people don't. All right. Anything else anybody wants to say?
Yeah.
All right. Then the court is going to find that there is sufficient evidence to support this motion to revoke unadjudicated probation as allegation 1 is proven true by a preponderance of the evidence or greater, as the defendant never reported to probation as he was required on June 23rd and 23 and was an absconder until later caught. His criminal history is prolific in misdemeanor and felony theft related convictions. This is a robbery, which is a theft related conviction type of case that the defendant is on probation for. And anyways, there is sufficient evidence supporting this allegation to grant the motion to revoke probation by a preponderance of the evidence or greater as the defendant has pleaded true voluntarily, knowingly, intelligently. And that is sufficient to grant this motion. It is granted by a preponderance of the evidence or greater, and your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense, and you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. You will be given credit for time that you have served in accordance with that. Anything else? Let us on.
No.
More, is that you, sir? Present with your attorney, Mr. Sandel, and the state's attorney. You've been charged with murder in this indictment handed up by the grand jury on February 14th, 2024. It alleges that on or about December 3rd, 2023 in Jefferson County, Texas, you committed the offense of murder by shooting the victim with a firearm. Do you understand what you're charged with? Sir. Okay. You're asking the defendant's bond is now,
At $1 million, we're requesting it come down to at least 50,000. He's a student. He's 17 years old. He's a student. Both of his parents have been in each one of the well, the last time we were here, they were here. He's not working. He cannot afford to pay a bond. His father works in a refinery and as a contractor, and his mom is a certified nurse assistant. He has no checking account, no savings account. He has no money set aside. He has no means of raising an amount that would get him a bond of $1 million. He has no prior criminal history. He has a pending charge of unauthorized carrying a weapon and this charge. We believe that with the weapon charge, that will stand on its own. But we believe the presumption of innocent until proven guilty is off. It's really not being seen when he has a bond of $1 million, because that's not something that he can do. So he has no prior criminal history. He turned himself in. He will be living with his mother. His mother is here, his father's here. He will adhere to any conditions of bond, even if it means the monitor or any means that the court sees fit. He's not a flight risk. He doesn't have money to flee, and he does not have a passport. He's from Beaumont, born in Beaumont. All of his family's in Beaumont. He has 2 young brothers, 2 younger sisters. They're all in Beaumont. So he will adhere to any conditions that's set by the court as far as bond. He will appear at any appearance that is required, and that he's shown other than these offenses in which he's presumed innocent, he's not done anything contrary to show that he's a risk to the community safety. And we're asking that the bond be lowered so that he can help me in preparing for his defense in this case.
what's that say?
Judge, looking at the probable cause, you can see that not only did they shoot the person in the house and kill him, but later came back again and went back into the house, then came back out, then tried to destroy the evidence by burning the vehicles. A sweater, which is not mentioned in the probable cause, was found by the burning vehicles right outside the Suburban with blood on it that matched the defendant. So the DNA came back matching him in the octaves. We would disagree that he's not a danger. This is the worst we could get, is a home invasion where people get killed inside their own home. So we would ask that the bond stay the same.
What's the issue on this unlawfully carrying weapon charge? What's the status of that? It says on.
It's still pending. It's a pending misdemeanor.
How long does it take? Generally, y'all file on these pretty quickly. What are y'all waiting on, if anything? Can you
It
tell me?
says there was a deferral in August when it was sent back to the police department for more information. And then it finally got filed in January this year. I don't see a court setting
What's
yet.
been filed? Oh, so there's a charge filed.
There's a charge filed unlawfully carrying a weapon, yes, sir.
Okay.
And again, everything that's been stated by the court is an assumption, because there's a presumption that he's innocent of that. And this bond, as it is excessive, and that's tantamount to being no bond at all. And I think the Constitution states that each individual should have a right to a bond.
That's, it infers that, but that's not what happens though, is it?
No, and that's why there's
The
been
law.
an assessment. They give a means of dealing with that. And that's what we believe.
The gun that he's charged of having possession of was a mini Draco, which is a small assault weapon. Smith and Wesson caliber handgun and Glock. There were 3 guns in the car with these people. He was one of them.
There were 4 passengers in. And we believe the facts will show that he was not on board. But that's for another day, another time. We just believe he's still entitled to a bond. A reasonable bond. That's not reasonable for someone that's 17 who does not have a job.
Why not? Why doesn't?
Because he doesn't have the means of doing it. He's a student in school trying to matriculate to get his diploma.
I went to work when I was 16 at 3 in the morning
So did I. Well, I wasn't 6 in the morning.
on Saturdays and Sundays. But I was a student
That was years ago. Oh, excuse me.
about the time you were in.
Okay.
As I recall, it was like the same time.
Touche. Okay.
All right, here's the rules of bond, of course, are set forth in Article 17.15 of the Texas Code of Criminal Procedure. The nature of the offense and the circumstances under which the offense are committed are to be considered, including whether the offense involved violence. Here, well, is there any more serious crime than the murder of one of God's creatures, a fellow human being? No, it is an offense involving violence. And the nature of the offense is this was a home invasion, correct? Where
That's correct. Allegedly.
I'm talking about the probable cause affidavit, which is in the court file here,
Yes.
which states that the defendant was involved in a home invasion where the sanctity of one's home is foremost, and when that is invaded, of course, that is an aggravated factor. The future safety of a victim, law enforcement, and the community shall also be considered. Bail factors also from court decisions include aggravating factors of the charged offense and any prior criminal record. I don't see a prior criminal record, but the state has filed an information charging the defendant with a misdemeanor of unlawfully carrying a weapon. What I want to do is I'd like to have a hearing on that issue. When yeah,
Yes, sir.
since this is a crime of violence involving shooting of an individual by a weapon, I want to see what connection the defendant has and what the significant evidence is to support unlawfully carrying a weapon.
Yes, sir.
I'd like to have that in a week,
Yes, sir.
and I'm going to defer any finding until that hearing. All right,
In a week.
week. Give everybody time to be ready on that. And we are in short recess.
Every day in the USA, people find themselves in court.
So everybody in court has a role. I'm the judge, of course. You have prosecutors and you have defense attorneys. The way this district attorney's office runs is similar to the way other district attorney's offices run. And usually you have different divisions for prosecutors. You have criminal trial division and you have family violence division. So over here is criminal trial division, over here is family violence. Family violence, they handle anything involving children, anything involving family, anything involving boyfriend, girlfriend, type of relationship things that way. This side, they handle everything else that's really not that. You do have what they have a civil rights division, and that division handles any cases in where police officers are alleged to be, well, police officers are the accused. Right. And then you have an integrity division, and the integrity division works on maybe somebody has an innocent claim. They'll say, hey, I'm actually innocent of this, or at the time I didn't receive the discovery that I'm supposed to receive. Sometimes they'll get notices of stuff like that, and they'll look over the case and see whether it should be dismissed. I think from cases, I've had cases in my court that have come back before I was even judge with the integrity unit, and they'll look over them and we'll have counsel appointed to that person to see whether or not their case should be dismissed or not. Yes, yes. And sometimes it's cases involving DNA. Yes.
Morning, Judge. On Sebastian Delgado, that's just a PTD contract issue.
All right.
We submitted that this morning.
All right. Let me have the clerks come out because they are not out here for some reason. Oh, there you go. I can't see you around the screen. Attorneys, if you're ready to approach, then you need to have the clerk pull your file. Only approach the court if you confer with the state and confer with your client. All right. And I'm glad you're speaking up now.
Morning, Your Honor.
Good morning. How are you doing?
Fine, thank you.
I have an intern here.
Do you really?
Yes.
Oh, good.
And thank you, John. I knew
The
bloom.
magnolias are out.
They're in bloom. I love, it reminds me so much of home.
I took one over to Tamworth
Yeah.
for old time's sake.
Okay.
I just want to make sure nobody had stolen it.
Aw, thank you so much. I appreciate it.
People around here, you know?
Yeah.
Thank you, ma'am. Judge, remember Thomas?
Yes.
And then Leticia, he referred Leticia.
Yeah.
Well, they called me last week that they wanted to take me to dinner because they were so appreciative of what I've done for them. So we went out to eat and everything, and
That is so
they
awesome.
didn't want me to pay, but of course I paid anyway.
Yeah. Oh,
Yeah.
but yeah, so you'll have to meet the new intern.
I'll go around here in a second.
Okay. So those are divisions, and we have some more divisions in the district attorney's office. Like you do have prosecutors. This is Johnny Cisneros.
What's happening? Thanks a lot. Have a good day. Have a good day.
I would rather.
It's all a ruse from Joe Gonzalez.
You're doing pretty well, so it doesn't matter.
No, he does great. Thank you.
I'll be back a little bit. I gotta look something in the water.
Oh, sure, no problem. So they have other divisions upstairs as well. But you'll be able to learn a lot. When I was in law school, I'm more the person who learns by doing. I have to, and then I can see, this is why it's this way. Because I'm telling you, the rule against perpetuity, you just, And then finally, when we take the bar exam, I'm like, oh, it's so clear now. But doing it, you learn it. We're probably gonna end up having a jury trial in here on Tuesday, and they'll have the jury selection, so you'll get a chance. Unless everything works out, you get a chance to see a trial from beginning to end. And so, and then the other person people tend to ignore, but they're very important, is the court reporter. So.
You could be right. I thought it was a.
So they take down everything that everybody says. That's why I always tell people, please speak up. Because when you think about it,
Yeah, that's what.
there are no less than
Okay. Sure, we'll visit this week.
4 people that they usually have to take down on average. And then on the civil side, sometimes it's 6 people. And if you can imagine, everybody talks at a different speed. Some people whisper, no matter how many times you tell them to speak up, but they have to take everything down because if it's not in the record, it sort of didn't happen. And what I mean by that is when they're doing a record for an appeal, they'll try their best to like put on the headphones to listen to see if they can get that one word. And then if they can't get that one word, then it's, you can't get that one word. So they do have a shortage of court reporters though, and they're looking for court reporters. So you know somebody who would like to be in a legal field, but they don't want to go to law school. They want to do something else. Court reporting it's a good lucrative job to have. Yeah, ask them. And so it's very lucrative if that's what you want to do, and you get a chance to hear what everybody else is saying. So yeah. But and the other thing about the prosecutor's office, they have first chairs, second chairs, and third chairs in felony court. When I was in felony court, I would always tell my second chair the only difference between me and him. They would say like, what's the difference? I'm like, there's no difference. You're an attorney, you have a bar card. You know, review a case. If you have a question about a case, ask me. If I made an offer in a file and something changes and you feel like that offer should be changed and somebody comes up to you and change the offer, just have a reason for why you're doing it. Some people don't feel that way. That's the way I did it when I was starting, because you got to let them fly and spread their wings. But so Jason Gerhan, that's the first chair. Jason, can you raise your hand? If you'll raise your hand. All right, that's Jason Gerhan. He's the first chair. That's Daniel. He's second chair. That's Hank, third chair. Well, second chair now because he's been promoted. Congratulations. Yay. All right, and then over here, I'm still learning your name. I'm so sorry. Margie. I don't know why I can't remember that. Over here, we have Margie, and she's in family violence. So move about the courtroom. Right now, you have an attorney here. He's talking to one of the prosecutors, and they're probably negotiating plea offers, or maybe there's discovery that he feels he doesn't have. So step down, get in the mix. Yeah, just go up there. Yeah. You got to be bold. Sure. And then after that, I'll introduce you to probation and the advocate. Sure.
Then we left them in the back.
Oh, yeah. And then I'll introduce you to the deputies. So Jason, Hank, Daniel, he's a little bit shy. Move him into the mix. Let him see what you all are doing.
Here, it's actually and this is
Maria, whenever you whenever you need a break, just let me know.
okay, yes, thank you.
Sure. I'm gonna grab some sheets.
Horrible handwriting.
I know.
I'm sorry for her.
No problem. What overtime here?
Ron, if I'd like to put something on the record, can I do that?
Okay.
Well, Judge, here's the thing. Did I tell you about my first week on the job?
No, you did not.
I was sitting in the cafeteria.
Do you have your rubber boots on?
Yeah, I do.
It's gonna get high here, I feel like.
I was sitting in the cafeteria, Judge, and I'm just minding my own business, you know? I'm a new kid on the block, you know? And one of the prosecutors for the DA's office came up to me and he was like, "Give me your lunch money." And I was like, "Am I being bullied?" I'm like, "Is this like, am I like in middle school?" Like,
what's happening?
And he threatened me. He was like, "I'll beat you up if you don't give me your lunch money."
What?
Yes, this is true.
Get out of town.
Uh-huh. Oh, yeah, right here, Judge. Look no further. And he said, "Remember the name, Hank Wilkins." And see, he was already intimidating then, but now, Judge, that he's been promoted, I find him extra intimidating.
Oh, my God.
So I'm just wondering, is he staying here, Judge? Are we putting him back there with those guys?
Oh, no, I think he's gonna be here.
Well, I'm a little scared, Judge. I just want to know.
And now I think he's gonna charge interest.
Trying to be, I've never been intimidated.
You know, on no jokes, he actually was my first email at the DA's office.
Oh, wow.
The time you were with the conviction Tariq, or they send you the emails when you first on board, he actually was for real, the first person to ever reach out to me
Oh, wow.
and like welcome me to the DA's office.
Well, and Zach is very proactive. He came down here and was like, "Hey, I want to meet you." So that's good, you know,
Yeah.
That's real. Yep. Hank was the first person that ever said like, "Welcome to the team."
Oh, that is so awesome.
You know that?
I just recognize talent, you know. And
Oh.
He was looking in a mirror when he said, "Excuse me."
Oh, and Deputy Laura, whenever you want to take James to the back, you know.
We'll take them.
Yep.
I can't believe it. I'm caught up on my emails. And just as I say that, I get more emails.
He was so nice. Very good.
I was their chair.
Vashon, can I see you for a moment?
That's where you.
Hello. And Robert, we have an intern and you're sitting next to him. Yes.
Yes, I think I saw it.
And Margie, I just figured out why I couldn't remember your name. Now I'm gonna know it always. But it's because I never see your name on documents.
On document?
Yes.
It's because, yeah, I've been recently trying to sign them off and fill them in,
But
yeah,
once it
exactly.
gets to me, but now I know it. So you don't even need any documents anymore.
Sure, okay. I'll take it, yeah. You want the file or? No.
And I told you this.
So these grants and all. Yeah. Whatever you can. I do not have. I'll look at something.
How many days long somebody has?
Oh, I know. It was just easier this way.
2024 CR 1418. Six days ago. This is first settle. 30 days. Oh, I'll wait.
Oh, I'm the one who set
Okay.
cases. Yeah. All right, Jonathan Dash.
Do you want him up here, Your Honor?
Yes. And let's see. All right, why were you late?
They told me second floor, came second floor, told me fourth floor.
All right, so now you know where the court is, so do not be late, okay? All right, counsel, have you received all the discovery?
I believe so, Your Honor. I still need to review to make sure that I have, this is our first setting, so I still need to go through everything.
All right, State, were you able to tender an offer?
I wrote an offer, but I don't know that's, we had to take a chance to talk out. No, we had, Your Honor, I wanted to, I guess, wait until I review discovery before I discuss an offer with the state.
Okay. All right. All right, we're gonna recall this, and it's being recalled for June 10th. And that's gonna be your plea deadline date. At that date, you're gonna need to let the court know whether or not you're accepting the state's offer or whether or not you want a jury trial. Do you understand? Once I give you the reset form and you sign it, you're excused.
She excused, Your Honor?
Yes, once he signs the reset form and turns it in. Yes. Oh, that is so awesome.
We had a good time.
Oh, that is so
We were
good.
there 3 hours, I think.
Oh,
Yeah, we had a really good time.
that is so awesome.
It makes me feel good, and I asked them, how much else do you want to have when I was at 75 years old? You know?
Yeah.
I said, we just love your character, your personality, and
That is so awesome.
so it was an honor for me to be invited by them.
Oh, but yeah, if you have a trial or something coming up, you know, James would be willing to work on it.
Okay, thanks.
Okay, awesome.
Yes, ma'am. I'm gonna tell him something in front of you.
Okay.
I'm the only one. You can look me up on the internet. In the history of undergrad and law school that made the dean's list all through undergrad and law school. Now, my name was never on it. I worked at the office and I would print them out.
Man. I like that.
Okay, run.
Oh, James. Oh, so those are inmates. Sometimes people are remanded without bond, which means they're not allowed to have a bond. And then you have some people who have a bond and it's too high and they can't make the bond. So that's why they're in custody. And different colors of uniforms mean different things. So the male inmates, they can be in orange, they can be in tan or sort of like a gray color, and they can be in red. The orange color is just someone who they say is not a problem child, right? They just have like basic charge. Maybe it's theft, maybe it's a drug case. The red they're usually an administrative segregation. Maybe they're a gang member. Maybe they've been causing issues at the jail. So that's what red means. And also sometimes they will put people in different colors or put them in segregation for different reasons. Sometimes it's mental health issues. Sometimes it's because they're gay or something of that nature. They will separate them. But then you have some people who are a member of the LGBTQ plus. I mean, I hope I didn't miss anything. They will have them in general population, but that's because they're fine with being in general population and they want to be in general population. The females, their colors are blue, which is similar to orange in the fact that it's just, they're really not going to cause any problems. They just have your standard cases. But then females can also be in red too for gang membership or they're causing issues at the jail. And sometimes they will have them, you know, in the tan or white or gray, and those are trustees. So those are people that they get extra credit for helping at the jail. And when I say extra credit, when people are serving time at the Bexar County Jail, you either get day for day, which means if you're in there for 5 days, you only get 5 days credit. But then you have some, and usually that has to be requested by the judge saying, I want you to serve day-to-day time. I normally never do that. Then you have some people who, when you're in the jail, automatically you get 2 for 1. So that means that for every day you serve, you get credit for 2 days. And then you have people who are trustees. Trustees, they get 3 for 1. So every day they serve, it counts for 3 days. And that's because sometimes they'll take them to clean trash around the building. Sometimes they're painting. I don't think they do it anymore, but usually they would send them to the court to paint or something like that. Then you also have females who are in yellow. That's either solid yellow or white background with yellow stripes. That means they're pregnant. And that's help the deputies know, because when you're pregnant, you're not supposed to handcuff them behind their backs for medical reasons. So that's the thing. And that's their classification. Yeah. And so whenever you have a client who's being difficult with you for absolutely no reason, sometimes clients will be difficult for you because they just want to be difficult. But other times, sometimes there may be issues and you want to look at what their classification is. And the deputy, when she gets a break, she'll show you the cards they have, because they get a card for every inmate who comes over. And on it will tell you what their classification is. Like, are they in the mental health unit? Are they in the infirmary? Because they do have nurses at the jail. Now, sometimes there are things they can't handle, so they'll send them to University Hospital, which is usually where they go if there are major medical issues. But they do medications and that type of thing at the jail as well.
Yeah.
So
So I'll
that's
just
the
talk
thing.
to them. Okay.
Yes, and if you ever want to
Thank you.
a tour of the jail, just let me know.
I remember you gave
Yeah,
me a tour.
I did.
Neat experience.
Yeah, it's like code 2.
Yeah.
Oh, yeah, because I always tell people, honestly, if you want to be a prosecutor or defense attorney or work in the criminal field, you really need to see all of it so you can make an informed decision. Like, is this my passion? Is this not my passion? Because it really has to be a passion thing. Because honestly, the solo practitioner's life, you're not going to get super wealthy. Like what you see on television where somebody gets a case and they get paid $200,000 for it on the criminal side, that's very rare. It's rare that you have somebody who's charged with capital murder and they can actually afford an attorney, because when you think about it, you have to pay the attorney. You need a mitigation expert, and that's standard for capital murder cases if they're sentenced to death penalty, even if they're not. I used to always want a mitigation person to delve deep into my client's history and talk to family members. And I talk to family members, of course, but I'm looking at it from the viewpoint of a defense attorney and how we can make all of this work. But sometimes you want somebody to look at it from the viewpoint of a mental health issue. And if somebody is guilty, how can we mitigate their punishment? I always tell people, when you do go to a jury trial, if you're a defense attorney, you should always think worst case scenario. Worst case scenario is my client is found guilty. How are we gonna handle that? What witnesses are we gonna call? Because once the jury finds you guilty, the only thing the jury knows about you, unless other things have come into evidence, is that you've done a bad thing. And with the jury, sometimes, even though they're not supposed to let sympathy or bias play any role in their decision, when it comes to punishment, you want the sympathy, like, hey, here's my client, this is the hard life he had. I once had a client on the CPS side, and he ended up having, his children ended up having a case on the criminal side. And I was sitting there, and I went up to the defense attorney and said, hey, your client has been through a lot, and you need to ask for CPS records. And maybe the state will offer something different. And once they realize everything that he'd been through, they did. He's doing great now. But yeah, so that's what you should be doing as a defense attorney. So, and being a defense attorney is sort of like when you first start driving, you follow all of the rules. Like if somebody says, hey, this is where your hand's supposed to be on the steering wheel, you turn your signal here always, and this is the number of feet. But of course, once you become a more experienced driver, the hands on the steering wheel go out the window. Because what had happened to me in Louisiana, I had my driver's license and I went to go get it renewed. Now, mind you, I have been driving forever. I think by that time, like maybe 10 years or something like that. So I go back to get my Louisiana driver's license. They can't find me in the system anywhere that I ever had a license. I'm like, here it is right here. And do you know, they made me retake the driving test. And let me just tell you, in my mind, I'm like, oh my gosh, where are my hands supposed to be on this wheel? What if I fail the driving part? Because I lost everything. And the guy tried to trick me. There were some train tracks. He's like, oh yeah, you can turn up here. And I'm like, it's not a one way. I'm not allowed to turn unless the light has changed. But it was, my heart was beating. And then he tried to joke at me and play it off when we got back to the office, and he's like, well, I've never seen anything like this before. I'm like, no. And then he told them, okay, you pass. I'm like, yeah, because I was just like, oh my gosh, I'm not gonna have a driver's license. So sometimes that happens with the attorney. And I would always tell people, when you come out of law school, you know more law than any attorney knows who's been practicing, because you just got it all, and law is changing. Of course, you know, the Constitution is the Constitution. Certain things are not going to change as it relates to that, but everything else about new things. Oh, just one second. Michelle, does anyone know?
They're double checking that right now, Your Honor. I don't, it looks like they've given me everything. However, it's a very big file because it's many bank statements that need to be combed through.
All right, so your July 8th date then will be for discovery. Everyone needs to make sure that all the discovery is there by that date. And once you sign the reset form, you'll be excused.
Thank you.
You're welcome.
Yeah, of course.
All right, and this is the docket sheet. So what the docket sheet is, it's a link to everybody who has court today. And there's one that's produced every single day. Now, sometimes the system messes up. And that's why I always look to see if there are cases that have not been set. But everybody on there is everybody who's supposed to be in court today. And some of them are inmates. And if you look at it, let me show you. So off to the side here, right now, that means they're in jail. This means that they're on the bottom. you look through it, all of them will let you know. And on the side, this is the list of terms. An A means they're appointed. Usually they're appointed by the system, and H means they're hired. And then if you see somebody with nothing by their name, that means that they have something happen in the system, and either they haven't been interviewed for an attorney, or either sometimes it'll say denied, which means they were interviewed for a court-appointed attorney, but the decision was made that they can afford an attorney. Yeah. Yeah. Yes. And then there is a while on the CPS side, because it's civil. Before I became an attorney, they would not give you an attorney for different proceedings. But now that's changed, so you have an attorney at a majority of all proceedings. Sometimes when it's a safety plan, where they're just trying to help you out, saying, hey, clean up your house, and we'll come back and check on it. If it's clean, we won't file a legal case, but that's on the civil side. And usually you will find that your CPS cases, which are child protective service cases, sometimes those become criminal cases.
Sorry.
Because usually you have an allegation of physical abuse of a child, sexual abuse of a child, or maybe a child died. So even though you have the case over there, you'll have it running sort of like a companion case of a criminal side. But even though they're completely separate entities.
July.
And the key thing
Yeah,
about
so there's
civil
July.
cases and criminal cases, on the CPS side, if your client decides to take the fifth, it can be held against them. Yes. And so on the criminal side, it can be held against you, but yes. And so sometimes I would have clients on the civil side, and they're like, oh, I want to testify. I'm like, no, because whatever you say over here, somebody, if they're paying attention, they're just gonna come over here and ask for the transcript. And then it could potentially be held against you. On the criminal side, when you testify, they'll use it against you. And technically, it wouldn't be hearsay because it's taken while you're under oath. But sometimes people would have to balance, do I want to fight for my child? Plus risk having a criminal case because of what I've said. And sometimes on the CPS side, they want you to admit what you've done, because that shows that you accepted responsibility. Accepting responsibility is big over there because it shows that you're learning and you're internalizing what they believe you did wrong, and you're making changes. But then that counts against you. Yes. Okay, let me see this. Could I see the following? So Vashon, on that one, they're gonna withdraw their plea and do a new plea agreement, I'm assuming. All right. Okay, all right, thank you.
Work schedule and they'll attach the response, same with the you know, the hours of this. You might as well. I mean, yes, that was that's class. I don't know, but this is now. Well, he shouldn't have.
Well, he's, yeah, spring semester then, yeah. he should- So he should know. And then some. Well, so it's. Yeah, the spring semester. So he should know the schedule.
I don't want to be difficult, but yeah, it's really, you're by the line. It's for 15 hours. 7 AM. It's the whole. You might tell me.
Yeah, but we've all been college and we have different classes.
But if you attach the schedule, then no one has to finish.
Sorry.
Yes.
Same thing.
Two things. First, I apologize. I wouldn't have given you the flower if I'd known I was going to be coming here to see you on business.
Oh, no problem.
Second,
I love flowers.
this gentleman did not show up in March. I was hired after that date. So I didn't realize he'd already
That's what that is.
muddied the water here in the court.
So is he in custody?
He is not in custody. What I want to do is get the bond set so he can go to a bail bondsman, get the bond money for the paperwork, and then show up over at satellite office.
All right, so then here's the issue, because I need to see him
Okay.
in order to do it. But if you take this to Judge Nahara, he'll take care of it.
No.
Okay.
Yeah, and he's in the basement, I believe.
I know he is.
Okay,
And I will take that with me. Thank you, Your Honor.
you're welcome. Yes. Oh, here it is over here. Who's here on Dylan Bell? Type it. Thank you. Yes. And everyone, just give me a moment. Yes. Okay.
No worries.
I can ask you a question.
I would have to ask about this.
Every day in the USA, people find themselves in court.
Miss Rot Johnson, can you hear me?
Yes,
Are you also known as Victoria Rogers?
yes. I just got married last week, so I haven't changed my name yet.
All right. I'm Judge Middleton. I'm here at the courthouse in Centerville. Thank you for being here on a timely manner. Your manager, Ms. Cousineau, is here, and we have two lawyers here from the Cox Law Firm, Carrie Zanin and Alex Lubianski. Your landlord wants you to move. They have filed a termination of tenancy alleging that your utilities are not properly in your name and that there's some health and sanitation issues with your unit. So you are a defendant in a termination of tenancy action. As such, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you, and they're usually here with us, but they're not here today. I did send you the contact information for them. You have a right to have the matter heard here in St. Joseph County where the property is. You have a right to have the matter tried by a judge or by a jury. If you do wish to have a jury trial, you have to tell me today and be prepared to pay the $50 filing fee or file a written jury demand within 5 days and pay the filing fee unless you're unable to pay the fee and the court grants you a waiver of the filing fee.
Okay.
As I indicated, they are asking you to move, so this does not have to do with payment of the rent. So there's no emergency housing assistance that is at issue here. If you and the landlord both are willing to go to mediation, I can refer the matter to the Citizens Mediation Authority for an attempted mediated settlement. Finally, if you're able to reach an agreement of some sort of settlement, that means the case would be dismissed. We would file a conditional order of dismissal and the court would provide you with it or tell you where to find it. Who's going to speak for this case?
I was prepared, Your Honor, but I didn't know Carrie would be
Well,
here.
what happened last time is Ms. Zanin was caught in another court and got some emergency backup. So I will go with you, Mr. Lubianski. But first, let's ask Ms. Johnson, what's your position? Do you wish to move or do you wish to stay there?
I would very greatly stay here. Because of the fact that I have 4 kids. I just diagnosed with cancer over the last 6 months. And so like this living here is kind of my only option right now.
Or you also mentioned that you got married.
Yes.
Ms. Kuzino, has her husband been added to the lease?
No,
No,
only supposed to be
no.
kids.
I actually was, after the Zoom meeting, if I was able to stay, was gonna go onto the office and do it, but it just happened on Friday.
Okay. Mr. Lubianski, what's your position?
We're just seeking possession, Your Honor. And we're looking for the statutory 10 days. We believe all of the clause within the complaint is valid, Your Honor.
Ms. Kuzino, have the utilities been placed in their name yet, or they're still in the complex's name?
The utilities, I believe, have been placed in her name. I haven't been receiving any more bills for that. However, the other issues are still standing.
In the addendum, Ms. Johnson, they contend that your apartment is essentially filthy and as a health hazard to the other tenants, and they want you to move as a result of that. The law requires that I adjourn this matter at least 7 days for you to perhaps get assistance from legal aid or other counsel. But if they get what they ask for, if I adjourn this matter 7 days, that would take us to May 13th. If they get what they ask for, you would have until May 23rd to move out, or you'd be subject to being evicted. Now, the notice to quit was filed some time ago. I don't know what the current status of the premises is. Apparently, the utility issue has been resolved, but I don't know what the sanitation issue is. Also, you've got a new spouse who's not on the lease, but I'll give you some credit. He just got married on Friday and now it's Monday. Doctor's appointment. Can we adjourn this to Monday, May 13th at 1:35?
That's fine, yes.
Yes, Your Honor.
I also said yes. I don't know if you heard or not. My phone's kind of blotchy.
Yes. Well, I can hear you and see you, but the phone angle isn't very good. There, I can see you.
Sorry.
I don't know, but they're talking about bed bugs and gnats and other things, and I'm not going to ask you to show me your apartment, but one of the contentions is because of the cleanliness of the apartment, it's a danger to the other tenants, which is a reason under the lease as just cause for termination. I would suggest that you contact the number at legal aid that I gave you with the packet that was sent with you. Usually legal aid is here, but let me repeat, if they get what they ask for, you would have to move by May 23rd, or the sheriff would come put all your stuff out, you and your kids and your new husband. So there's a lot at stake here. So
Yes,
we're
sir.
going to take another look at this next Monday at 1:35. Do you
Yes,
have any
sir.
questions?
No, sir, I do not.
All right, my advice would be you contact legal aid or other counsel, but I don't know what the status of the apartment is. All right. You're good to go. I'll see you next week.
Okay, thank you, Your Honor.
Thank you, Your Honor.
There are 2 files here regarding Alexander Riley O'Neill Foster. File 232388 is an incident that occurred on December 30th, and he was driving without a valid operator's license. I think he's actually suspended, but that was reduced to allowing another to violate the motor vehicle code. His license was expired and otherwise. So that was in December of 23. In February of 24, He still didn't have his license, but he got arrested for operating while intoxicated in Sturgis, and that was written under Sturgis ordinance, and that was reduced to impaired driving. So both matters are set for sentencing today. One is under state statute, one is under ordinance. Daniel Frazine prepared the screening report. I set this at an unusual time of Monday at 4 because the defendant was working someplace. I forgot, where were you working?
Morgan also.
That's right. Are you still there?
No, sir, I'm full-time, well, my business,
Oh, so, all right. Well, I guess I could have done it at a different time, but what's your business?
Smoking Ain't Easy Barbecue.
I knew you were trying to start a barbecue business, but, all right. I had some questions here, which is why I wanted Daniel here, and here he comes now. This was a bad set of facts. The defendant was very intoxicated in the intersection of US 12 and Centerville Road, which would be the main 4 of Sturgis, and passed out behind the wheel. He had smoked some marijuana. He had an open whiskey bottle in the car. He had no valid operator's license. He had unpaid fines and costs for other operators' license. And he was fortunate the officer didn't tow his car. It looked like they parked it at Tuffy's. The police report says you were transported to the county jail and lodged. Daniel's report says you were turned over to your girlfriend and she took you home. I called the jail and they don't show any record of you being lodged on February 16th. So you got what appears to be a couple of huge breaks. They didn't tow your car and they let you go home, which never happens. So did you go to jail that night or they let you go home with your girlfriend?
Whatever they got at the county, at the station, whatever room they, I don't know.
Well, they took you to Sturgis and gave you the breath test, correct?
And then I went into, I don't know, holding tank.
And then they let you go home with your girlfriend?
Correct.
All right, well, the police report's incorrect. It says you were transported to the county jail and lodged, so you didn't. Also, I did find in the police report, they requested $120 worth of restitution. So Ross, what would you like me to know?
Your Honor's correct that it was bad facts. To be passed out at the wheel is not something that Mr. Foster's proud of. And I do know, and it's included in Mr. Frazine's report, that he's thankful that no one was injured. This could have been a nightmare had it happened 1,000 yards prior to where it did. I will note the PBT results were well above the legal limit. They weren't in the category that a lot of the ones you see through this courtroom are. He wasn't 0.19, 0.23, whatever. He was.
Well, if you smoke a little marijuana before you drink too, it makes you sleepy. And he fell asleep. But yeah, his BAC wasn't off the chart.
And I think what's notable is that Mr. Foster is working on making his life better and putting it more in his control, starting a business that he's now full-time involved in, and that he's solely responsible for. He can't. I know that when you're in business for yourself, there aren't days off, and he's taking ownership of that, taking ownership of his life, in a way. He's taken steps to secure a driver's license so he can have the legal transport. Obviously, this is a complicating factor with getting the full valid license, but he's taken his exam. He's got a paper one here. I think Mr. Frazine's accurate in his report and his recommendations. It would probably be beneficial, especially with the stress of going into business on his own and some of the, you can call it freedom that comes with that, to have support with sobriety and not slipping into things. I think he recognizes that drinking and driving while intoxicated in any fashion is not appropriate. You don't want
to injure someone. So I would just ask the court to institute the recommendations as given by the probation agent, who's had the time to interview and create the recommendations.
Okay. We got back on track in file 20-40 ST. He got charged with driving suspended and was reduced to no ops. He made some payments and then stopped paying in 21. And when this happened, he got back on track and he's made some payments on that, but he hadn't made a payment in 3 years. He had another one, a DV case where he owes some money, and same thing, he's back on track with that. I was distressed that he got this no license ticket on December 30th, and he didn't go get another license, and he didn't have a license when he got arrested 40 days later for this case. Anyway, so you do have a license now?
Yes, sir.
Can I see it?
Oh,
He's still with a paper license because of this pending case.
Does have a temporary instructional permit dated 3/25. So he got a TIP. So you got a break that this no ops doesn't show up. It's going to be allowing another to violate the motor vehicle code. That's 232388. And I'm going to fine you $75. $75 crime victims rights fee, $50 state minimum fee, for a total of $200 as part of your plain payment plan. So you did finally. This thing hadn't hit yet. So that's a positive. 5, 6. Two, 3, 1. 2, 9, 1. All right, Mr. Foster, what would you like me to know?
I mean, I'm changing my life, working hard.
Tell me about this business, because you had a good job at Morgan Olson. That's got great benefits, good insurance. And I didn't want you to miss work, so I set it for now. And then so when I saw you last and now you quit and decided to go full-time in your barbecue business?
Well, I didn't quit. I put my notice in because I didn't want to leave a job like that, quitting.
Well, I didn't,
I'd
maybe
rather be
quitting
safe
is,
than quit.
but you resigned in good standing.
Correct.
Okay.
So,
And then tell me about your barbecue business.
me and my partner, Brian Green, we kind of started it last year, but this year is like the kind of first year we're starting off, and we got quite a bit bookings coming up. We got some horse shows we're doing. Our main setup is in front of the GOAT in Myers. So we've been doing pretty good with
In
that.
front of which Myers?
3 Rivers.
The Myers let you set up there?
In front of the GOAT.
The strip mall in front of Meyer.
Okay, all right. And So you have your own trailer?
Yes,
Where to get your meat?
from Lowry's. We got a couple of meat markets we go to, but Lowry's is the main one. in
Where's
Buchanan.
Lowry's?
In Buchanan.
Okay. All right, do you have drinks and stuff too?
With
Like,
water.
yeah, soft
Yes,
drinks or
yes.
that sort of thing. All right, well. Okay, Daniel, the guidelines call for 7 to 9 days, and your recommendation is no
Well,
jail.
I didn't know how to score this because technically they did detain him there for a while. They said, and I had to call and follow up on this report. I called Sturgis and they said they did hold him there for a while until somebody came and got him. So technically they would have went to our jail and process, like the police report said, he would have been given a day's credit. So I was kind of thinking 1 and 1. There's no alcohol charges on here. The only possible one would be the drug one, but that was knowledge. So in light of everything and from talking to him, I just felt that doing some community work service and having him on probation for 12 months would be probably do a little bit more than a couple more days in jail.
Well, I do think we need a probation. I'm gonna do 12 months probation. I want you to attend the victim impact panel. Drug and alcohol testing as directed. No drugs and no alcohol, including marijuana. Marijuana is legal for people to use, but you combine marijuana with alcohol the night this happened, and the facts were bad. I'm gonna order 3 days jail, credit 0, leaving 3 days to serve, but of the 3 days, 2 are deferred. You're gonna do a night in jail like everybody other drunk driver. And it'll be scheduled by the probation department. There was $120 police reimbursement hidden in the report on a handwritten form. I'm gonna take out the community service, Daniel, in light of the fact that I gave him a day in jail. Okay.
The $300 fine, $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee, $150 attorney fee. This is expensive. I had one of these this morning, $480 probation oversight fee. Now, let me say this, you can all right. The discharge at the end of 6 months. Maybe this will be the thing. You'll end up being successful at this. You'll own 10 barbecue trucks. You'll be a multimillionaire and live happily ever after. But this was a youthful indiscretion with some bad. I've had several of these. Someone today was passed out in the middle of 131 and US 12. I have another guy who was passed out in the intersection of Broadway and 131. And this is the main 4 in Sturgis. And I had another gentleman who was passed out at US 12 and the road that goes back to the high school, all in the middle of the heavy traffic roadway, which shows pretty significant intoxication at our time waking you up. Let's add this up. 300 plus 75 plus 50 plus 100 plus 150 plus 480 plus 120 plus 32 for the victim impact panel. It's 1,307. That's what I came up with this morning. Exact same case. Payment due, probation.
don't think I have any bond. And fortunately, the Sturgis Police Department didn't tow your car. That would have been another bunch of money. And Anthony, I think what will happen is now that you have a temporary permit, this will cause your license to be restricted, or Alexander. You'll be restricted, which means if you need to drive your trailer from one job site to the next job site, you should be able to do that. Or if you're going to buy meat for your business, the restriction should allow you to do that. So keep track of that with you.
What about also transporting my daughter? Cause she in AAU basketball.
That doesn't count.
Okay.
If you're in sobriety court, you can get some special provision, but it allows you to drive to and from in the course of employment, treatment, court. Doesn't allow you to take your kids to school or basketball games or movies or camping. It's just limited to certain purposes. If you're in sobriety court, you can get a special order that allows you to take your kids to school and school functions. But this isn't a sobriety court case, and that takes a special order of the court. We're gonna get your numbers to 0. There might be marijuana in there now. We're gonna get it to 0. I have high hopes for this. You've completed several probations successfully. From when you were a kid. Daniel refers, several of the cases got deferred. I think 3 of them, meaning you did a successful probation 3 separate times. So I don't have a reason why I don't think you should be able to do this. When's your next gig?
It will be, I gotta talk to my partner today, so it'll probably be sometime this week, probably Wednesday, the rest of this week.
Where at?
In front of the goat.
Because I want to come in and I'm gonna order some.
You can do that. I got a card for you too.
A what?
A business card.
All right, we have one.
Judge's orders at your barbecue stand are a lot more pleasant than judge's orders from the bench.
I said something about barbecue, and my old friend Angela Brown brought me some barbecue right in here. Yeah, there's Steve Green.
That's Brian.
Oh, Brian Green.
Yeah. That's all right.
Welcome, DG and Foster. All right. I'll be coming to visit you. You're good to go.
You also got a Facebook page too, so.
I'm not on Facebook, but, all right.
Thank you, Your Honor.
Okay.
Thank you.
All right, so you don't have to do a day. You want to schedule it with them?
Okay.
So you-
All right.
All right, Daniel, I'll give you the file. You can have it. And yeah, you got to schedule that day in jail, which could be any day of the week. All right, I hope you make it. Cash app, debit card. All right, Ross, thanks for coming in at 4 o'clock. This wasn't convenient for you either, but turns out we didn't have to do it this way, but
Every day in the USA, people find themselves in court.
All right, Mr. Saldana, you're here for a plea deadline date. So did you have a chance to internalize what I was telling you?
Yes, ma'am.
All right, so Do you wish to have a jury trial?
Yes, ma'am.
All right, Ms. Ferguson, state, are you all going to be proceeding on the possession 1 to 4 or the injury to child?
The injury.
All right, so how long is this trial? How long will this trial take? All right, so Ms. Ferguson, if we could set this for a jury trial first thing.
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Saldana.
Mhm.
Your Honor, I have some time this afternoon. Would it be possible for Mr. Saldana to, and I to confer just a little bit longer?
Sure.
We'll get the jury trial date, but just to make sure that we are all on the same page as it were.
Okay, sure, most definitely.
I appreciate it, Judge. Thank you.
All right.
Your Honor, can I speak on the record?
What do you want to say?
I would like to object to the indictment and the evidence they're using for the indictment. And I'm also reserving all my rights.
Mr. Saldana, why are we talking?
All right, so let me explain something to you, Mr. Saldana. I understand what you're saying. I'm internalizing what you're saying,
Yes, ma'am.
but this is what I'm going to say, and I want you to internalize what I'm saying.
Yes, ma'am.
If you need open heart surgery, are you following me with this scenario?
Yes, ma'am.
And the doctor tells you, hey, you need open heart surgery, and I'm going to do the open heart surgery. Do you go to the library, read a book, and tell the doctor, hey, I know you're doing open heart surgery on me, and this is the scalpel you should be using, and this is the stitch you should be using, and this is the way you should perform that surgery?
No, ma'am.
See, and people think that attorneys just talk, oh, I can do that. All they're doing is talking, but behind their talking comes a lot of knowledge and a lot of experience. And everybody thinks that they can do that. So for example, with regards to an objection to the indictment or objection to the evidence used for the indictment, that's something that your attorney will be taking care of if legally there's a reason for it to be. If he determines that legally there's no grounds for it, then he's not going to go forward with it. That's the way it works. So your attorney wants to have a chance to talk with you. I'll let you speak with him in the box. And what date, Ms. Ferguson? All right. Your jury trial is going to be July 2nd. If you want to do something with this case, you can do something with it today, or either what's going to happen is you're going to be set for jury trial on July 2nd.
Yes, ma'am.
And I'm sorry, Your Honor, just for advanced information, I have a conflict on the 3rd. I'm a prosecutor for a local municipality. And we
Okay.
have court on the 3rd.
Oh, we'll work around it.
Thank you, Judge.
You're welcome. All right, so just have a seat in the box, but your jury trial date is going to be July 2nd.
Yes, ma'am.
Mr. Harris.
Coach Sean,
Yes.
and while my intuition, my spider sense is tingling, could I approach on a different matter?
Sure. All right, court is calling 2024 CR 2324, State of Texas versus Valentin Saldana. Could I have parties announced for the record for the state?
Marjorie Hillman for the state.
Defense?
Your Honor, good afternoon. Frankie Sandoval on behalf of Mr. Saldana.
Are you Mr. Saldana? Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Saldana, did you review the document entitled True Bill of Indictment with your attorney, and did you understand it? All right, you need to speak up. All right, counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the enhancement paragraph and we're proceeding on the underlying offense.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Ma'am.
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? All right, you're moving very slow with your answers. Do I need to speak up for you?
I think everybody can hear me pretty clearly. Yes, ma'am.
All right. I'm sorry, what?
Yes, ma'am.
Are you understanding everything?
Yes, ma'am.
All right. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Saldana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
No, ma'am.
All right, do you want to go to a jury trial?
If I'm not satisfied with the way I'm being represented, no, ma'am, I don't want to go to trial.
All right. All right, so this is your attorney. This is what I know. We can go off the record. Here's the thing. An attorney will tell you, this is what the state is offering you. You can either accept it or reject it. This is a case that the state has made the decision to waive the habitual. If we were proceeding of the habitual, you know what your minimum is?
Ma'am,
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual.
I'm like, yes, ma'am, I'm like,
What does that mean?
all right.
All right, we're back on the record. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a US citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There are no applications. The state is taking in consideration County Court Cause number 722-472, 2024 CR 3082. There's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
No.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, the state offers state's exhibit number 1 and all attachments.
Any objection?
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
In the interest of justice, that would be our request, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Saldana presents himself before you, accepting responsibility for the matter before you. As the court may be aware in reviewing his record.
Excuse me, just 1 second. Mr. Cox, if y'all can move down to the other end, we're on the record. That's okay. All right, we're back on the record. Yes.
Thank you, Your Honor. As the court is aware, Mr. Saldana is currently on parole on a previous case. He would respectfully request, and I make this request on his behalf, that although we understand and he understands not binding, we would ask that the sentence that will be imposed today by this honorable court run concurrently with whatever actions parole takes on his former case.
All right, and what are the parole case numbers?
Your Honor, Mr. Saldana. If I may have a moment, Your Honor.
Sure.
Thank you. The burglary of habitation, Your Honor, case out of the 226 District Court, case number 2014 CR 10282B as in boy.
Mhm.
Yes, Your Honor, that's the open parole matter that, again, Mr. Saldana is aware it's not binding, but he would respectfully request this court make a notation that it's the court's desire that it run concurrent.
All right, this court is going to do, as previously stated, the court is finding you guilty. The court will sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. This will run concurrent with 2014 CR 10282B. Take in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence. There's to be no contact with Mallory, Malerie Saldana, Jaden Saldana, Jayden, and Irene Portelis. Is there anything else with regards to sentencing from either side?
Nothing from the state, Your Honor.
Not on behalf of Mr. Saldana, Your Honor, we appreciate the courtesy extended by the court and the state in allowing us to address this matter this afternoon.
All right, and then did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Those documents go to the defense attorney. All right, we can go off the record. Your minimum is 25 years in the prison. You understand? Your attorney was able to get you less than the 25 years. Do you understand? And I don't know what you don't understand. It appears that prison is not teaching you what it should be teaching you. But if you come back out and you commit another offense or alleged to have committed another offense, potentially based upon whatever offense that may be, you're looking at a minimum of 25 years. Do you understand? All right, come over. Don't do this nonsense where, oh, I'm not coming over today because you're not in charge of the court schedule. Do you understand? So I don't want to get another report from the jail or from the deputy saying, she says she's not coming over and she's being violent. Do you understand? So the next time that happens, it's not gonna be good. You understand?
Yes.
All right. Ms. Ferguson, what date are we bringing this back? All right, so we're gonna recall this for tomorrow for a contested hearing. You understand? You have any questions?
I'd like to see about a property release on a case that was disposed out of your court. It is no longer pending in your court, so we'd like to get his phone back. There's no legal reason why he could not.
All right, state. There's a request on Owens for the return of his phone.
I have no dog in this fight, Judge.
Okay.
He has,
But sometimes there's a dog that's wandering down the street.
he has paid his fine and served his time. So he doesn't have to post an appeal bond. He doesn't have to do anything. It's just an appeal on an issue. Mhm. His fine is paid in full. So it is simply an. Yeah, they have it. It's in the property. He's able to file an appeal, right? Yep.
All those rounds be opposed to the judge.
All right, so he's filed a notice of appeal.
But he's paid his fine in full and he served his sentence, so it's simply a First Amendment issue. The case cannot, I mean, even if he appeals and wins his appeal, the case cannot be retried. So it's just an it's just a issue of First Amendment, it's not.
So is he appealing, I mean, what grounds is he appealing on?
He's appealing the issue of whether or not some language in the jury charge would have been free speech. It's a free speech issue. He's already paid his fine in full and served his time. So he doesn't require an appeal bond. So
I'd like to talk to somebody who feels about it, Judge.
Okay,
I've already done that, but anyway.
you can leave it here and I'll call you, Charles.
Well, I'll hold on to, so y'all are objecting to giving this phone back?
I just want
I just want to know, is that
Yes.
your office's position, so I can let somebody know?
Yeah, I just wanted, I didn't.
He wants to contact the appellate section and I'll let him do that.
This is gonna be this is about to open up. Okay,
No, he's just gonna call this.
I
appellate
understand, but
section.
I just want to make sure, because this is gonna open up a huge kerfuffle, because y'all have absolutely no right to not give him his property back.
Everything's kerfuffle with this guy.
But it didn't have to be, because you have no rights.
Okay, all right,
don't
but,
have-
but
Judge,
here's the
They
thing.
don't have any right to keep
Here's-
his phone.
Here's the thing.
They
What
have,
and here's the thing, I know what you're saying.
but Judge,
Let me
they have
ask-
no right to
but
have
let
any
me-
say in this.
Let me ask you this.
They have no
Let me
right
ask
to
you
have any
this.
say in this.
Let me ask you this. What does it hurt for him to call the appellate section and for the appellate section and say, we don't care, give him his phone? we
As
have
of
no
right
objection"?
now, there's no notice of appeal filed,
Yeah.
so let me have it back.
Yeah.
There's no notice of appeal filed, just, they don't have any say in this.
Yeah. Okay, so here's the thing. People are telling me you're appealing it or you're not. This will take 5 minutes. Can we do that for 5 minutes? Is there?
Judge, I did everything to help this guy. They don't have any say in this. But they've given his damn phone back.
Let them call. They want to call. I'm gonna let them call. We'll take it up today.
Unless we just file it the second. Check and see if time's been paid, the sentence is completed.
I think we started it last time we were here,
Mhm.
and I think we said rest it, and I don't know whether they were gonna. do anything.
Oh. So do y'all have the exhibits with the exhibits are with the other court reporter, correct?
Yes, ma'am.
Okay. All righty. So the court found violation of condition number 1 true. All right, is that correct?
Yes, ma'am.
I
My
see.
recollection.
Mhm. All right, we're gonna go on the record in 2022 CR Just one moment before we do that. Counsel, do you have a trial court certification of defendant's rights to appeal? You may have turned it in last time, but it's not in the file. So if you could do that for me.
No, no. Yes, sir.
All right, we're on the record. And 2022 CR 0423, State of Texas versus Joseph Balboa. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Cornelius Cox for the defendant.
And are you Mr. Balboa?
Yes, ma'am.
All right, the court did have a chance to review the exhibits that were entered in the contested hearing from April 30th. The defendant had pled not true to violation of condition number 1. Evidence was presented as it relates to violation of condition number 1. And that was states exhibits 1, 2, 3, 4, 5. And the court found violation of condition number 1 true. And we're now here for sentencing. State, what are you requesting?
Your Honor, we're asking for 15 years in the prison, based on, the underlying is a second-degree felony, Your Honor. It's a drug case. But I know you've seen the court summary. The defendant had opportunities on probation, and he got something for it in exchange for his plea, right? So in exchange for pleading to deferred, he's looking at the full range here. But he didn't take advantage of that opportunity while he's on deferred, Your Honor. He wasn't reporting. Didn't do a whole lot when he was on that community supervision, Your Honor. And then he did assault that officer. I know you heard the testimony, and you saw the video, and you saw the pictures. So that's why we're asking for 15 years, Your Honor.
All right. Defense?
No, if I may, I know the court saw the video. In testimony, I know the court found true, but even the officer, as he testified, indicated that my client was always moving away from him. There was some suggestion that my client would say maybe the aggressor. Now, there may have been some type of resisting, but in terms of actually assaulting the officer, I don't think that was clear on the video. I don't even think by preponderance of the evidence. Both parties, my client was injured. He went to the hospital. I think the officers got some pictures too at the hospital.
All right, I did see on the video, your client punched the officer, and it was his first day on the job, I think. The witness who testified, yes, he was brand new.
And I don't think, I didn't see it that way. I saw there was some movement, but in terms of a punch, though my client's name is Balboa, I can see that, but the punching part, think it was more backing up, trying to create distance between him and the officer. And I think on the video, it was indicated that my client was basically just trying to close his house down, and he was gonna leave peacefully, but it never came to that. So he got, he got hurt too. I mean, some things were done. I just feel that, Judge, on this type of situation, I think 15 years, like the state is asking for, based on the underlying.
If he's revoked, what would you be asking for?
If he was revoked, my first preference would be to continue him on. And basically she just wants work, he wants to provide for his family. And he would absolutely love another opportunity to improve himself. But I think if the court just gonna revoke him and give him a felony record, my suggestion would be 2 years.
All right. So here's the thing, Mr. Balboa. You entered a plea bargain agreement. And that plea bargain agreement was for punishments to be assessed at 6 years. The state was silent on your application for deferred adjudication, but they were recommending community supervision. And I'm sure I probably told you, if I grant your application for deferred adjudication, you're subject to the full range of punishment. All right. And so do you remember my saying that to you?
Yes, sir.
All right.
And may I say something?
Well, here's the thing. Do you want to be subject to cross-examination? Oh, that means that the state would have a chance to question you. All right. So probation, has he done anything on probation?
I was doing the parenting class. I missed one day and I had to restart it. Just a parenting class.
Could you please speak up? I can barely hear you.
I'm sorry. Yes. All right. She states he's done his TAP evaluation.
Last reported in March of 2023. So I don't have anything that's current as that.
All right. Thank you.
Well, I was with the classes, but I missed one.
All right. So here's the thing. If you all whisper and have a conversation, the court reporter is trying to pick it up and put it in the record. So
I would just like to urge that sometimes probation records, sometimes not as complete. Client indicates that he has taught the parenting class, but then when they miss a class, they make them solve it.
all right. The court is going to find you guilty. Court is going to grant the motion, revoke you. The court is going to sentence you to 7 years. I'm going to give you credit for any time served. And I'll ask for the therapeutic community. Is there anything else? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, so you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I think you know deep down in your heart, I gave you a chance to be on deferred adjudication. And all you had to do was report, do some classes. And if I ordered parenting classes, it's because you had a child. You saw yourself on the video, right? I mean, you saw yourself on the officer's body cam.
That's fine, but I have film on my own as well, but I'm not gonna.
I'm sorry, what?
Nothing, it's irrelevant.
All right, because they were coming to serve a warrant because you have a warrant out this court.
So you said they were there for a welfare check, so.
Yeah, I mean, a welfare check plus, guess what? When they went to go do a welfare check, according to the officer's testimony, they found out that you had a warrant, and that warrant was not reporting for your probation in this case. You understand? So guess what? If you would have been reported in probation, they probably would have never had to do a welfare check. You know why? Because if you would have had an issue with mental health or anything else, you could have told probation, probation would have taken care of it. But at the very least, they would have just been there potentially for a welfare check. But now it spirals to this, you understand? All right, what's happening with this other case?
I'd like to talk to Mr. Cox about it, Judge.
All right, just have a seat in the box. Yeah, I do.
The other case is Aaron's Sales and Lease versus Nathan Walden and Natalie Thayer. Aaron's Sales and Lease and Nathan and Natalie have been attempting to get their sound connected. Mr. Walden, can you hear me? Mr. Walden, can you hear me? Boy. Rogelio, can you hear me?
Yes, sir.
They logged in early at like 2:45, but they were struggling trying to get their sound connected. Mr. Walden, if you can hear me, raise your hand, please. The problem is at their end, they seem to be oblivious to what we're doing here. Ms. Thayer, can you hear me?
We're sorry, your call cannot be completed.
Mr. John Cock, bear with me here. We're trying to deal with these folks.
No problem.
Let's try again.
Okay, so when TJ comes.
We're sorry, your call cannot be completed at this time. Please hang up and try your call again later. Thank you.
Well, we'll leave them where they are.
Hey, if you can read them, tell them what's going on. You don't know what you can read.
Just start looking at it as opposed to staring off in oblivion. Mr. Walden, can you hear me?
Yes, I can.
All right, that was quite a long way to get there. Stay right where you are. We had a hard time connecting to the sound. I'm gonna do our other case first rather than make him wait through this anymore, but. This is Aaron's Sales and Lease versus Nathan Walden and Natalie Thayer. After quite some time, we were able to get their sound connected. Are you Nathan Walden?
Yes, I am.
Are you Natalie Thayer?
Yes, I am.
And Rogelio Segundo is the manager at Aaron's Sales and Lease, or at least the collections manager. Will everyone please raise your right hand? You all swear or affirm any testimony that you're about to give here will be true to the best of your knowledge and belief.
Yes, sir.
Yeah.
All right, let me make a note here. This is a claim for $5,753 plus costs, which is $5,904.24. We are in small claims court, and the rules are different in small claims court. They're more relaxed. There's no formal record being made of any small claims proceeding. Neither party is allowed to have an attorney in small claims court. There is no appeal from small claims court. Any decision rendered here is final. Either party has the right to remove the matter from small claims division to the general division of the court. You have to tell me before we start. Once we begin, any decision here is final. Mr. Segundo, you agree with those terms?
Yes, sir.
Ms. Thayer, Mr. Walden, you also agree?
Yes, I do.
All right. The complaint alleges that there was a contract between the two of you and Aaron's refusing to make payments. Said items on the lease were stolen and asked to bring in a report, which they never did. And the items, I wasn't clear under this new contract what was what. Some DeWalt tools.
It was
Yeah,
a
go ahead.
PS5, a tool set, a washer and dryer, and a 75-inch TV. I have the complaint number here for the officer that came out when my house got broken into.
Okay. Do you have homeowners insurance or renter insurance?
Just got 'em.
What?
I just got homeowners insurance last week.
But you didn't have it at the time of the theft?
No. I even had my teardrop camper stolen.
Well, this is on you, not on them.
I know.
And when was the break-in?
It was in January.
Who's the officer in charge of the case?
Zach Raddick. I think I'm pronouncing his last name right.
Radke.
Radke, is that how it's pronounced?
So someone broke into they stole your washer and dryer and your TV, and they stole everything out of your house?
My tools and my PlayStation.
All right, what about the washer and dryer and TV and that sort of thing?
Yeah, I still have that. And if he wouldn't have called me, you know, I know it's childish, but he was kind of being rude to me. I'll agree to pay because I know I owe it, but right now and I can only afford like $50 a month. And my wife ain't even on any of these. She's not even my wife, she's my girlfriend, but she's not even on any of these leases.
She did sign for
is.
some of them.
Her signature is, but her name ain't on none of the leases.
She does.
Natalie Thayer.
She's
Yeah,
the secretary on the accounts. And
yes,
she did
she
sign for
is.
the others.
All right, I find for the plaintiff. So the tools and the PS got stolen. Those are things that are easy to steal. The washer and dryer and the TV are still there. You just quit paying for them. Well, it's a great deal. You get a rent to own, you stop paying, you keep the stuff, and you lower your payment to $50 a month for the next 25 years. That doesn't work very well for them. She is a signature on the lease for the items. So why did you refuse to return the other items? Because you got mad at him?
Yeah. No excuse.
If I may, I also offered to lower the price on the items that were stolen as long as, because he was paying well up until that point. We offered to retype it, and that's something that we can still do.
Well, I find for the plaintiff in the amount of $5,753.10. Filing fee is $97. The service fee is $54.14. I find it for against both defendants jointly and severally in the amount of $5,904. What I would suggest you do is you go up to the store. Right now, this gives them the authority to collect. They can seize property. They can garnish your wages, seize your income tax refund or other things to attempt to collect on this. But he indicated they were willing to rewrite it. But the fact that you just got mad and quit paying, you've got their washer and dryer and their TV set. The small stealable things allegedly were stolen, but you're still liable for them.
Yeah, they also lied to me. They said I had insurance that covered all of that too, but it doesn't.
No, we offered you the insurance, but you never took it. It does cover theft, but you never signed up for it.
Sir, well, please don't.
Okay, and then, well, really,
stop.
Thank you, Judge.
This just makes it worse. All right, but you got some stuff stolen. You didn't pay for the theft insurance. You both signed the lease. You stopped paying on the big expensive items, and they'd go broke if every contract resulted like this. So my suggestion is you go up to the store and talk with them, see about either returning some of those items or rewriting the contract. Otherwise, they can pursue collection. This judgment is good for 6 years. So thank you. Do you have any questions?
No, thank you, sir.
All right. All right, Rogelio, same thing. If they don't pay, you can pursue a discovery subpoena, but we'll see. All right, I'll send you a copy of that judgment. All right. I got mad, so I quit paying.
Every day in the USA, people find themselves in court.
Good morning, sir. Are you Bradley McKenzie?
Yes, sir.
We've met. I'm Judge Middleton. Your lawyer, Mr. John Bush, is here with me. This is file 23614FY, People versus Bradley James McKenzie. Mr. McKenzie was charged with these matters, and then he went off the grid for a while, and we just caught up with him. It's alleged that on or about December 10th of 2022, you did possess methamphetamine, possessed a controlled substance, analogs, and operated while intoxicated. The methamphetamine charge is a felony as a habitual, so it carries a potentially very large sentence. I'm sorry, Mr. McKenzie, my data management system is all mixed up and you're not even in the system. No, there you are. This all allegedly occurred, as I said, on December 10th. You're charged with possession of meth and these other controlled substances as a second offender, as a habitual third offender, making those potentially punishable by up to life in prison. So the prosecutor Marvin has offered all misdemeanors, offered to dismiss all felonies, for a plea to use of methamphetamine, use of a controlled substance, fentanyl. Those are both misdemeanors, punishable by up to a year in jail and a fine of up to $1,000. And operating while intoxicated. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and would require that your license be suspended. There was also a charge of ecstasy or MDMA, which is going to be dismissed. And more recently, you found people that are mixing methamphetamine, which is a stimulant, with opioids like fentanyl, and that's a recipe for disaster. But at any rate, all of these charges and the habitual will be dismissed if you plead to those misdemeanor charges. Do you understand?
Yes,
And are you going to plead to those charges?
I will.
All right. Now, I told everybody here what their rights are, and I've done this with you before, but let's talk about it here. If you plead to these charges, Mr. McKenzie, you'll be giving up your right to have a trial in front of a judge or jury. If you had a trial, you'd have the right to be represented by an attorney. Mr. Bush is here with you, and he's aware of this and has discussed it with Mr. Marvin. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to take the witness stand and testify on your own behalf, because you have an absolute right to testify, but you also have an absolute right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
All right. Well, let's talk about this.
Yeah, this may have to be no contest. That from dealing with him, he does not have 100% recall of what happened, but perhaps you can,
All
as
right.
far as you can, factual
Do
basis.
you remember this time back in December of 22 when you got pulled over by the cops?
I did not, sir. I overdosed pretty good. I was lucky.
Yeah, and you and I talked about that. All right, well, let's talk about, we were just talking about some of these cases. I had a guy yesterday who was passed out at the intersection of US 131 and US 12 in the middle of the road at the main four in White Pigeon. I had a guy earlier this week who was passed out at Centerville Road and US 12 in Sturgis, a very dangerous intersection. You have the distinction of being passed out in the middle of Broadway and South Main, which I guess could be worse. According to Trooper no, this was Justin Holbrook of Three Rivers PD. He's a good young officer, assisted by the state police. They get dispatched to East Broadway and South Main, where and they were transporting somebody, and then they saw you in the middle of the intersection as an altered mental state and at times unresponsive. Observations of alcohol containers leading to open intox. They found you slumped over in your car. Your interior lights and dash lights are on and your alarm was blasting. Smelled like marijuana and there were beer bottles in the car, but you didn't have alcohol in your system. You were very disoriented and confused. They found 12 Coors Light bottles and you said, I don't drink Coors Light. Anyway, they took you to the hospital and you acknowledged that you took too much drugs. You used marijuana and heroin and methamphetamine. And your blood alcohol was 0.0, but you had those other items in your system, fentanyl, amphetamines, and they found some methamphetamine and a bindle with a small amount of fentanyl in it. So that is sufficient for operating while intoxicated, use of methamphetamine, and use of fentanyl. Now, then you told me you went to rehab and then you quit showing up. You were adamant that you weren't using, but you were like a cat on a griddle. When I talked to you that first day, you were very agitated,
Nervous.
which led me to believe that you were coming down off something. I asked you if you're going to detox from opioids and you said no, but I got a definite methamphetamine vibe. The next time I talked to you, you seemed much better. And today you seem much better. How are you doing?
I'm much better. I'm better than I was. I was very nervous the first day. I was just very nervous.
Well, all right, we're doing better now. Today
He's
is
currently on probation, Your Honor, to your court.
yes. John, are you available at 11 o'clock on May 20th? Oops. This is strong. You're here that morning anyway. Neri Felipe Mazarigos. So I'll set it for Monday, June 20th at 11. Makes the morning crowded, but all right, I will see you at that time. I'm going to leave your bond where it is. You need some clean time. And we'll be doing a lot better at that time. There's a substantial chance that you'll get out on that day, Mr. McKenzie. But so this set for screening and sentence on the OUIL. All right, I'll see you at that time, sir. You're good to go.
Thank you, Judge.
I like
Thank you,
talking
Judge.
to this version of you much better than the other one, so I'll see you on the 20th.
Thank you, sir.
Good morning, Miss Sweet. This is Judge Middleton. Your lawyer, John Bush, is here with me. I brought you in just so I could speak to you and tell you what's going on. This file is 24694FY. You're charged with delivery of methamphetamine. You've been gone for a while. I haven't seen you in a year or two. This charge is a felony punishable by up to 15 years in prison, 10 years in prison and $15,000, but you're charged as habitual. Audrey, you got a bunch of other problems. Apparently there's a federal hold on some sort of federal charges. You have Indiana charges for one or more jurisdictions. You have a parole hold, and there's a complicated search warrant. Who's your PO?
Bobby Joe Nolan.
What they decided to do, even if I was to give you a PR bond, you can't go anywhere. So they're gonna leave this set for a preliminary examination next Tuesday at 1 o'clock. In the meantime, your lawyer, Mr. Bush, and Mr. Marvin and his staff are gonna go over all this. My question is, how did we come to this? How did we get here? I met you when you were about 15 years old. And here we are with all this heavy weight hanging on you. Anyway, you probably also could use a little clean time, but I will see you next week, next Tuesday at 1 o'clock.
Mr. Middleton,
And,
I don't even know how I got into this mess, but I have been clean. I've been doing my drug screens for the feds and I've been doing my drug screens for Newland. But I mean,
All
you
right,
can tell.
well, we'll sort it all out. But I don't like seeing you like this. And you don't like being like this, but like I said, you and I go back a long ways. But I'll see you next Tuesday at 1 o'clock.
I did the paperwork on the search warrant and the affidavit were sent to my email. I will get those printed and get those to you then.
Okay, and can I please get another copy of the police report? Coffee got all over the one that you gave me. Some girl
Okay.
spilled, there was a spell in my cell and I don't have that police report no more.
All right,
Thank you, sir.
okay.
We can get you that.
This is file number 231852. People versus Candace Williamson Hawkins. She's from Decatur. Charged in a 2023 felony complaint with possession of methamphetamine. That is a felony. It's punishable by up to 10 years in prison and a fine of up to $15,000. Prosecutor Marvin has agreed to reduce that to a misdemeanor charge of use of methamphetamine. Use of methamphetamine is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $2,000. Do you understand? Mr. Marvin says you're not eligible for 7411 probation. You've been waiting patiently and you've heard me go through the advice of rights a couple of times. Do you understand you have those same rights?
Yes, sir.
Anybody threaten you to get you to plead to this charge?
No.
Or promise you anything?
No.
All right, you got pulled over at 131 in Millard at Rite Aid there. And they searched your car and they found some methamphetamine and some pipes. This is trace amounts. So So earlier that day, had you used some methamphetamine?
I think so, way earlier. Yeah.
How had you happened to be in Three Rivers that day?
Me and my friend come over to, we was gonna go to, Cavoni's and, or I don't know how you say it, Cavani's or whatever. We was gonna go and order something, we'll get something to eat, but it was packed, so we was just gonna go to Menards and call it in and come back and pick it up. But he.
Well, that's a
he lives
long way
over in-
from
well,
Decatur
actually,
to,
my kids went to Marcellus School, so I live like, just like right outside of, little outside of Marcellus, and it's like between Marcellus, Decatur, Dowagiac, Cass, so Livonia.
I just drove to Dowagiac, which I don't ever do, down Young's Prairie Road. But no one told me Young's Prairie Road was closed for construction. I ended out in the boondocks of Cass County on someplace called Briar Patch Road. It was so muddy, my car was filthy, and I got where I was going. I don't. Are you on probation or parole anywhere now?
No.
What do you do?
I'm a waitress,
Where do you work?
Mr. Wahoo's restaurant
Where?
in Dowagiac.
Okay.
She's been there 18 years, right?
Well, don't drive down Young's Prairie Road. You can't get here from there. I need to know more about this. There's no criminal history in here. You can't, methamphetamine is a slippery slide to the bottom of the pit. You can't dabble in it a little bit. You smoke it here and there. Pretty soon it just consumes you. So you have been able to maintain employment. I'm gonna set forth sentence. Need CCH and police report. These trace amounts of methamphetamine have become almost like marijuana cases when marijuana was unlawful. Although methamphetamine is so much more debilitating.
Her
Well,
prior
that's-
7411 was marijuana, 24.
Yeah, it was a long time ago. How about July 1?
At what time, you
10:30.
That's just fine.
All right, Michelle got me some notices, so I can. That's Monday. I believe we're on a home stretch here, John. All right, I will see you on July 1st. I'll get more information about this, about you, girl. Good morning. You're Brittany Nicole Tilbury.
Yes, sir.
Let me get your file up. You and I don't go back as far as poor Miss Audra Sweet, but I've known who you were for a while here. There it is. Allegation is that on or about April 19th, you were in possession of heroin and you did resist and obstruct police officers, 2 counts. You were quite disoriented out in the Constantine Township. Those are both felonies. The heroin charge is punishable by up to 4 years imprisonment. The other 2 charges are punishable by up to a year in jail. Prosecutor Marvin has agreed to dismiss all of the felony cases for a plea to use of a controlled substance, which is a 1-year misdemeanor, and attempted resisting obstructing. Attempted resisting obstructing is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. You understand?
Yes, sir.
All right. You heard me go through the rights a couple of times. You understand you have those same rights?
Yes, Your Honor.
And you're giving those up by entering this plea.
Yes, Your Honor.
Now, I wasn't sure you were going to be here today. I was told that you were at Bear River up in Boyne Falls.
Mhm.
Did you go there?
Yes.
But you're not there anymore?
No, I'm transferring to the Gaia house
Through Bear River or through another agency?
through another agency. It's through Jennifer, and I gave him my attorney her phone number.
And
She
where's
said
Gaia House?
Sorry, Manistee County in Brethren.
GII, Mother Earth. All right, the police got called because you were wandering around out there in the country, in purgatory with your daughter, and you were quite disoriented. Did you have some heroin in your possession? Do you recall this very well?
I recall somewhat. It was just a whole mess of things that happened that day. It was just all at once.
All right, well, that day, did you possess or use some heroin?
Yes, Your Honor.
Was it heroin, or was it some synthetic?
It was what came back in my blood test. Well, my mouth swab was xylazine and fentanyl.
All right. That's the new thing. Xylazine is a new way to mess up your brain, and fentanyl. Do you remember how you took it?
Nasal.
Okay. So then, because you were so disoriented, the cops were trying to corral you, and you were very disruptive with them. Do you remember that?
Yes,
All
Your
right.
Honor.
And you were kicking the door and that sort of thing. And they took you to jail and impounded your car. Whose car was it?
Mine.
All right. Well, I'm glad that you're in some treatment.
She
but-
also has an abuse and neglect case, and I'm her counsel in that, and I know,
All
so
right, yeah,
she's
there
going
was
to have a
your
lot
daughter there.
going on.
Where is your daughter's father?
Which daughter?
Oakley.
He was in Grand Rapids. He did a
But
year.
is he in the picture? Is he involved in her life at all?
Yes, but the last year he was in rehab in Grand Rapids, and he moved up there to get away from here. But he does talk to her over like FaceTime.
All right. What's his first name?
Thomas.
Okay, that's what I
Odell.
thought. Yes.
Yeah.
All right, your life is complicated. Now, the girl I just talked to, Miss Audra Sweet, is a little older than you are, and unless the heavens break and rainbows shine through, she's going to prison for a long time on a federal charge. And things got worse, and then they got worse, and then they got worse. And you mix heroin, methamphetamine, throw in a little xylazine, and That's a recipe for problems. So I'm glad that you're trying to address it. So I'm gonna set this out a little bit. In fact, are you on probation or parole anywhere else?
No, Your Honor.
How long is your program at Gaia House?
Anywhere from 3 to 6 to 6 to a year.
All right,
The
we're
3
not
to
gonna
6
wait.
are months now.
What?
The 3 to 6 are months now.
Yes. Well, you don't cure long-term addiction with a flyby, and so the more successful programs are the longer ones. But let's go out to July 1st. May it'll be warm then. July 1st at 10:30.
That's a good day, Your Honor.
How'd you get down here?
My mother picked me up yesterday.
Very good.
Mhm.
Laura, I'm out of notices. I got a funky one here. I'll just send you out to the counter and we'll get a proper notice.
Of course, we're gonna see each other.
I want you to sign a release for your lawyer
Okay.
from Gaia House. So we can see how you're doing. Now, there are bond conditions of your bond that remain. You're not to use or possess any controlled substances. You're not to drink any alcohol, smoke any marijuana, and comply otherwise with the terms of the law. So I'm hoping that when Irwin,
Yes, sir.
Mr. Irwin, you're charged with assault with a dangerous weapon and child abuse in the 3rd degree. The weapon is a board, and child abuse in the 3rd degree is a misdemeanor punishable by up to 2 years imprisonment. Mr. Marvin, the county prosecutor, has agreed to reduce this to a charge of domestic violence, 2nd offense. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. If I understand from the affidavit, this had to do with a disagreement with your 17-year-old son.
Yes, sir.
He actually was taken to the hospital for treatment after he got hit in the head. So are you going to plead to the misdemeanor charge of domestic violence, 2nd offense?
Yes, sir.
Anybody threaten you to get you to do that?
No, sir.
5, 7. I went through the advice of rights a couple of times. You understand you have those same rights?
Yes, sir.
You're giving those up by entering this plea?
Yes, sir.
All right, so you got involved in an argument with your son. Now you go by Clark?
My first name's Bruce, but that's my middle name.
So what do you go by?
Bruce.
Okay, I don't know why they put Clark. Anyway, so you end up striking your son with a board?
Yes, sir.
I don't make him in light of this. You're probably not the first father of a 17-year-old that didn't want to hit him in the head with a board, but that's not the answer to this question. He had to go to the hospital and get a CAT scan and some stitches. What was the argument about?
Well, he'd been putting his, Brock's been in trouble for putting his hands on my 8-year-old before. He's got a deal in Cass County over, he was supposed to stick till 18. But, all day we went to a friend's house, to pick up a shelf, and he just kept getting on Grayson, grabbing him by the arm, jerking him around. You know, when we get in the car after we loaded up the shelf, we head back to, from Vicksburg to White Pigeon, and the whole car ride turns into argument over his cell phone, and as much as I told him that he wasn't allowed to have a cell phone because his grades sucked and he was cutting school behind our back, that he still didn't take that as an answer he wanted to hear. So he began to be belligerent. He slammed the car door on his brother, went to the back, knocked his brother down, and then when I tried to get the trailer undone, he checked me a little bit like a hockey check and shoved me out of the way, and then I got pissed and I did what I shouldn't have did.
All right. Now, there's always a no contact provision. Are you out of your own house? Where is he?
He lives with my girlfriend. He's in the house that I live in.
So
He's my full time.
All right, so he's at Maple Street and you're not?
I'm not.
Well, I was gonna set this
Oh,
up.
wait a minute. No. 302 South Kalamazoo is my address where Brock's at. 6 Maple Street is where I'm staying.
All right, now who lives there?
My friend Phil Chisholm.
All right, well, I'm not gonna put it out that far. We need to get things reconciled here. Is there abuse neglect case, John?
He has talked to Child Protective Services. I am not aware there's been any formal filing in the family court.
Well, we're already busy, but let's put 11 o'clock on June 5th.
Have we cleared that day already or not?
I think, yeah, we did. Sometimes a matter of putting 10 pounds of sand in a 5-pound bag, but we'll see if we can make it work. All right, all your bond conditions remain in effect. I want to get the police report, victim input, but I don't want your family to be unreconciled for 2 months, so I'm gonna do this on June the 5th.
You see at what time, Jeff?
11 o'clock. Your bond is
I'm playing a circuit court jury trial.
Well,
that
I
day.
thought, I set 2 cases, but they weren't you. They were out of town counsel. So I thought you were already cleared for that date. My apologies. What's your circuit court case for that day?
It's the Haskins.
I'm
not sure. We're still some expert witness issues. I wouldn't want to bet the farm that's going that day, but.
Well, I wish it would go. It's about 500 days old. But I don't want to do that to you. How about May 29th at 10:30?
The circuit court jury trial set that day also. I mean.
Life is complicated. It's gonna get more complicated. And I was gonna set it on Thursday, but your Thursdays are bad. 20. Well, how about Monday, May 20th? I just set you for Monday, May 20th. I guess we'll cram it in there. Be a no lunch day.
What time?
11.
That's just fine. Thank you.
Michelle, I don't have any more notice forms, so would you take the defendant out and the clerks will give them a formal notice? Stay in contact with your lawyer and your bond conditions remain in effect. This will be about 2 weeks from now as opposed to something further than that.
You want me to get you more notice sheets?
Yes, please. All right, you're good. Headquarters on his case, Mr. Richard Curry. Is Richard Curry here? Tazi, I know you had a very busy morning. I did approve you to appear by Zoom, but not your client. As I also indicated, there's an open warrant for his arrest on another charge that you don't represent him on, at least not yet. The case that was set for this morning is file 2442 FY, People versus Richard Charles Curry. Mr. Curry is here. Good morning, sir. Are you Richard Curry?
Yes, sir.
Your attorney, Mr. Anastasi Marku, is here with us by Zoom. You are charged in a 2-count felony complaint with home invasion in the first degree, which is a felony punishable by up to 20 years imprisonment, and assault with a dangerous weapon that is alleged to have occurred on September 26th of 2023. Prosecuting Attorney David Marvin is here, and your lawyer is here by Zoom, as I indicated. Mr. Marvin, what's the status here?
Oh, I don't know. There was an offer. And I guess it's up to defense. We're gonna have a prelim or not, I don't know.
Is it my
Mr.
understanding, Mr. Marvin, is it my understanding that the offer is a plea to 1 count of home invasion 3rd degree, dismiss the other count, and I think that might be the full extent of what I believe the offer might be.
It also included a felony assault.
Okay. So at this point, Your Honor, I had conversations with Mr. Curry about this offer previously, and as the court knows, he was in a motorcycle accident and is not doing well. So he and I have not had a chance to meet in person about it. But the last time we did talk about that particular offer, he wanted to not accept that offer and to move forward with the preliminary examination. My suggestion is that Mr. Curry and I speak tomorrow and or Thursday. And if he chooses to waive to keep that offer open, we'll alert the court right away and make sure that's effectuated.
Offer open until Friday. Reason for that is because it causes the prosecutor to get subpoenas out and get people blocked out and disrupt their schedules. So if we're going to have a prelim, it will be next Tuesday, May 14th.
Isn't that on the, didn't I have court next Tuesday anyway?
Yeah, that's the date that was set. They
Yeah,
set both dates at once, Mr. Curry. They set this date for a pre-exam conference. And if the matter's settled, we don't need to have the prelim.
I see.
So it's previously been set for the prelim if we need it.
Your Honor, I haven't been in trouble in 40 years. This
All right, well, don't say more about it. Mr.
Yeah.
Mark, who's not here, but now you have a new charge, which let me see if I can find it. There's a warrant out for your arrest.
There is. I'm aware.
Yeah, not much. You had some civil, you got sued by your foot doctor and your dentist maybe, but no criminal stuff. All right, it's alleged in this new file, 24641, that you made an assault and battery upon Bruce Whitmore. 2 counts on or about April 1st of 2024. The affidavit of probable cause. We're back at Cato Lane. And Mr. Whitmore says he was riding his electric bike and you pulled him off the bike and punched him. And you said you had a knife.
I did.
Curry stated he did pull Whitmore off the bike and punch him several times as he is sick of Whitmore. He stated Whitmore damaged his motorcycle and his car in the past. So that allegedly occurred on April 1st. When was your motorcycle accident?
It's a spider bit me, Your Honor, and I passed out on my motorcycle just leaving home and I went over.
What day was that?
I don't know. I was in the hospital for 5 days, so I don't really remember.
Well, this was April 1st.
It was after that.
Okay.
It was after that.
It was after that, Your Honor, for sure. We were aware that this accusation might be coming up. When I first met with Mr. Curry, he had bruises and took a pretty significant beating, and I presume it was from that same fight with the victim in this case. I don't know actually what happened or didn't happen, but I know we were both expecting.
Well, don't say anything,
Richard, you're not supposed to say anything, Richard, okay?
The question we have to deal with right now, Mr. Curry, is whether you're going out to the jail to get booked in and lodged on this charge.
Yes, sir.
Mr. Marvin, what's your position regarding that? My concern is he's got medical problems.
Yeah, I do too. I don't really want to burden the jail with his medical appointments.
Mr. Marcoux, are you going to appear in this case?
Yeah, I think I am. Mr. Curry struggles with some prior closed head injury issues and some other issues, and I even though he's not going to be able to hire me on this, I'm still going to represent him.
All right.
So is there a pretrial?
I'm going to set it for the same time as the prelim.
Okay.
I'm going to set bond at $500 PR. No contact with Bruce Whitmore. You're gonna need to go out to the jail and get your mugshot taken and fingerprinted. Set a pretrial conference for May 14th at 1 o'clock. Now the problem is you and your neighbor both live at Cato Lane. You don't live there anymore?
He absconded, sir. I don't know where he is.
All right, he's not there?
He took off.
All right, well, very good. So you won't have to have any contact with him.
Yes, sir.
All right.
Your Honor, I would still order no contact, just to be on the safe side in case
Yeah, I have.
Okay, in case he comes back.
I don't know what this is about, but the home invasion is last September, and it's Whitmore's again, Trevor Whitmore. So obviously there's something going on here that's outside of my understanding, but I don't want to have anything else in the meantime. So Mr. Curry, I want you to go out to the counter, sign the bond, and then before you go back to Sturgis, you need to stop at the jail and get your fingerprints taken and your mugshot taken, but I'm not going to have you lodged.
Thank
All
you,
right.
sir.
The bailiff will take you out to the counter for the notice and
That's a $500.
it's PR bond.
Oh, it's a PR bond.
Yes.
Thank you, Your Honor.
Okay.
Thanks,
Mr.
Your Honor.
Martin, good luck for your next stop.
I'm now in.
Every day in the USA, people find themselves in court.
Arbor One versus Savannah Powell and Savannah Powell versus Arbor One.
Good morning, Your Honor. Cheryl Lukoff on behalf of the plaintiff and counter defendant.
Your name, ma'am? All right. And where are we on these cases?
Your Honor, Ms. Powell is represented by counsel, Mr. Biggs, who's also present by Zoom.
Oh,
I'm
is
not
it?
sure. I believe so, yes.
Is he there?
I think he's muted.
Oh, you're muted, counsel.
Sorry, Your Honor. That was actually one item I wanted to address with the court. Ms. Lukoff and I were working on a settlement discussion. We were very close to getting, I think, to a resolution. And as such, we were hoping to just get a brief adjournment of today's hearing, and we're putting that on the record. However, I heard from my client this morning that she was not interested in settlement, and moreover, wanted to proceed as representing herself. So, Your Honor, I propose this is now an oral motion to withdraw as counsel if my client wishes to proceed in pro per.
On the date of trial?
That was what I was informed at 7 o'clock this morning, Your Honor.
I wasn't informed of the settlement until about 4 o'clock last night, maybe a little bit earlier. But I told them weeks ago that this was going to go through, that I wasn't going to have any more money to pay them. So for the sake of not ending up back in your court because I can't pay rent for my new apartment, I don't have the means to have it anymore. So this is something that has been communicated on multiple occasions with
What's been communicated?
that I don't have any more money to pay.
I couldn't hear that, Your Honor. I'm sorry. That she doesn't have what?
That she doesn't have any more money to give the attorney. Well, okay, so if I allow your counsel to withdraw, right? And don't adjourn the trial, what are you going to do today?
Today, I mean, I'm prepared to move forward. I have all of the documentation, pictures, videos, everything that I need.
Okay, so,
And we can adjourn now if you'd like.
well, I know we're gonna do what I like, but that goes without saying. But I'm trying to figure out. Counsel, were you close to resolving the case?
Well, we were close to what we believed was a reasonable settlement, but my client was dissatisfied with that idea and wishes to proceed against the advice of counsel.
And you're not interested in settling the matter, ma'am?
With the amount that was offered. I can't afford what was offered. So I'm kind of just in a really awkward spot here.
Wait, let me, was it? Okay. And if nobody wants to discuss it with me, that's fine, except that, is it an amount you have to pay? Okay. And is the amount, there could be two reasons why an amount is whatever. It could be because payment is a lump sum that I can't afford to pay. Okay. Or I just need the dollar amount is not what the dollar amount is a dollar. I just need to find a way to manage and be able to manage the dollar. You follow me?
Yeah, I follow you.
Okay, so of those two options, is which one is it? Or is it none of that?
So I
And you don't have to answer me if you don't want to, because I mean, it's a non-jury trial, so I don't want to really be involved in settlement. But you've had counsel, there's negotiated with other counsel, they've come to something, and I want to make sure that you're not just sort of making a decision because of this financial pressure here, and then deciding to go to trial, and then next thing you know, you end up worse off than where you may have been. That's what I'm looking.
I appreciate that, Your Honor. And I mean, if I'm being fully honest, the only time I've been in court aside from this was for a traffic ticket when I was 17. So
Yesterday then, right? Okay, go ahead.
But I am not super familiar with legal proceedings, especially in landlord tenant. I deal with some.
Oh boy, then a trial would have been fun. Go ahead.
Minimal experience in my job. I work in the Department of Anesthesia, so I do a lot of contracting and legal licensing legal wise. We're actually in the middle of a site visit at work, so this is a really good day for me to be here. But there's a couple things. One being that I feel like I have the documentation and I've been very reasonable before this even came to court with the leasing complex, providing all the documentation when I told them that I was initially withholding rent, which is why I was in eviction court in the first place. I told them that I was willing to provide all the documentation that I had. And to make a long story short, they decided to ghost me and not respond to the multiple emails that I sent, and then it sent me an eviction notice.
Who ghosted you?
The apartment complex, the manager.
Okay.
But I feel like if I had the chance to present the documentation, the emails, the videos, the pictures, everything that I have a really good case.
Okay. Let me just say this. Everybody who comes here thinks they have a good case.
Absolutely.
Okay. At least half of them are wrong. Okay. That's one of the reasons why settlements happen. And being in court is not necessarily, I mean, I enjoy it, but it's not necessarily fun for folks. And so you try to resolve things where you can. So again, going back to my one question, because it's going to be a determination as to what I do with this case today. Is it an issue of I don't like the amount?
Correct.
Or managing that amount?
It's a little bit of both. I don't like the amount because I shouldn't have to pay rent with the things that we're going.
Okay, but listen. What do you do if after hearing everything, you end up with a worse number?
That's a really good question.
I know, I asked it. So what do you do then? I mean, ma'am, understand this. And people don't sometimes understand it about attorneys and what they're doing for the client. But I'm sure with these two attorneys, they work very hard to try to come to something that's acceptable to both sides. All right. I would imagine as much as you are unhappy, Ms. Luckoff's client probably thinks, well, we might be able to do better too. But there's always a downside risk. All right. Which sometimes can just be crazy Judge Simpson and what he's going to come up with. All right. That can sometimes be the downside risk. And everybody didn't have to laugh so hard at that. All right. But the real question is how do you get yourself to a spot that's comfortable for you? Do you really, listen, really, do you really want to go through a trial? I mean, really?
Realistically, I never wanted to do any of this in the first place.
Okay, then that's the answer. And your attorney, I'm sure, knew that. and is trying to negotiate the best possible solution for you. And sometimes that number is not every month I get a DTE bill. I don't like that number. All right. But I had to figure out a way to manage it. And sometimes that really is what the hiccup is. Okay. So what would you like me to do?
So to make this decision, I had like not even 12 hours because this came to me late yesterday afternoon. And that's kind of how this entire thing has gone. I've had hours to make huge decisions like this, and they're very big decisions. Because essentially we're playing with my financial freedom. I have used the majority of the money that I had saved for the down payment for a house on all of this. Again, just because I was trying to be an honest person. And if you look at the prorated rent for what I was asking before this even I started withholding rent, it was like $300. We're all standing here for now, thousands of dollars amount for something that could have just been resolved if they would have just reimbursed me for the couple of days.
It's why I have a job.
Which is why.
Go ahead.
This felt like the gut decision to make because I feel like I have been going through this entire process in the dark. And a lot of questions that I've asked have been met with I don't know. A lot of things that I have figured out have been through Google, which I'm sure is not the best source for legal advice. I spent
Okay, go ahead.
like I have been doing my best, but this felt like the decision to make because
What
the
decision?
amount that they are asking, the decision that I made to move forward today and show up here with what I thought was without representation. I did tell Brendan ahead of time that I had more money to pay him. But I don't even know where it's going. Oh, the amount that they're asking for the settlement was the amount of the rent that I was withholding anyways, including the time that I was out of hot water. So essentially I have spent I would be spending that money anyways, and then I would be losing out on thousands of dollars for an attorney.
Okay, so what do you want to, that's, okay, ma'am, that always is a risk.
Absolutely, I understand that.
So what do you want to do? I mean, understand something. Sometimes what you do is you get yourself involved in something, feeling that you're right. I don't think that a lot of people come before me not thinking that they're right at the outset. But all of a sudden you get kind of toward the end, and this isn't turning out anything like I think it should. So you can do one or two things at that point. You can double down and then go ahead, and then, oh God, you never know what's going to happen. Or what you do is you make a decision. I'm cutting my losses. I'm moving on with my life. All right. So what do you want me to do today? You came here for a reason. I mean, I'll give you a trial, but I don't think you really want a trial.
What are my options for today? Because I don't even, my options.
Whatever I say.
What options do you have?
Well, the reason I was asking the questions is because I'm trying to fashion something that will make sense to all parties. I would imagine that Ms. Lukoff has spent a great deal of time trying to negotiate this with your attorney. And so they're invested in doing this too. So I'm keeping that in mind. But then I get here on the date of trial. I have a litigant who now wants to get rid of their attorney, and so there are a number of things I can do. I could force you to trial today, right? Don't know that that would be entirely fair to you, because I think you're as prepared to go as you want to go. But I'll leave that there. I could adjourn the trial and see if you guys could just hammer in the fine details of what's going on.
I'm naturally such a pacifist, like this is also.
What?
I said I'm naturally such a pacifist, like this is the first time that I've ever had the confidence to do something like this. Sorry.
It's okay. All right, look, young lady. No, just listen. Okay. I'm glad you said that. Okay. Because what you're doing, and it's a hard thing, because what you're doing is you're standing up fighting for yourself. Probably haven't done that a lot. You probably just kind of give in and go on your way. So you stand up, you're fighting for yourself, and then you get to this point, and you've invested in fighting for yourself. And so when you go to that side of things, it then becomes a bit harder to just, in your head, you're thinking it becomes harder to give in, even though that solution may very well be what ultimately is in your long-term interest. But in the back of your head, you're still saying to yourself, I'm not giving in, I'm fighting. And sometimes fighting may not be the best thing. And that's your dilemma.
I think you're probably correct, Your Honor.
Not probably, I'm the judge. I'm always correct.
Okay.
All right, but sooner or later she'll figure it out.
I mean, it is your courtroom.
Yeah, oh, absolutely. No, this one isn't mine. I don't like this one. What?
I said I'm happy to meet you.
Yeah, there's people in mine, but anyway, go ahead.
I'd also like to point out that before this settlement that I declined, as of this morning, we had another settlement that I gave Brandon the okay on, and then when it was written up, it came up as more than it was supposed to be. I don't know how that was determined. Brandon thinks that perhaps it was because of the amount that I have had in escrow was not accounted for in the settlement that was drawn up. But I think you're correct. I think this is very, again, I never stand up for myself. Others I have no problem standing up for. I feel this daughter of 5. I was just heavily, like, it's never a problem. But for myself, I would rather go plan in traffic than like
Then what?
plan in traffic. I really don't like standing up for myself. Long story short. But I just
Playing in traffic. Go ahead.
oh, I lost my train of thought again. I just have been so overwhelmed with this entire process, and every large decision has come hours before, or the evening before, or the morning of the court date.
Welcome to the law.
Yeah, that's not generally how I function in a personal or even in a professional sense. I'm a pretty tight ship against each other, but I just feel like I have never had enough time to make a solid decision throughout this entire proceeding. So if we could adjourn, and maybe if I have more than 12 hours to think about a settlement, or we could adjourn to a jury trial, and I could consider.
A jury trial. I don't
Your
think
Honor,
anybody-
that ship has sailed respectfully.
Yeah, it's me. Yeah, ooh, joy. But no, I don't mind trying the case. I really don't. But I can adjourn it out. I mean, how much time are you going to need to think this through?
To think this through whether or not I'm taking the settlement. If I could have What's today? Today's Tuesday.
It was. No, it is. Go ahead.
Sorry, I forgot. Today's Tuesday. Can I have until, I don't think I'll need until Friday at noon. Can I have until Friday at noon? Or do you need?
No. Are you gonna be able to, Friday at noon? Okay, so let's say you decide you're going to take the off. How are you intending to communicate that?
However.
Okay, let's do this.
I'm happy to play.
Hold on, just hold on. All right, because, okay. Council, your motion to withdraw is denied.
Yes, sir.
You'd have to file a written motion. All right, so here's what that means. What that means is an attorney, once they get into a case, can't come out of a case until the court says they can come out of a case. I'm not letting them out of the case. Okay, so that's your attorney still. You guys figure out your communication, but you still have an attorney. I will adjourn the trial. All right, there's been a request to do that, so I'm going to adjourn it. What I want you to think about, young lady, is sometimes when you stand up for yourself, you learn a little bit about yourself just by the process, not by what ultimately happens, but by the process. And it isn't really about the end, right? Life's a journey. And you said it yourself, otherwise I wouldn't be discussing, is that you're usually one that sort of doesn't stand up for yourself, flows like water, as opposed to whatever, right? And sometimes getting to that point of whoever you want to be in that regard, it's not going to happen overnight. It's not going to be defined by these two cases in front of me. It's a journey. And so you have to figure out, did I get enough? And it may be, I got enough out of this part of it that all said and done, I'm a better person. I'm closer to where I want to be. And that's all that you can ask, right? Win, lose, or draw, these cases don't define you. Right? All right. So here's what I'm going to do, folks. There was a request to adjourn anyway. So when's my next day?
Tuesday 14th, which is next week.
All right. I'm going to adjourn this out 1 week. You guys are close to settlement. I think it can be resolved. All right. You're a bright young lady. Figure this out. Okay. But work it all through. Right. I don't think you want to be in a courtroom all day. I just don't think you do. Yeah. Someday I have days like that too. All right. Yeah. Well, all right. So, folks, I'll adjourn a non-jury trial 1 week out, and hopefully she'll have time to think through the resolution, think through what's been said today, talk with your attorney about how you got there. And, you know, I think sometimes what people don't understand about attorneys is that they're really doing what's in their client's interest, and you may not like it. Right? But sometimes what's important, in as much as it's for the attorney to listen to the client, really also listen to your attorney. Okay. All right. 1 week. You guys come back. You guys resolve this thing. Okay.
Thank you, Your Honor.
All right, I guess Jeremy Robertson, it says reset for announcement. What happened there?
It was a declaration of the
Travante Fontenot.
He's outside, Judge. You sure?
Okay. No, what's your announcement?
Oh,
It would be, he's outside.
I think I'm
Kinda
ready to
gets us
reset.
nowhere.
I've spoken to the prosecutor and he was supposed to give me some information, but I don't see him down here yet. So before you'd have like a
Who's
month.
the prosecutor?
Mr. Sonny.
Well, I don't think he's gonna be here to.
He's sick right now. Well, I talked to him yesterday. He tells me that Mr. Fontenot may have another case, and that's the thing.
Is that what you're looking for?
Well, I don't know that it's indicted or what.
Well, if we received it, I'll look and see.
Okay. Or you could just dismiss one and then I just go about my merry way. Judge,
All right, bring him
I've
in.
spoken to him.
Bring him in.
I think he does have a misdemeanor also set.
Probation.
Another.
On probation. For him.
I don't know about probation.
Huh? Yeah, you just don't know. He also.
Every day in the USA, people find themselves in court.
Yes, sir. He got charged with being a disorderly person in the city of Three Rivers. That's a misdemeanor. Michelle, would you check and see if there's a Jessica Quintana out there?
Yes, sir.
The file number here is 24540OM. Disorderly person under the Three Rivers ordinance is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Let's take a look at the ticket, and my system is defective, so I have to. No,
No, she was not checked in.
all right, Vivian, thank you for being here on short notice. Let me find your ticket, Mr. Tyree. It's gonna be a long morning if OnBase doesn't work any better than this.
They were complaining about it in your office too.
Oh, it's locked up. Here we go. They charge this on a formal complaint that you were with a retail fraud by stealing an Xbox controller, but they didn't charge it as a retail fraud. They charged it as a disturbing the peace or disorderly conduct. That's interesting. That was done by the Three Rivers charging officer. They alleged that you were at Walmart. Didn't you work at Walmart at one time?
Yes, sir.
Okay. And you took an Xbox controller and then left with it. It was worth $49.84. So rather than charge you with retail fraud or embezzlement, they charge you with disturbing the peace, which is kind of a gift. A normal fine for this is $100. That would also be question of restitution, and that would be the state costs. How do you plead to that, Mr. Tyree?
I'll plead guilty to that.
And I promise you anything to get you to plead to this
No, sir.
or threaten you?
No, sir.
Were you still working at Walmart when you took this?
No, sir.
Good morning, Mr. Moore. These are one of the things that people steal that they can sell. Were you going to use it or sell it to somebody else?
No, sir. I was actually going to use it.
All right. What are you doing now?
I'm currently focusing on graduating. I graduate near June, July.
From where?
Three Rivers, the high school.
Okay,
Yes, sir.
good for you. All right, well, this is not going to show as a larceny charge, but it is a very minor misdemeanor. Did you charge this, Tim?
Yes, sir.
So that was a gift, really. All right, $75 fine, $75 crime victims' rights fee, a $50 state minimum fee, and $50 restitution to Walmart. That's $250. You're also barred from Walmart for 1 year.
Your Honor,
Yes,
the controller was recovered.
oh, was it?
Yes, sir.
Asked Tyree for the controller and Tyree returned it to Sippers. Okay. You owe $200. Do you need time to pay that?
Yes, sir.
Do you need a payment plan or can you pay it within 30 days?
Just to keep it safe, a payment plan would be nice.
Well, I agree with you. I want you to cross the finish line and graduate from high school.
Yes, sir.
But then I want you to pay $50 per month. All right, the bailiff's gonna take you out in the ways will help you set up that payment plan. Are you still living on Peeler Street?
Yes, sir.
Okay. All right, you're good to go. We have Brittany Morgan, who was supposed to be here.
I am.
Yeah, the other day, but you're here now, so,
Thank you for calling me.
okay, why don't you come up?
Good morning, Judge.
Good morning. Are you Brittany Lynn Morgan?
Yes, sir.
You got a ticket, and we get lots of these for driving without a valid operator's license, called no ops sometimes. We're supposed to be here last Thursday and you didn't come. I called your phone and left a message for you. And said you needed to come in here. I issued a bench warrant with a $250 bond, but a 48-hour hold. They haven't done that yet, so we're gonna recall the bench warrant.
Can you recall the bond?
Yeah, I recalled the warrant. You're not gonna get arrested.
Thank you. But
If
can
people
I,
will just show up, then we wouldn't need to do a
I
bench
would-
warrant. You did show
I
up.
don't know why the county didn't let anybody know, but I was incarcerated around those times. Like in Branch County and then Van Buren County.
Well, we don't always know that.
I like
So
have the worst
what-
luck.
You were in Branch County and Van Buren?
Yes, sir.
When did you get out?
Good, 2 weeks ago, maybe.
All
And
right,
then
well,
they know,
this was last Thursday, so I don't know why you didn't come last Thursday.
because I was in Van Buren.
Oh,
Like I got a sentencing coming up on June. And they know that I'm in the middle of a move. Everybody should know that.
all right.
But
Well,
I
the
plead not
allegation
guilty.
is that on March 5th, you were driving here in St. Joe County without a valid operator's license. How do you plead to that
Not
charge?
guilty,
What's that?
not guilty.
Okay. What are the charges you have in the other jurisdictions? Are they driving charges or other sorts of things?
No, it's criminal. Not driving.
Well, it's your absolute right to plead not guilty. Let's take a look at this. You do not have a license. Nothing bad on it, you just don't have a license. You have an ID. The ticket says that you were driving Haynes Road and South Fisher Lake Road. That's where the road is out at 5 a.m. on March 5th. Okay.
The truck wasn't even on.
What's that?
The truck wasn't even, the keys were out of the ignition and I didn't get pulled over. Like,
All right, so your contention is that you weren't driving.
no, the truck was
Okay.
off. I was putting gas in the truck for my fiance.
Okay.
And then I got a no trespassing, a warning for a property that I've never been on. Like, at all.
All right, I'm just gonna set this for trial. Well, maybe I'll set a pre-trial. You tell your story to the prosecutor. Where are you living right now?
Constantine. You want the address?
Well, I don't want to put it here on the record, but I'll set a pretrial with the prosecutor, and I want you to provide your address to the clerks.
Yes, sir.
So the prosecutor is very busy this morning, and they're also shorthanded, so I don't have time to do the pretrial. So your contention is you weren't actually driving, and that's a pretty good defense to this charge if it's true. I don't know what was going on at 5 o'clock in the morning out there at that spot. Like I said, they're repairing that bridge. The road is closed along there. I don't know if it was in March. Yeah, you missed a couple of dates. Is your phone number still correct?
Yeah, that's how I knew you. That's why I
All
came
right.
in. I got your.
Well, the
voicemail.
good news is there's no bench warrant. The bad news is you got to come back and explain the story to the prosecutor.
That's fine.
So I'm going to send you out to the clerk and I'll give you a date for the pretrial and I want you to give them your address.
Yes, sir.
All right, thank you.
You have a great morning.
All right, I'm glad you're here. I'm glad we don't have a Matthew Kyle Killian. I saw you on screen the other day and I apologized. I thought you were a witness. And she said, no, she's just here hanging out before we send her out. This is file 24653OT and a civil infraction of registration plate violation. The White Pigeon Village attorney is here. And I always mispronounce your last name, Aaron, and I apologize again, but would you state your name, please?
Aaron Geschwint, Your Honor.
All right, I was close. Geschwint. Geschwint or Geschwint? Went, all right. Geschwint. I was in the right neighborhood. Anyway, she's agreed to dismiss the civil infraction, which would save you $120 if you plead to the minor misdemeanor of having open intoxicants in a motor vehicle. That's punishable by a fine of up to $100 and up to 90 days in jail. Nobody, I think, in the history of the world ever got 90 days in jail for open intox, but that is the maximum allowable. Normal fine for this is $200. Do you understand the charge?
Yes, Your Honor.
And you're from Shipshewana?
Yes.
And were you driving up here in Michigan on April 16th?
Yes.
And did you have some open beer in the car?
Yeah.
Where were you going?
To McDonald's.
What do you do down in Shipshewana? What do you do down there?
I live there.
I know, but where do you work?
Oh, I cut trees.
Okay. Other than this plea agreement where the other charges dismissed, anybody promise you anything to get you to plead to this?
No.
Or threaten you?
Nope.
You did do an advice of rights. All right, the fine is $75. There's a $75 crime victims' rights fee and a $50 state minimum fee. That's $200. Don't have any bond. How long will it take you to pay that? Can you pay it in 30 days?
I can pay it now.
All right, that'll save you a trip down here. Oh, we're having trouble with on base. It's blinking on and off. An A coin somebody gave me. All right. Don't uncap it till you get home or stay in Indiana and you'll be. I don't know what the open intox law is in Indiana, but. All right, $200, lesson learned. You're good to go. Don't come back. Thank you. That's a long way to drive for that, but you could note that the other case was not resolved.
All right, who's here on Rolando Gomez? Are you all ready? On that one, they want a bond motion. All right, are you all ready to proceed with sentencing?
We are ready.
Okay. Court is calling 2024 CR 1562, State of Texas versus Rolando Gomez. Can I have parties announced for the record for the state?
Hey, looking for the state. Roger Pettis for Mr. Gomez, Your Honor.
And are you Mr. Gomez?
Yes, Your Honor.
All right, we're here today for sentencing. You entered a plea of no contest and a plea of true to paragraphs 1 and true of the enhancement. The court found there was sufficient evidence to find you guilty. And we are now here for sentencing according to the plea bargain agreement. Punishments be assessed at 4 years in the prison, and the state is silent on your application. And I believe on this case, there was supposed to be a TAP evaluation and a DDRF evaluation. Are both parties in receipt of the DDRF evaluation and the TAP evaluation?
Yes, ma'am. Yes, Your Honor.
All right, any objections?
No objections, Your Honor.
All right, the state is silent. Anything you wish to say on behalf of your client?
Judge, Mr. Gomez has understood that he has made a little bit of an error in this particular situation. He's gone through some issues, both physical as well as recently mental. He went to St. Pete many years ago. he has access to family members that he can stay with. We understand that there's an appointment for a DDRF or a MIC appointment in June 27th. We're wondering if the court would be would grant him the honor of probation, and he would immediately make that June 27th deadline. And he understands that if they rule that he needs some assistance, that it would be an inpatient program, and he's motivated for that. He's motivated to try to get these things behind him.
All right, anything you wish to say, Mr. Gomez?
Yes, Your Honor.
Yes, what would you want to raise your right hand?
No,
Do you, you don't want to say anything?
I'm good. Thank you.
Okay. All right, so this is where we are. Where we are is you continue to pick up cases, right? And I know there are some underlying issues as it relates to those cases. So you're going to have a choice. People always say that probation in this court is very difficult, but I don't do cookie cutter conditions of probation. Hopefully the conditions I'm setting for you are designed for you to change your ways and for us not to see you anymore. So if you would like, I can sentence you to 3 years in the prison, or I can place you on probation, but what's going to end up happening is you're going to remain in custody. You're going to have a review with the DDRF. And if DDRF doesn't accept you, you're going to safety. So those are your choices. Well, I mean, your attorney's saying program for you, but here's the thing. You know yourself better than I know you, better than your attorney knows you. You know whether or not you can successfully complete probation. What I'm telling you is, people say that probation in this court is difficult, but the conditions that I give you hopefully are conditions that can help you rehabilitate yourself and become a citizen.
Yes,
and an upstanding citizen. You understand? So the question becomes whether or not you want to do prison or whether or not you want to have treatment. Either way, you're going to be in custody.
Can you give us just a minute?
Sure. And Mr. DeLeon. Norma. Michael's available for that. And we're off the record while they discuss. Mahia, there's always long discussions on whether you want treatment, prison time. Have y'all finished your discussion?
We have, Your Honor.
All right, we're going to go back on the record.
Program.
Okay. All right, so this is what the court will do. The court is going to sentence you to 4 years in the prison, suspended and probated for 6 years. There is going to be regular reporting by Zoom or in person. The UA hotline upon release. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Probation, do you think felony drug court would accept him? All right, so first, a referral to felony drug court. If not accepted, then he can remain in custody for DDRF. And then if not accepted to DDRF, then it'll be safety. And if he's not accepted to felony drug court when he's released from custody, then it's going to be 90 sober meetings in 90 days. Field visits, one time per month for 4 months. And the CATS theft course 1 and 2. Probation, is there anything else he needs? All right. Yes. Defendant is to remain in custody. For all evaluations. Do you have any children?
Yes, ma'am.
What are their ages?
They're already graduated.
All right. And there's going to be 200 hours of community service restitution, and those hours will be not waived. How far did you go in school?
Tonight.
All right. So what type of employment have you had in the past?
I get benefits every month.
Benefits for what?
Social Security.
I mean, why? Why is Social Security giving you funds?
Mental.
Okay. All right. 200 hours, but he says he's receiving Social Security. So proof of employment within 30 days of release, or proof of SSI within 30 days of release. And there's to be no unsupervised contact with minors. And we're also going to have to do, if DDRF doesn't pan out, then it's going to have to be MIC or either referral for Center for Healthcare Services.
Not good enough to until they do an evaluation, they either send you to one facility or another. You're gonna be on probation for 6 years.
All right. Is there anything else? Is there anything else that you need from the court to be successful?
Yes, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
We can go off the record. In this court, probation, to be successful, communication is key. If there's an issue, let your officer know. If you feel as though they're not addressing it, you can always come to court. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
Who's here on Ernest Diaz?
We're ready, Judge.
And Norma, if you can see where the attorney for Mara Lopez is. I'm sorry, Mariah Lopez. All right, court is calling 2023 CR 2715W, State of Texas versus Ernest Diaz Jr. Can I have parties announced for the record for the state?
State.
Defense.
Greg Gameray for Mr. Diaz.
And are you Mr. Diaz?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Ernest Diaz Jr. who was placed on community supervision in 2023 CR 2715W for the offense of continuous violence against the family on March 27, 2023 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 39.
on or about the third day of April 2024 in Garrett County, Texas. The defendant, Ernest Diaz Jr., did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department's duly diagnosed residential facility, in that the defendant was unsuccessfully discharged due to disregard of facility rules in violation of condition number 39.
How do you plead to that? True or not true?
True.
Your Honor, we'd waive the other violation.
No objection.
All right, did you understand by pleading true to violation of condition 39, court could find it true, grant the motion, sentence you up to 2 years in the prison and up to a $1,500 fine?
Understand.
Yes.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes.
Court will find 39 true. Is there a proposed agreement?
There's your Honor. We are asking that the court grant the motion, revoke the defendant's probation and sentence to 2 years.
That is our agreement, Judge.
All right, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Want to take care of this today?
Yes.
It's a little nervous, Judge, but we
No
talked about
problem.
it.
There's no need to be nervous, okay?
Mhm.
I'm just trying to make sure that I do what is best for you and also best for the community. So, probation. Oh, if you could speak up so the court reporter can hear. What is probation's recommendation?
Judge, at this point, it's revocation.
All right. And so, Mr. Diaz, there is no other program or any other placement that's available for you. So I'm going to grant the motion and I'm going to follow your agreement. I'm going to sentence you to 2 years in the prison. Give you credit for any time served. There's to be no contact with the complainant. And this wasn't a family violence case, was it?
It was continuous family violence, but I wasn't the original.
All right, thank you. And there's an affirmative finding of family violence. And I'll request mental health for him at the prison. Mental health therapeutic community. Whether or not you're placed in that will be up to them. I have no jurisdiction to force them to do that, okay? You still have to ask for it, you understand? All right, is there anything else with regards to sentencing?
Nothing from the defense.
Nothing from the state.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal
Yes,
with
ma'am.
your attorney?
Yes,
Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. When you're released from TDC, if you can't find someone to help you with your mental health treatment, you can always come back to court. If I'm here, I'll try to direct you, okay?
All right.
But when you're released, it's best for you to go to Center for Healthcare Services, okay?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome. Yes. So Albert. Good morning. If you'll come forward. All right. Mr. Albert, based upon the nature of the case, your previous defense attorney was, had to be replaced. So Mr. Cabanas is, your defense counsel.
Yes, ma'am.
All right, so where are we, counsel? I know you just got appointed.
I did, Your Honor. I talked to the state about this case. It appears that in addition to these 3 cases, there's some more that the state currently has under investigation that have not been indicted.
Okay.
So the state's asking to request more time so they can determine what they're gonna do with those other cases. While that's going on, Your Honor, I talked to Mr. James about this case. He's asked me to ask the court for a bond on these 3 current cases. And I think he wanted to address the court regarding those.
Oh, a motion will have to be filed in that situation. So your counsel will have to file a motion, then the court will hear it.
Yes, ma'am. So it's no possible way that I could get a bond today?
No.
Yes.
And the reason why I say that is because this attorney is brand new to your case.
Yes,
He'll have
ma'am.
to file a motion,
Yes,
then I
ma'am.
will hear the motion.
Yes, ma'am.
As soon as the motion is filed, which I assure you, Mr. Cabanas will do that quickly. And then Ms. Ferguson will place it on the docket quickly. All right.
Yes,
And if you all have some type of agreement, of course, you can always go see Judge Nahara.
Yes, Your Honor.
All right. How much time are you all asking for?
Just a short reset, Judge. There's several unindicted cases, so I want to talk to the intake attorney about what's going on with those unindicted cases, Judge.
All right. What I'm going to do is I'm going to recall this because I see it's a lot of cases. I'm going to recall it for 30 days. If you all want to be back sooner than 30 days, well, here's the thing. I don't know why you're having the disappointment. Let me just explain something to you. I understand disappointment that people want things done immediately, but here's the problem. If you want things done immediately, then maybe the state will take the cases that they don't have as worst case scenarios cases, and they will make the offer based upon worst case scenario.
Yes, ma'am. I made the gesture because when you said 30 days, I just knew I would miss the birth of my son. That's all.
Well, here's the thing. I don't know why people,
That's why.
and let me just tell you, I don't accept any of these cases as true, but I will tell you, so many people come before me
Yes, ma'am.
that get in trouble. You know what the first thing they tell me? I want to get out for the birth of my child. People who are on probation. I know I didn't report, but I'm trying to get out for the birth of my child. And you know what I always tell them? Guess what? If that would have been at the forefront of your mind, we wouldn't even be here.
Yes, ma'am.
But then the downside to that, if that was at the forefront of your mind, then maybe attorneys and judges wouldn't have jobs.
Yes, ma'am.
It's because people don't put children at the forefront of their mind, their jobs at the forefront of their mind, what their family will think at the forefront of their mind, that judges have jobs and attorneys have jobs. So I don't know if we should thank you all or just be upset by it all, but that's where we are. So Ms. Ferguson, can I have a 30-day reset on Mr. Albert? All right, we'll be back on June 13th. And Mr. Cabanas, if you all want to come back sooner, then you all can come back sooner.
Yes, Your Honor.
All right, June 13th. Thank you.
Harvey? Also.
Yes, sir. Thank you.
Joshua Wong.
Yes.
Every day in the USA, people find themselves in court.
Good morning. I have Richard Austin. He's in custody.
And we're just waiting on the court report.
Sounds good. Thank you.
Yes, I see. Hey, good morning. What case are you here on?
Good morning, sir. Jamie Crook.
Okay.
Has
Now,
Mr.
what
Crook
case-
checked in?
I'm sorry?
Has he checked in with you?
Yes.
Is it possible to have a breakout room with him, please?
Okay, now you're asking a lot. I'm just kidding. Hold on a second. Go ahead and join the breakout room. Mr. Parker, what are you here on?
Morning, I have Mr. Krigler, Crigler.
All right.
I appreciate you guys' patience. I'm just waiting on the court reporter. She has some personal issues she's tending to.
No rush, Your Honor. I can go last. I have plenty of time.
Now, are you here on Easton, correct?
I am. I just need to change the preliminary exam date and I'm gonna waive his presence. I spoke to him, but I wasn't able to get a hold of him yesterday or last night.
Why do you need to change the preliminary exam date?
I have something else scheduled in Macomb County on the 13th. Let me get my glasses.
Which one was scheduled first, mine or theirs?
Theirs.
So why would you schedule mine at the same time then?
I'm sorry, I don't understand.
If you knew that you had something in Macomb County when you scheduled my case, why would you schedule something at the same time?
Well, I was hoping to get a different date or come later. So.
No, you're not understanding. If you knew that you were supposed, let's say if you're supposed to be in Macomb County, you had it already scheduled for 9 o'clock on Wednesday. And you knew this, why would you schedule my case at 9 o'clock on Wednesday?
Okay, I am not sure. Are you saying that the exam date is Wednesday, May 15th? Because
no, I'm using that example. I don't know when your date is.
Because that is a short Zoom hearing and I can probably attend both if I could get a later time. I mean, I have emergency motions filed. Sometimes stuff comes up like out of the blue. I apologize. I do have another hearing this morning as well. In a different court.
Oh, there's a probable cause conference. You don't even have an exam date yet. That exam date you get at arraignment doesn't count. I don't hold you to that.
Yeah, I just saw it on the ROA. It's not on the petition for appointed counsel. I didn't handle the arraignment because I'm appointed on this case. So
yeah, ignore the exam date that you got at the arraignment. Okay, that doesn't matter.
Oh, okay.
We'll set the exam date today.
Yes.
Okay.
But you're always the priority in my book, Judge King. I don't.
You had me nervous for a minute. For a second, I didn't think I was.
Absolutely. You know, but like this week, I had 2 add-ons of emergency bond motions, an attempt murder case, and then that Macomb case changed from yesterday afternoon to what the supposed exam date was in this case. So yeah, we can set an exam.
Okay.
And I chose you over my legal assistant's ticket in Judge Millhouse's court this morning. So
I appreciate it.
First and always.
You were here bright and early, and then I can't even get started because I don't have everybody in place yet.
No problem.
Okay. She's on her way in though. Colin, come on up for a second, sir. Colin, come on up for a second. Oh, I'm gonna need. Oh. How you doing this morning, young man? How you doing this morning? Yeah, how are you? Doing good, thanks. This is my travel. This is what actually works. You're supposed to wear a tie, man.
Yeah, I actually decided against the tie today. Wore it last time.
Well, that's better with the tie.
Yeah, it's not.
Can I approach the bench? Yes, ma'am. Please, sorry. Good morning. Good morning. Very nice to meet you. Good. Okay. Was that okay? Are they gonna be able to hear me? Yeah. Well, let's go. Colin. Sorry. And now turn up a bit. Turn up a little bit. No, I can hear. Okay. I didn't want to take it. I should have changed the name. Stay in the king. Oh, just moving, I'm back.
What's that, Judge?
Hey, just having a little fun this morning.
Okay. Worried for a minute there.
Judge, while we're waiting, would it be possible to get a breakout room with Mr. Austin? I think he's one of the people at Wayne County Jail.
Okay, hang on a second.
Mr. Austin, if you're on the Zoom, could you raise your hand? Yeah, okay, that is him.
Okay. Girl, yes. Go ahead and join. Got here?
We're gonna go head up the check break.
Okay.
We'll be back. Say bye before.
All right.
Oh, good morning.
Let me know when you're ready. Okay. First up, Ms. Tucker. Okay, we are ready on Newman. I have an APA here on Newman.
Your Honor, I'm going to stand in on this.
Okay, great.
Calling case number 9605821601 for the state of Michigan versus Derek Newman. Defendant is charged in count 1, criminal sexual conduct, 4th degree.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Can't hear you, Ms. Tucker. Still can't hear you. What did you do? I could hear you earlier. No, can't hear you. Okay. We'll come back to Ms. Tucker. Ms. Birchback.
Good morning, Your Honor.
Ready on Austin?
Yes.
Okay.
Calling case number 2405697501. People of the state of Michigan versus Richard Austin. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder by strangulation, count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Charlotte Birchback from the Neighborhood Defender Service, P number 86740, on behalf of Mr. Austin, who's on Zoom. Mr. Austin, could you say your name for the court?
Can't hear you, sir.
Seems like
What's your pleasure, counsel?
Your Honor, we're missing digital discovery, but I'm fine to set for an exam sometime next week. I am in trial Monday through Wednesday, so I'd be asking for a Thursday or Friday date.
All right, the court will continue to plead not guilty and set this matter for preliminary examination on May 17th at 10 o'clock.
Thank you, Your Honor.
Bond will be continued. Thank you.
Thank you.
Thank you. And Miss Drain, you heard I'm missing digital.
Yes, as soon as the program is up and running, I will be able to get it to you.
Got it. Thank you.
Thank you.
Okay, Ms. Tucker, are you ready now?
Yeah, can you hear me, Your Honor?
Yes, I can hear you.
Okay, I don't know what happened.
Recalling case number 9605821601. People of the state of Michigan versus Derek Newman, defendant is charged in count 1, criminal sexual conduct, 4th degree.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Derek Newman, who's present on Zoom.
Mr. Newman, tell us your name for the record. You have to unmute yourself, sir.
Derek Newman.
What's your pleasure, counsel?
Your Honor, this is our third PCC because of the age of this case. We still have not received any discovery.
If I may, after a review of this case, and the fact that it is almost 30 years old, I would be moving to dismiss this case at this time.
We have no objection, Your Honor.
So ordered. The court will dismiss this matter without prejudice.
Thank you.
Thank you, Judge.
Thank you.
Mr. Gagnon.
Good morning again, sir.
Good morning, sir. You're ready on Crook?
I am.
Okay.
Calling case number 2405694901. People of the state of Michigan versus Jamie Crook. Defendant is charged in counts 1 and 2, criminal sexual conduct, 1st degree. Count 3, kidnapping.
Appearances for the record, please.
Good morning, Kirsten Kelly on behalf of the people, P83952.
Brian Gagnick, Your Honor, Neighborhood Defender Service, P64220.
Mr. Crook, tell us your name for the record.
Jamie Crook.
What's your pleasure, counsel?
Set us an examination date, sir.
I was May 13th at 12:15.
You have to be in Taylor in the afternoon on the 13th.
I can do.
I'm available a little bit earlier that day.
May 13th at 9 o'clock.
I'll take it.
That's good for the people?
Yes, Your Honor, that works for the people. Thank you.
Okay, May 13th at 9 o'clock.
Thanks.
Ms. Diehard on the phone. Mr. Parker. Mr. Parker.
Hello?
Okay, Ms. Diehard, are you ready on Easton?
Yes, Your Honor, I'm ready on Easton.
Yes, okay.
Calling case number 2405-698901. For the state of Michigan versus James Easton. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, domestic violence. Defense. Defendant has a habitual offender, third offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Judge King. Rosemary Dare on behalf of James Eason, P number 37888, and I respectfully request to waive his appearance today.
The court will waive the defendant's presence, continue the plea of not guilty. What's your pleasure?
Well, when I first spoke to him, we indicated that we'd go forward on exam. I'm going to make every effort to continuously call him and send him a letter to get a hold of him. If we schedule an exam date, if he changes his mind, I'll let the court know in advance so we can appear by Zoom to waive it.
How's May 15th at 10 o'clock?
Judge, I can't do the 15th. I have a motion in Oakland Circuit. I can do the 17th though.
Can you do the 13th?
I can't. I have a Rochester Hills case and then I'm in Macomb in the afternoon.
May 17th at 10:15?
Yes.
Okay, May 17th at 10:15, Bound, we continue.
I mean, I have an exam on the, okay, that's fine. Thank you, Judge.
Okay, thank you. Have a good day.
You too. You as well.
Mr. Parker. Mr. Parker, are you there? Mr. Parker going once. Mr. Parker going twice. Moving on, Ms. McMillan.
Good morning. I'm here on Terry Hunter.
Case came from Judge Jones. Calling case number 2405-606501. For the state of Michigan versus Terry Hunter Jr. Defendant is charged in count 1, assault with a dangerous weapon, count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Corianne McMillan, PA 7150 on behalf of Mr. Hunter. He was trying to log in. I was just asked to waive his appearance for the purposes of this proceeding.
For the waive the defendant's presence, what's your pleasure?
I would like to set for an exam.
Court will continue the plea of not guilty and set this matter for preliminary examination. How is your client in custody?
He's out.
How's May 13th at 9:15?
That works for me.
May 13th at 9:15, Bound, we continue.
Thank you.
Thank you.
Mr. Parker.
Good morning.
Good morning, sir. You had your hand raised. What's up?
There's probably a mistake there. I did not even notice it.
Okay, you ready?
Taking it down. I don't have any questions.
All right, you ready on Krigler?
Yes, I am.
Okay.
Case number 2405-678-401. For the state of Michigan versus Tymaine Krigler. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon. Count 3, domestic violence aggravated.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, James Parker on behalf of Mr. Krigler. My P number is 53832.
And what's your pleasure, sir?
Your Honor, we'd like to set this for a preliminary examination, please. I'd also like to ask the people to send me the digital discovery.
And let me just tell you that I did, there was not any available on evidence.com. I did send an email to the officer in charge. He emailed me back and stated that there is no video available. She walked into the station to make the report and the desk officer did not have his camera on.
Is Mr. Krigler in custody?
Yes, he is, Your Honor.
All right, the court will continue the plea of not guilty, set this matter for preliminary examination. How's May 13th at 12:15?
Yeah, that'll be a good date. It's after 12 o'clock. That's 12:15. You said 12:15? Yeah, that'd be
Yes, sir.
perfect.
All right.
Yeah.
May 13th at 12:15, bond will be continued.
Thank you very much.
Thank you, have a good day.
Do the same.
I just don't want to get up.
Your Honor, Krigler all set?
Yes, Krigler's all set. His next court date is May 13th at 12:15.
Thank you so much.
Shanice Glass, case number SP 1477226, counts 1 and counts 2. Appearance for the record, please.
Clay Miller, PA 6291, here on behalf of Attorney Hill, here for Mrs. Glass. Mrs. Glass, can you please state your name for the record again?
Juanita Shanice Glass.
Thank you. Your Honor, we're here for arraignment on the bench warrant regarding the arraignment. I'd waive formal reading, enter plea of not guilty at this time, and stand mute.
All right, let's also call into the record case number. It's a bunch of different case numbers down here. That for some reason did not make it.
There's four civil defaults, Judge. She's also got some arraignments on the bench warrant set for June 7th. There's a little bit of everything, so I'm not sure what's the best way for the court.
Date of birth, Ms. Glass.
January 1891.
All right, so I see what's going on. I have two different dates of birth here. It's January 18th, 91 and January 18th, 99. We're gonna pull it up by your driver's license number there. All right, let's also call into the record SC Detroit versus Juanita Shanice Glass, case numbers SP 133630, strike that, SP 13363901, SP 1458748, SP 1520267, counts 1 and counts 2, SP 1560205, U 4761591, 17 3489381, 18 411 0671, 18 4655 321. Did you state your name for the record, Ms. Glass? You did. All right, today is the date and time set for arraignment on the bench warrants. Go ahead, counsel.
We would waive formal reading, stand mute, enter plea of not guilty at this time.
Enter not guilty plea on your client's behalf. We'll give your client a $0 bond. Okay, Ms. Glass, I'm gonna have to ask you, do you need some drug treatment, ma'am?
I didn't hear you.
Do you need some drug treatment?
No.
There's an allegation, Mr., albeit it's older allegation, albeit, of some possession of ecstasy. There's only two reasons why I would figure that if the allegations are true, that someone would have that is, one, they either using or they're selling. So that's if the allegation is true. I'm gonna tell you, Mr. Miller, to get a offer from Madam City Attorney, and then you can present that offer to your client. Keep in mind, your client has an absolute right to a trial. We'll put you in a breakout room with Ms. Schneider and have a conversation with her. And then you can, I'll give your client a breakout room as well.
Thank you, Judge.
Ms. Glass, wait on Mr. Miller in the breakout room, please.
Okay.
Glass. Giving you an opportunity to speak to retry the case, counselor, and speak to your client. Did you speak to your client?
No, I have not, Judge, but we're ready.
And I think Ms. Glass is in. Hey, go in the breakout room to speak with her, please. All right, let's pass the matter again. Oliver is not supposed to be here today. Are we ready on Glass now?
Yes, we're ready, Judge.
Let's go back on the record with Ms. Glass. Ms. Glass, giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we're asking for a bench trial date. She's aware of her rights to a jury trial. She'd like to waive those and set it for a bench trial.
Is that what you want to do, Ms. Glass?
Yes, sir.
Okay, I'm going to set the trial date for August the 6th, 2024 at 9 a.m. If there's nothing further, have a very good day. Best of luck to you.
Thank you.
Thank you, Judge. Have a good day.
Ms. Glass, next time come on with more than a tank top. These numbers SP11882281, SP11994448, counts 1 and counts 2. SP12075003, counts 1 and counts 2. SP142639, counts 1 and counts 2. SP14718061, SP14996671. Appearance for the record, please.
Good morning, Your Honor. Harry Bachman for the defendant. Mr. Gibson, please state your name.
Jermaine Lee Gibson.
This is an arraignment and the defendant waives any more formal reading of the information, complaint, or warrant, stands mute for that purpose.
They're not guilty plea on his behalf. We'll give him a $0 bond. You can go ahead and get the offer from Madam Corporation Counsel, and I'll give an opportunity to speak to Mr. Gibson about it. Mr. Gibson, keep in mind that you have an absolute right to a trial, okay? So if you don't agree with the offer, if you don't want the offer, think you can do better at trial, you can exercise that right, all right?
All right.
All right, Mr. Bachman, why don't you get an offer from Ms. Snyder and then speak to Mr. Gibson?
Suspended. That's what they told me in Detroit, because I got pulled over in Detroit first, and then when I got pulled over in Livonia, that's when they took me to jail, because the Detroit police officer told me that my license was suspended, and I told him that's not true. It's valid, and I showed him the register of actions, but he still gave me the ticket.
Well, I don't recall. I don't know how that's gonna affect these tickets moving forward. Are you asking, like, this is a case in equity, I guess? You don't, I don't hear a valid defense necessarily, but you're saying, hey, Judge, you know, had this not been the case, then it wouldn't have snowballed into me getting arrested, losing a job. So can you please not find me anything? Is that what you're saying?
No, what I'm saying is that I've had to pay over $700 in fees because of the oversight on you guys' behalf when there was a ticket that wasn't closed out. I spoke to your court clerk, and you guys did expedite it pretty fast in regards to clearing out my license with Secretary of State that day in court. I was not on your docket, but I did call in, and I was allowed to speak with you that day.
Can you see that, Ms. Mathis? I'll put the ticket up. Are we talking about the same ticket, SP 151-36571?
While she's looking, Your Honor, Alexa Schneider for the people, P80322. I believe the only ticket she has left outstanding is a fail to stop that is amended to a blockading. Whether or not she has a license has nothing to do with whether she failed to stop. So I appreciate her sharing that with the court, but I don't think it's relevant as to the sanction today.
That's again what she's. I guess that's what I'm saying. And that's what I was going to say, Miss. I think what she's saying is, have some mercy on me. Is that what you're saying, Ms. Graves?
I'm not sure. I guess that's what I'm saying.
No, because I agree with Ms. Snyder. If the allegation is if the allegation of disregarding the traffic control device is true, had you not run the traffic light, and I'm just saying if it's true, it's now is a mere allegation, but if the allegation is true, Ms. Snyder is saying had you not run the traffic device, we likely wouldn't be here. So the fact that your license was suspended by, say it is our fault, the fact that it was suspended, it had nothing to do with you running that traffic control device. Do you understand that?
Correct, but I never ran the traffic light. It was yellow when I passed, so.
Okay, well now you've admitted to running the traffic control device, because if the statute says if it's an amber or a red, the amber is considered to be red, okay?
I was already passing the light.
You just said it was yellow, ma'am.
I was already driving as it turned yellow is what I'm saying. I was already driving at a steady pace. I was not speeding or anything. I was driving at a steady pace and he pulled me over.
So now we've opened up, now you've opened up a whole new can of worms.
I have.
Now you've opened up a whole new can of worms. The offer is going to, because now you're saying that you didn't do what the officer said you did.
I didn't run the light.
Well, you just admitted the light was yellow.
It was turning yellow as I was passing. I was
now
driving.
You're adding more to the story. You said the light was yellow. When I told you what the statute, what the ordinance says, then you add on to it. It was turning. I mean, I'm only going by what your words said, man.
I don't have a reason to lie. I'm saying what happened.
No, I'm not saying you're lying. I'm not saying that. I'm saying that as we go along, then more gets to the story. That's why I asked you not to speak to me about it. Speak to Mr. Berry and let your conversations go.
He said he didn't want to hear it. He told me he didn't want to hear it. When I literally went through this, I have my court papers. I was taken to jail because 36th District did not clear out a ticket that was dismissed on the 26th. I was taken to jail from work. I was headed to work. I work in Westland, Michigan. Livonia stopped me and said, oh, well, it doesn't matter. Do you have any weapons or drugs in the car? I said, no. He checked my vehicle. You're going to jail because your license is suspended. And that was dismissed on the 26th of February.
What am I gonna do? What am I to do with this?
I no, just I guess you guys are just gonna keep on racking up tickets on me and taking me to jail, I guess.
No, why you rack up the tickets on you? The offer is blocking traffic, man. $175. We'll close everything else out.
I had the offer of limited access 1 to 5.
Miss Snyder just changed it.
Oh,
Yeah, no
okay.
objection.
All right, it doesn't abstract. We'll close everything else out. Want to take the deal? Or we can set the matter for a trial, and then you can bring all of that.
Do what's best. I just want this to be over with. I want it to be over with.
You want to take the deal or not?
Yes, I want it to be over with.
All right. Stipulate to the face of the ticket as an active factual basis for the responsible plea counselor.
So stipulated, Your Honor.
Stipulate the probable cause for the dismissal of the other matters.
Yes, so stipulated.
I'm going to find your client responsible for the amended count of blocking traffic, 0-point offense, and I'm going to close it out with no fine, all right? So you get what you want, Ms. Graves, and the city gets what they want, all right? Everybody gets what they want. Everybody wins. All right, Ms. Graves?
Yes.
You still owe the court $240 on that old ticket, all right?
Exactly, and that's my whole point of saying this. I owe $240, but I had to go in debt and pay over $700 to. Okay.
Miss Graves. Oh, she's talking about the old. She's talking about the old no ops. Let's see that. Let me take one look at that. Yeah, I can't, I'm not saying that it's not true, ma'am. I'm not saying that it's not true, but you entered into an agreement to pay that ticket back on February the 6th. It was
Yes, and I was unable to pay it, but
it's supposed to pay by April 8th. I'll give you more time to pay it.
That's appreciated. Thank you.
I'll give you another 30 days, and if we did anything wrong, we apologize. Best of luck to you, ma'am. Have a very good day. I'll give you till June the 6th, all right?
Thank you.
Well, this man, pay you like June the 6th. Goodman?
Yes. Yes, I'm here.
Great. Let's go. Hold on. Let's go back on the record with Gray. Mr. Gray, I've given you an opportunity to speak to counsel. Have you spoken to counsel?
Yes, sir.
You said no, sir?
Yes, I have, sir.
All right. I'll give you an opportunity. Is that no registration?
Yes, sir.
So this is a misdemeanor here, a $240 fine. That's what you want to plead to? Dismissing the other matters?
Well, after speaking with the councilman, I was explaining to him how difficult it hasn't been a matter of me not wanting to register my car or not having the money to register. The issue is that the car is from Texas and it's on a salvage title. And it's me being a teacher during the day and a security guard during the night. It's more time consuming than I originally realized, trying to do this by myself, getting the car switched over from Texas and getting a salvage title and doing things back and forth through the mail. I've been communicating with Texas and their Department of Motor Vehicles to get the car switched, to get the title so that I can get the inspection here in the state of Michigan to register it. And I ended up sending off the wrong kind of application and fees or whatever. So we've been communicating back and forth in mail, and that stuff just takes time. I'm waiting on them to send the title now. I thought I would have it today, hopefully. And I'm assuming that it'll be here by the end of the week. So I was hoping to get a little bit more time so that I can complete this process effectively. But if not, I was willing to take the other option that the councilman mentioned.
Come back on June the 24th, 2024, at 8:30. All right.
God bless you. Your Honor.
Have a very good day. Best of luck to you.
Thank you. Thank you so much. Thank you, Councilman.
Go back on the record with Ms. Lyles. Ms. Lyles, I've given you an opportunity to speak to council. What's your client want to do, Mr. Baughman?
Judge, we'll take a next best action date. The defendant is going to pay the reinstatement fees, try to her level best to come back with a valid driver's license and any other document. Right, Ms. Lyles? You're on mute. Can you unmute your device, Ms. Lyles?
Yes, yes.
Okay. All right. Is that what you want to do, Ms. Lyles?
Yes.
Everybody's sighing today, like, well, what? What do you want to do?
I'll do it.
Yeah, we definitely want a chance to get our license back, Judge. It's easier than you think, Ms. Lyles. Be encouraged.
Nobody's forcing. All right. You understand what that requires, ma'am? Coming down, it appears you owe $245 reinstatement fees. Bringing $90 down. You have to bring it down to the window. There's no other way I can allow you to do that. It's just special for you, Ms. Lyles. You bring that money in, you pay that money, you wait 48 to 72 hours, and then you approach the Secretary of State and start the process to see if you can get a valid license. If you can't get a valid license, I would ask the Secretary of State for a printout so that when you come back, one of the attorneys may help you read that printout, or they may tell you, every other jurisdiction that is affecting your license. Thank you. So I'm have you back on June 24th, 2024 at 8:30. Okay, you understand what you're supposed to do, ma'am?
Yes. Pay the $90 and go and try to get my license, right?
Yeah, and you're bringing that $90 down to the window down here, all right?
Okay.
On a no insurance proofs, on the state, no insurance proof, and a city, no insurance proof. Ms. Mathis is gonna put it in the computer. The clerk at the window downstairs should know exactly what you're saying, all right?
Okay.
All right, if there's nothing further, come back June 24th, 2024 at 8:30 a.m. Best of luck to you. Have a very good day.
Okay, you too.
All right. All right, Christopher Goodman, Charles Goodman, I'm sorry.
Yes, Your Honor.
Charles Kevin Goodman.
Charles Kevin Goodman.
Good morning to you. You got dates all over the place, you miss. City of Detroit versus Charles Kevin Goodman. Case numbers SP 1539662, counts 1 and counts 2. SP 1553307, counts 1, 2, and 3. SP 1553565, counts 1 and counts 2. SP 1562166, counts 1, 2, and 3. He's not on the docket today. Mr. Baughman, appearance for the record, please.
Harry Baughman for the defendant. Sir, state your name, please.
Charles Kevin Goodman, Sr.
Thank you.
For purposes of arraignment on the warrant.
Please enter a not guilty for the defendant. The defendant waives any more formal reading of the information, complaint, or warrant.
I need more pre-trial basis, man. No, I'll give you the pre-trial. You have the last one, 6/24/2024 at 8:30. Come back on June 24th. We'll have your file and all your documents, all right?
Your Honor, The last time I was in court, on the Zoom, there was I spoke to a lady and was saying that it was a program, far as to help me resolve a lot of issues that I'm having far as residents. I was missing my birthdays because I was forced to move out of my house. And
Did
so
you
the
get,
ticket,
hold on, did you get in contact, did you talk to Street Democracy Court?
no, my phone got cut off. I was,
All right, hold on a second.
I was,
Let me try to get them in, let me try to get them in here, all right?
okay. And what was the program called?
It's Street Democracy Court.
Okay, because I didn't understand it either.
All right, we'll pass the matter. We'll wait until Mr. Patel or somebody from his staff comes in. Gilbert. William Gilbert.
Yes, Your Honor.
Good morning to you, sir. Is this William Jerome Gilbert?
Yes.
What's your date of birth, sir?
6/18/87.
City of Detroit.
Can I approach you, John?
City of Detroit versus William Jerome Gilbert. Excuse me, case number SP 1565109, counts 1 and counts 2. Appearance for the record, please.
May it please the court, Harry Bachman for the defendant. Would you state your name, please, sir?
William Jerome Gilbert III.
So, this is a pre-trial. I do have an offer for Mr. Gilbert. It's,
Does he have valid registration and insurance?
Yes, I have a valid business registration. I don't have a vehicle in my name. The car that I was driving was a rental.
Speak to Mr. Bachman in the breakout room. I'll give you an opportunity, Mr. Bachman, to speak to Miss Snyder.
I have an offer. I'm ready.
He's talking about that was driving a rental car or something. All right. All right. Pass the matter. All right. Go ahead. Let's go. Okay, let's go back on the record with Gilbert. Understanding that he indicated to the court that he was driving a rental car that day. Is it unregistered, untitled, and no insurance misdemeanor, both of them misdemeanors?
Your Honor, I'd have to set it for trial so we can get the facts from the officer. If Attorney Bachman can send me a discovery request via email, you'll pulled up before that date.
Well, I don't think a video would necessarily necessitate that. I mean, unless.
This for Gilbert?
Unregistered, untitled, and no insurance misdemeanor. And he's indicating that he was driving a rental car for some reason. Go ahead, I'll let you speak to what.
The defendant's going to come back with compliance documents. He's got one of the two documents that he's going to need to achieve dismissals of these innocent cases. There haven't been any prior adjournments. Would you adjourn this one time for the defendant to come back with what he needs?
When can you bring it back, Mr. Gilbert?
I can as soon as possible.
You want to come back on Friday or something?
Yeah, that could work.
All right, come back morning, all right, and we'll review the documents and.
What time Friday? Same time?
Same time.
Okay.
Sign in early. He'll be out early.
Okay.
Friday, is the 10th, 2024 at 8:30. All right.
All right.
All right. Nothing further. Have a good day, sir.
All right. Thank you.
Okay. All right, Mr. Little, good morning. Okay. Is there any resolution? Let's find that out right now.
Not at this time, Your Honor, although
Mr. Little.
Officer Green didn't appear. Officer Paramo did.
And what's the position for Officer Paramo? What do we have? How many?
He only has one misdemeanor, the rest are civil infractions.
So let me say this. The issue that we're having is we don't have a jury. All right, the city of Detroit versus Bernard Brandon Little, case numbers SP 1513015, counts 1, 2, and 3, SP 1513029, SP 1556287, counts 1 and counts 2, SP 1556352, counts 1 and counts 2, and SP 1556353, counts 1 and counts 2. Appearance for the record, please.
Good morning, Your Honor. Alexis Schneider for the people, P80322. I have one of the issuing officers present.
Okay, and good morning, officer. Can you state your name for the record and your badge and cover, please?
Yes, sir. Officer Brown, badge number 1410 out of the 11th precinct.
Your Honor, could I get officer to repeat his name? I had the printer going at the start of the time.
Yes, Officer Paramo, badge number 1410 out of the 11th precinct.
Can you spell your last name?
Outside voice.
Oh, louder?
Yeah, because we're over here. That's
okay. Okay, Officer Paramo, badge number 1410.
Spell the last name, please.
P-A-R-A-M-O.
Thank you, sir.
Mr. Little, good morning to you. Can you state your name for the record, please?
Bernard, for the record.
Today is the date and time set for a trial on the matters. Let's deal with the officers that did not show. SP 1556287, counts 1 and counts 2. SP 1556352, counts 1 and counts 2. And SP 1556353, counts 1 and counts 2. I'm gonna, on the court's own motion, I'm gonna dismiss those because the officer did not appear.
For the record, Your Honor, I'd like the record to reflect those matters are dismissed without prejudice, please.
For the record, Your Honor, Edward Taylor appearing with Mr. Little as advisor.
Very well. I'll dismiss the matters and they will be without prejudice. But the officer's gonna have to come with a very good excuse for why he didn't show up today, didn't give any response. But now, nonetheless, those matters will be dismissed. Okay, now, we have the SP 1513015, 2 and 3, and the SP 1302991 left. Mr. Little, the problem that we have here is that we don't have a jury.
Okay. What we say for another date for a jury?
We would have to, but I'm gonna say this. Mr. Okay. On the initial matters, SP 1513015, counts 1, 2, and 3 were all civil infractions. And you entered into an agreement to pay those civil infractions.
Yes, if you allow me to elaborate, John, my honor. Your prosecutor had an issue, and I decided, well, I wanted to figure out what she was going to do in return to me paying that, because I had already come up with an agreement with the courts. So that was like a contradiction to it, because I didn't agree to go back and forth.
Wait, you're confusing me now.
Well, I was confused too.
How are you confused? You set up the payment plan.
I had agreement with the court. As a payment plan, right? I went back up in court.
All right, to silence your device, please.
With the courts to pay it. I got back in court. She didn't want to honor it.
Okay, Ms. Snyder, go ahead.
Your Honor, I believe Mr. Little might be describing just paying civil infractions without coming to court, which is something that citizens are able to do in this jurisdiction. He would have to come to court for the misdemeanor. I don't have an independent recollection of that, but that might be something I would do, not agree to dismiss the misdemeanor for a payment plan. I did share with him before he had his appointed counsel, his license comes back from suspension in 10 days.
I don't want to.
He doesn't want a license.
I don't ever want a license.
He doesn't feel that he needs to even have a license, right?
I
mean, come on, that's what the real is, right?
Thank you, Your Honor.
At some point, though, you wanted a license, didn't you?
Yeah, when I was 12.
And at some point, you were Bernard Little.
No, we never have it.
Never been?
Never been.
So what did your mom name you? When
my mom named me Bernard. That's what she named me.
And where did the Little come from?
I don't know, my slave master, I guess.
Now, that might be true. Now, that might be true.
It may be even come from my tribe.
It may be. You may have a point there. But at some point, your mom, what do you have to say about that, Mr. Taylor?
It's above me,
It's above. So what it is this. He's entered into an agreement to pay civil infractions, 3 of them. I see it here. I think he made a payment for it.
I did, yeah. I stopped paying once I came to court.
All right,
so was denied access to pay.
What do we want to just dismiss the misdemeanor? He's paying a related civil infractions?
I have no objections to that, Your Honor.
I think that. All right. All right, I'm going to dismiss SP 151302991. I am going to note the contradiction in your actions, though.
What's that, sir?
By you paying this, you're admitting that you should have expired plates, that you should have plates and no insurance, or are you just saying, hey, I'm not even going to deal with it. The state and the city is so off base with what they're doing.
Yes.
I don't have time to.
Thank you, Your Honor, for saying it.
I got that. I understand.
Thank
you. Case dismissed, and we don't have a problem anymore. I'm going to waive any warrant. I don't see any warrant fees. That'll be that'll close the matter up.
Everything's closed, Your Honor.
Everything except for he needs to continue on with the payment plan. Very well. And those.
Charles Kevin Goodman.
Good morning to you. You got dates all over the place. You missed. City of Detroit versus Charles Kevin Goodman. Case numbers SP 1539662, counts 1 and counts 2. SP 1553307, counts 1, 2, and 3. SP 1553565, counts 1 and counts 2. SP 1562166, counts 1, 2, and 3. He's not on the docket today. Mr. Baughman, appearance for the record, please.
Harry Baughman for the defendant. Sir, state your name, please.
Charles Kevin Goodman, Sr.
Thank you.
For purposes of arraignment on the warrant.
Please enter a not guilty for the defendant. The defendant waives any more formal reading of the information, complaint, or warrant.
I need more pre-trial basis. No, I'll give you the pre-trial. You have the last one, 6/24/2024 at 8:30. Come back on June 24th. We'll have your file and all your documents. All right.
Your Honor, the last time I was in court, on the Zoom, there was I spoke to a lady and was saying that it was a program as far as to help me resolve a lot of issues that I'm having as far as residents. I was missing my days because I was forced to move out of my house. And
Did
so
you
the
get
ticket,
hold on. Did you get in contact? Did you talk to Street Democracy Court?
no, my phone got cut off. I was.
All right, hold on a second. Let me try to get them in. Let me try to get them in here. All right.
Okay. And what was the program called?
It's Street Democracy Court.
Okay, because I didn't understand it either.
All right, we'll pass the matter. We'll wait until Mr. Patel or somebody from his staff comes in. Gilbert. William Gilbert.
Yes, Your Honor.
Good morning to you, sir. Is this William Jerome Gilbert?
Yes.
What's your date of birth, sir?
6/18/87.
City of Detroit.
Can I approach, John?
City of Detroit versus William Jerome Gilbert. Excuse me, case number SP 1565109, counts 1 and counts 2. Appearance for the record, please.
And please the court, Harry Baughman for the defendant. Would you state your name, please, sir?
William Jerome Gilbert III.
So this is a pre-trial. I do have an offer for Mr. Gilbert.
Does he have valid registration and insurance?
Yes, I have a valid business registration. I don't have a vehicle in my name. The car that I was driving was a rental.
Speak to Mr. Baughman in the breakout room. I'll give you an opportunity, Mr. Baughman, to speak to Miss Snyder.
I have an offer. I'm ready.
He's talking about that was driving a rental car or something. All right. Pass the matter. All right. Go ahead. Let's go. Okay, let's go back on the record with Gilbert. Understanding that he indicated to the court that he was driving a rental car that day. Is it unregistered, untitled, and no insurance misdemeanor, both of them misdemeanors?
Your Honor, I now suspended for trial, so we can get the facts from the officer. If Attorney Bachman can send me a discovery request via email, you'll pull it up before that date.
Well, I don't think a video would necessarily necessitate that. I mean, unless.
This for Gilbert?
Unregistered, untitled, and no insurance misdemeanor, and he's indicating that he was driving a rental car for some reason. Go ahead, I'll let you speak to what.
The defendant's going to come back with compliance documents. He's got one of the two documents that he's going to need to achieve dismissals of these innocent cases. There haven't been any prior adjournments. Would you adjourn this one time for the defendant to come back with what he needs?
When can you bring it back, Mr. Gilbert?
I can as soon as possible.
You want to come back on Friday or something?
Yeah, that could work.
All right, come back morning, all right, and we'll review the documents and.
What time Friday? Same time?
Same time.
Okay.
Sign in early. You'll be out early.
Okay.
Friday, is the 10th, 2024 at 8:30. All right.
All right.
All right. Nothing further. Have a good day, sir.
All right. Thank you.
Okay. All right, Mr. Little. Good morning. Okay. Is there any resolution? Let's find that out right now.
Not at this time, Your Honor, although
Mr. Little.
Officer Green didn't appear. Officer Paramo did.
And what's the position for Officer Paramo? What do we have? How many?
He only has one misdemeanor, the rest are civil infractions.
So let me say this. The issue that we're having is we don't have a jury. All right, the city of Detroit versus Bernard Brandon Little. Case numbers SP 1513015, counts 1, 2, and 3. SP 151302991, SP 1556287, counts 1 and counts 2. SP 1556352, counts 1 and counts 2, and SP 1556353, counts 1 and counts 2. Appearance for the record, please.
Good morning, Your Honor. Alexis Schneider for the people, P 80332. I have one of the issuing officers present.
Okay, and good morning, officer. Can you state your name for the record and your badge and cover, please?
Yes, sir. Officer Brown, badge number 1410, out of the 11th precinct.
Your Honor, could I get officer to repeat his name? I had the printer going at the part of the time.
Yes, Officer Paramo, badge number 1410, out of the 11th precinct.
Can you spell your last name?
Outside voice.
Oh, louder?
Yeah, because we're over here, that's.
Okay. Okay, Officer Paramo, badge number 1410.
Spell the last name, please.
P-A-R-A-M-O.
Thank you, sir.
Mr. Little, good morning to you. Can you state your name for the record, please?
Bernard, for the record.
Today is the date and time set for a trial on the matters. Let's deal with the officers that did not show. SP 155-6287 counts 1 and counts 2. SP 155-6352 counts 1 and counts 2. And SP 155-6353 counts 1 and counts 2. I'm gonna on the court's own motion, I'm gonna dismiss those because the officer did not appear.
For the record, Your Honor, I'd like the record to reflect those matters are dismissed without prejudice, please.
For the record, Your Honor, Edward Taylor appearing with Mr. Little as advisor.
Very well. I'll dismiss the matters and they will be without prejudice. But the officer's gonna have to come with a very good excuse for why he didn't show up today. He didn't give any response. But now, nonetheless, those matters will be dismissed. Okay. Now, we have the SP 1513015 2 and 3 and the SP 13029 left. Mr. Little, the problem that we have here is that we don't have a jury.
Okay. What we said for another date for a jury?
We would have to, but I'm gonna say this. Okay. On the initial matters, SP 1513015 counts 1, 2, and 3 were all civil infractions. And you entered into an agreement to pay those civil infractions.
Yes, if you allow me to elaborate, Your Honor, my honor. Your prosecutor had an issue with it, and I decided, well, I wanted to figure out what she was going to do in return to me paying that, because I had already come up with an agreement with the courts. So that was like a contradiction, because I didn't agree to go back and forth.
Wait, you're confusing me now.
Well, I was confused too.
How are you confused?
Because
you set up the payment plan.
I had agreement with the court. I had a payment plan, right? I wound back up in court.
All right, to silence your device, please.
With the courts to pay it. I got back in court. She didn't want to honor it.
Okay, Ms. Snyder, go ahead.
Your Honor, I believe Mr. Little might be describing just paying civil infractions without coming to court, which is something that citizens are able to do in this jurisdiction. He would have to come to court with a misdemeanor. I don't have an independent recollection of that, but that might be something I would do, not agree to dismiss the misdemeanor for a payment plan. I did share with him before he had his appointed counsel, his license comes back from suspension in 10 days.
I don't want to.
He doesn't want a license.
I don't ever want a license.
He doesn't feel that he needs to even have a license, right?
I
mean, come on, that's what the real is, right?
Thank you, Your Honor.
At some point, though, you wanted a license, didn't you?
Yeah, when I was 12.
And at some point, you were Bernard Little.
No, we never have it.
Never been?
Never been.
So what did your mom name you?
My mom named me Bernard. That's what she named me.
And where did the Little come from?
I don't know, my slave master, I guess.
Now, that might be true. Now, that might be true.
It may be even come from my tribe.
It may be. You may have a point there, but at some point, your mom, what do you have to say about that, Mr. Taylor?
It's above me,
It's above. So what it is this, he's entered into an agreement to pay, civil infractions, 3 of them. I see it here. I think he made a payment toward.
I did, yeah, I mean, I stopped paying once I came to court.
All right,
There
so.
was denied access to pay.
What do we want to just dismiss the misdemeanor? He's paying a related civil infractions?
I have no objections to that, Your Honor.
I think that. All right. All right, I'm gonna dismiss SP 151-30291. I am gonna note the contradiction in your actions, though.
What's that, sir?
By you paying this, you're admitting that you should have expired plates, that
No,
you
what
should
I'm
have
doing
plates
is-
and no insurance, or are you just saying, hey, I'm not even gonna deal with it, the state
What
and
I'm
the
doing-
city is so off base with what they're doing.
Yes.
I don't have time to.
Thank you, Your Honor, for saying
Okay,
it. Yes,
I
sir.
got that, I understand.
Thank you.
Case dismissed, and we don't have a problem anymore. I'm gonna waive any warrant, I don't see any warrant fees. That'll be that'll close the matter up.
Everything's closed, Your Honor.
Everything except for he needs to continue on with the payment plan.
Very well.
And those matters will either, he'll either pay them or they'll go into default again and they'll come after him civilly for the money. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
Thank you.
Thank you.
Hey, take care, everybody.
All right. Thank you, Mr. Taylor.
Thank you, Your Honor.
Did you tell Mr. Judge Baltimore what I said?
I did. No, you know, I did something.
Why not?
You done had me down there all day.
All right. What's that? He's got this, he just woke up one morning and just,
He was chill as a cucumber too at the stop. He was nice.
He's told her.
Yeah, I was shocked. I was ready to watch it. And I was like, no, he's fine.
They don't have, you didn't give them any material.
Yeah, not
All right,
today.
officer.
Thank
You be safe out there, all right?
Thank you.
All right. Mr. Let's see, I did get a response, Mr. Goodman.
You good, Judge?
Yeah, we're good.
Okay.
That worked out, everything worked out.
Okay, okay.
All right, let's go back on the record with Goodman. Goodman, I have they're held up in meetings now. Usually we have somebody available, but I can forward the information if Mr. Bachman doesn't mind going over it with you to sort of is an outline of what requirements are. This is street outreach court, Mr. Bachman.
Yes, Your Honor. I'll be happy to do that.
All right. Oh, that's not it. Okay.
Since I've been in court.
I need a good email for you, Mr. Bachman.
HRBESQ@Yahoo.
hrbesq@yahoo.
Yes.
See if you got that handout.
Not yet. Yes, Your Honor, I'm in receipt.
All right, Mr. Goodman, go in the breakout room. Mr. Bachman is in receipt of the handout from the street outreach democracy support. Let him go over that with you and see if some of those things are, there's some steps that you need to take. See if you're willing to consent to those things so we can get you in the program, all right? And I need a good phone number from him if he is willing for that, all right?
Yes, Your Honor.
Join the breakout room and speak to Mr. Bachman. All right.
Mr. Goodman.
Mr. Goodman, giving you an opportunity to speak to council. You had an opportunity to go over, albeit not with the Street Democracy Court people themselves, but Mr. Boffin, I'm sorry, he's familiar with the program and he's a very, very good lawyer. Is this something that you're interested in committing to, sir?
Yes, Your Honor.
All right. And I always say this for people that come into my court in your situation. I use a quote that I stand by, I believe in. I've used it in my own life when I'm in facing challenges. But Dr. Martin Luther King says, the ultimate measure of a man is not where he stands in moments of comfort and convenience, but where he stands in times of challenge and controversy. I do understand that this may be one of the more challenging times in your life. I do believe that there is light at the end of the tunnel. And I believe that the man upstairs puts a lot of different tests for whatever reason in front of us, and this is your test. I hope that you rise to the occasion, put this behind you, and live to see better days. I believe if you believe in that, you will. And I just wish you the best of luck, all right?
I appreciate that, Your Honor.
All right.
Thank you, Your Honor.
We're gonna get a 150-day date. I'm trying to wait on a Street Democracy Court so that I can give you that and you don't have to come back. I do need a good phone number from you, sir.
You ready?
Yes.
It's 313-989-7247.
Is there a number on that document, Mr. Baughman? And can you email that document to Mr. Goodman?
I did.
Okay.
Did you receive that, Mr. Goodman?
Well, I have slow reception, but it should be in my Gmail. I don't see no notification yet.
Let me look and make sure it's in my sent documents. Yes, Your Honor. That was successfully sent to the defendant.
And is there a number on that document?
There is a phone number, you mean?
Yes.
Yes, Your Honor. There's a phone number for Mr. Patel.
Okay, very well. I'm gonna ask you to call Mr. Patel. That's 2024. Ask you to call Mr. Patel and get in touch with him. I need you to give him the date of October 7th, 2024. At 8:30 is going to be your pre-trial date. Hopefully by that time, you'll have completed the action plan and things are much different in your life and better for the better. Okay.
Yes, Your Honor. Thank you, Your Honor.
Your Honor, I just got a failure notice from my email. Just give me a moment to resend that and let's make sure you get it, please.
What's your email address, Mr. Goodman?
CHIEFROCKA46@gmail.com.
So I have Chief Rocka 46.
Yes.
That's your handle, huh? Chief Rocka.
Yeah, I'm stuck in my old ways. I don't know how to do the internet so much like that.
What's the okay, so I won't divulge it. I won't go into what that actually means then, since he said it's stuck in his own ways. That doesn't sound too good, does it?
I would not. That was my old football handle when I used to play back in high school.
Oh, well,
Right.
there we go. You know, I'm sure you probably think that you can get out there and still do it a little bit, huh?
Absolutely not.
I reset that.
You have the correct one, Mr. Boffman?
Yeah, I got it. I think I got it right, Mr. Goodwin. Can you check? I know you're out in the streets, but you should have an email for me.
Was that a different address than you put it in the first time, Mr. Boffman?
Yes, it was, and I just got another error message. I'm working too fast and misspelled the name again. I'm sorry. I'm going to send it one more time.
I have, and tell me if this is correct, Mr. Goodman. CHIEFROCKA 46 at gmail.com.
That's correct.
I'm gonna forward it to you.
He might be spelling chief wrong.
Yeah, twice. It did go through correctly this time, though.
Well, you said that both times last time, Mr. Boffman.
I know.
Let's wait on the error message.
First time I sent it to Chief Ricka, and then I sent it to Chief Rocka, but I put in an extra F.
His email. All right, I sent it.
Thank you.
And I don't mess up. No. All right. Listen, Mr. Goodman, if it's nothing further, sir, your next court date is going to be 10/7/2024. I'm going to contact Mr. Patel as well. I did message him just to make sure that we, that everybody's on the same page here, because this is not traditionally how we would handle this. But he indicated that he wants to speak with you. We'll let you speak, and if it's something that happens, then he knows how to get in touch with the court and get you back in front of us. All right, and you can always Zoom in as well. All right.
Thank you, Your Honor.
All right, thanks.
All right, Mr. Goodman, best of luck to you. Have a very good day.
Every day in the USA, people find themselves in court.
All right, so this is program publication was back for lab following her 22-111 dash.
Okay, sorry, Miss Adams. All right, so file number 22-21116 FH, 23-21646 FH, 24-21680 FH, 24-21681 FH, and 24-21683 FH. I have James Daly appearing on behalf of Mr. Ladd, and I have Amanda Wagner appearing on behalf of the people. So, Mr. Ladd, it's a pretty lengthy pre-sentence report. Have you had enough time to read through it?
Yes.
Have you had enough time to speak with Mr. Daly?
Yes.
Have you asked all the questions you have of him?
Yes.
Are you satisfied with Mr. Daly as your attorney and the advice that he's given you?
Yes.
All right, so Mr. Daly, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
Okay.
Do you as well, Ms. Wagner?
No, Your Honor.
Okay. Do you, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Had a juvenile record and a couple prior misdemeanors, but nothing other than that. All right, so I did review the guidelines. The only change I'm going to make is on file number 22-21116FH. OV1 was scored at 20 points, and I understand why it would have been scored at 20 points, but I spent quite a bit of time trying to review the nature of the chemical used in this case. And for definitions, the definition in OV1 and OV2 are a little bit different. So I believe that pepper spray falls under chemical irritant device, which wouldn't be scored under OV1. Do you agree with that, Ms. Wagner?
I do, Your Honor.
Mr. Daly? And it doesn't impact the guidelines a lot, but it takes the OVs to 55, which would be 2 to 17 months. Other than that change, Mr. Daly, do you, okay, so that guideline would be 2 to 17 on file number 22-21, somebody's talking. I don't know who's talking, it must have been Ms. Adams. All right, so, oh, it's probably my office, because I wasn't sure where Ms. Wagner was going to come in at, so I have my office open. All right, so on 22-21116FH, we've computed the minimum sentencing guidelines to be 2 to 17. On 23-21646FH for the police officer assaulting, resisting, and obstructing, 2 to 17 for the guidelines. 24-21681FH on the police officer RNO, 2 to 17 months. 24-21683FH for home invasion second degree, 43 to 86 months. And 24-21683FH for the felonious assault, 10 to 23 months. So do you agree with all those computation guidelines, Ms. Wagner?
I do, Judge.
And Mr. Daly?
I do.
All right. So, Mr. Daly, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. I think for the very first time in Mr. Ladd's life, as he sits here today, he's got a chance. He was born without a chance. He was born without anybody showing him at all about how people should live and treat each other. That was an absolute total void in his life. And the system has known about that for a long time, but he's never been properly positioned in the system to get the help he needs. When Mr. Ladd and I talked yesterday, he knows that for him, this can be a fresh start. He's got things he would like to do. He's tired of living the way he has been living. He's tired of being treated the way he's been treated. And he feels bad about how he has treated other people as a result of really not knowing any better. We may be sitting here talking to somebody that's 18 years old, but they're a lot, or over 18, but they're a lot younger than that when it comes to knowing about real life, how people should treat each other, and what should happen. The way Zach has been raised, in my opinion, means nothing here, is absolutely criminal. We should have a law that punishes parents for not raising their children properly in any respect at all. And he hasn't had that benefit. And by not having that benefit, he is here today. Society pays a price. We all pay a price because of what has happened in the past. But he can learn. He can be and wants to be a good human being. His problem is every shred of self-esteem he ever had was ripped away from him from the day of his birth. He was never known to have any, never known he could have any. And what happens when you don't have any self-esteem? You try to demand respect. And if you get respect through the end of a baseball bat or whatever you have to do, that's what you do. He knows those behaviors are going to get him no place. He knows that he has no life the way his life is going right now. And I believe he's got the potential and the capabilities for reformation and to become a productive member of our society. I just wished it didn't take a prison visit, a prison sentence to do this. But unfortunately, this is what we have to deal with. But I'm pretty positive that Mr. Ladd is going to do everything he can in the future to be a better person, because he wants to be, and he knows that he hasn't been. Thank you, Your Honor.
Mr. Ladd, is there anything you want to say on your own behalf? Sure. So why don't you stand up closer to the podium? And then do you mind, just for purposes of the record, that when you're done reading it, if we get a copy of it from Ms. Spade?
Yes, ma'am.
Is that okay that we do that? Okay, so go ahead.
So growing up and growing through life, I was never dealt a good hand. I grew up with a single mother who struggled to get by due to my father always going in and out of jail and prison. When my dad was around, he was my biggest role model and person I looked up to. As I'm getting older, I realized looking up to my dad and following in his footsteps is going to get me nowhere but where he is at right now and where I'm currently headed. I don't want to live life behind bars like everybody I know. I'm 20 years old, smart, and know what I need to do, but don't know how to do it. I'm not asking for leniency. I am just asking the courts to take into consideration who raised me and let me think that the things that I've been doing were normal or cool. I want to apologize to my victims due to the fact that what I've done is now okay. I am asking the courts to do what's good for my youth and my future.
Okay. So Mr. Daly, can Ms. Adams come in and get a copy of that and I can give it back to him? So just set it right on that table. Ms. Adams, if you could come get a copy of that to make for Ms. Spade. All right, Ms. Wagner, is there anything you'd like to say on behalf of the people?
No, Judge, I would just say that that's probably one of the more genuine statements from a defendant at sentencing that I've heard before, and one that seems to be taking accountability for his actions, and I personally appreciate that. And I would just ask the court to follow the sentencing agreement that we have.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication of the law, and the protection of society. So Mr. Ladd, I can remember when I was a young attorney and one of the newer attorneys when I first came here, and one of the first clients I had was your dad. And I remember when your mom was pregnant with you, you know, and so I understand everything you and Mr. Daly said, and I recognize that to be true. I know that your mom struggled and you have with you and your sister, and she did it alone, and your dad was there and then he was in jail, you know, and that's not a good role model for a kid, but it is what you knew. Right? And it, as a former teacher, because I was a teacher before I became a lawyer and I worked in school districts, the hardest thing for me is seeing these kids who are placed in situations they didn't choose and learning from those situations. So yes, you are smart. You have a strong will to do better. So I think you can do that. And you can break that cycle, because that's what it's about, right? Breaking the cycle. I'm sorry that we're here today with these charges in a prison term, but there are services available through Michigan Department of Corrections. There are resources, there are mentoring programs. So I hope that you take that time period, because there was a sentencing agreement entered into to, you know, get your diploma, get some certificate. I think there's welding programs. Like, I mean, there's a lot of certifications you can get that will help you when you get out to just start fresh. You know, because I think inherently you are a good person who wants better than what you had. Do you have kids? No. Okay, good for you. But going forward, you don't want your kids to have this lifestyle, do you? No. And go through what you went through. And, you know, your parents loved you and they did the best they could, but, you know, it wasn't good enough for you. You deserve better. Okay. So the Cobb's agreement, or the sentencing agreement, was on the 24-21683, correct? And that's the home invasion file.
Yes, I
And-
believe so, Judge.
And the sentencing agreement would be 60 months.
Yes, Judge.
Okay, now there's some lesser files that obviously 60 months won't apply to. And Ms. Wagner, some of the 2 years, the guidelines were low enough. He's already got kind of the credit. Do you have any objection if on those 2-year R&O files, I gave him credit for time served?
I do not, Judge.
Mr. Daly, any objection? Okay. So on file number, let's start. I just want to make sure I don't get it messed up. On file number 22-21116 FH, which is a assault with a dangerous weapon. On that file, it's the sentence of the court that you will serve 1 year, 11 months to 4 years with the Michigan Department of Corrections with credit for 250. Don't we have more credit? Didn't we adjourn this? No.
No.
Okay, 252 days credit for time served. There is a $68 state cost, $130 crime victim rights fee. During your incarceration, you're to obey and comply with all programming recommended by the MDOC. On file number 23-21646 FH, which is the police officer assaulting and resisting and obstructing, I'll give you credit for time served of 161 days, okay? And there's $68 in state costs. No, I think, well, yeah, $68 in state costs, $130 crime victim rights fee. On file number 24-21680 FH, that's the domestic violence, which is a 93-day misdemeanor, give you credit for time served of 252 days. Why does he only have 161 on file number 23-21646? Is that a bond I didn't switch back?
Let's see. $61. I just have a bond, 11,000 cash surety bond, 12/1/23 to 5/10/24.
Hold on.
646 file.
646.
Yeah.
I'm sorry, I'm gonna step back on file number 23-21646. I'm going to give them credit for the. And went back to today, and then did that. Okay. Why did you? That's weird because you're already in jail. It doesn't make sense to me. I'm gonna give you credit for 252 days on that one. Sorry, I'm gonna change that to 252 days credit. And then, as I said, on 24-21680 FH, I'll give you credit for time served at 252 days. There is a $75 crime victim rights fee and a $50 state cost. We don't collect through MDOC on the misdemeanor fines and costs. That's something that'll just be here when you get out. All right. They only collect on the ones you go to prison for. Okay. It's my understanding. All right. So on file number 24-21681 FH, which is another police officer assaulting, resisting, obstructing, and a domestic violence sentence of the court that you will receive credit for 409 days already served. And there is $68 in state cost, $130 crime victim rights fee, and then there's $50 state cost on the misdemeanor domestic violence. There's no probation, no sentence for prison on that one. So then we get to file number 24-21683 FH, which is the home invasion, second degree, and felonious assault. Hold on. 10/9/1, 23. Yeah, you didn't even get arrested on that one until September 1 of 23 to present. So your credit for time served on that file is 252 days. Sentence of court that you will serve 60 months. Well, it's 5 years to 15 years. So it's 60 months is what you're serving. And then the tail is 15 years. I'll give you credit for 252 days already served. Both counts. And then I'm going to order that these sentences be served concurrent because that's within the discretion of the court. So they're not consecutive. Do you understand that? Okay. So there is $130 crime victim rights fee, $68 in state costs for each count. So that's a total of $136. I'm going to order that all of those state costs and crime victim rights fees are payable once you're placed on parole. Anything I'm missing in there, Miss Holly, because there was a lot.
Yeah, you did good, but the felony, I don't think you said felonious assault is the same, but it's a 4-year max.
Oh, yeah. And on the felonious assault, the sentence is, it doesn't. Oh, I'm sorry. And on the felonious assault, you'll serve 1 year, 11 months to 4 years with the Michigan Department of Corrections. And as I said, they run concurrent to each other and concurrent to all the other files. So everything's going to run together. All right. Anything else now, Ms. Holly?
I don't think so.
I think I got it all. So, Mr. Ladd, I gave you a break and by allowing them to run together and then not putting you in prison on some of the smaller ones because your guidelines were low enough that you basically serve the time under the guidelines, okay? So Mr. Ladd, there's a bunch of paperwork now. You do have the right to appeal this sentence. So my bailiff's gonna give you a set of paperwork for each file. And I just need you to initial and date each one to indicate you received it, okay? And then the other copies are for you and you're gonna have like set for each file. If you wish to appeal this sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right? There's another one. You got it? All right. Thank you.
Yeah.
So Mr. Ladd, I wish you the best of luck. And when I see you in a couple years, I want to hear you're doing good and you got a job. All right. Good luck to you.
See you later, Zach.
Okay. So I have a gentleman in the jail room and I'm going to send you a request to unmute your device. Thank you. Sir, what is your name?
Hassan Singleton.
All right, let me grab your paperwork. Did you find Mr. Phelps?
I have not gotten Mr. Phelps.
That's really weird because he showed up for everything.
Let me yell for the hall, in the hall.
All right, I'm gonna call it real quick. Miss Underwood, I'll call it real quick so you can get on your way.
I'm gonna check the hallway, but.
Okay, I don't think he's out there. All right, This is in the matter of the people of the state of Michigan versus Mick James Phelps. File number 24-21692FH. I've Ron Underwood appearing on behalf of Mr. Phelps. So Mr. Phelps appeared for his pre-sentence interview. And so I'm somewhat surprised. Ms. Walsh, have you heard anything on him?
I haven't. I'm surprised he's not there or on Zoom.
Okay. So what I'm going to do, Ms. Underwood, for you only, is I'm going to adjourn the sentencing.
Okay.
Because I'm surprised he didn't show.
I am too.
Because so I'm going to adjourn Mr. Phelps. Ms. Adams, do I have a date available next week?
Not really, unless we do 2 p.m. maybe on May 17th.
What about the 23rd or 24th?
Can't do the 24th, 23rd is just about as bad.
So May 24 at 8:15?
We cannot do the 24th, Judge. May 23rd?
No. May 23rd at 8:15?
We do have 10 that morning.
Do we have anything later in the morning?
You have
I
a
mean,
10
is that
o'clock.
busy?
You have a 10 o'clock review. And then a 10:30 hour-and-a-half evidentiary.
I'm gonna set it for May 23rd at 8:15. It's gonna be a busy morning though, Miss Underwood.
They all are, Your Honor.
All right, and Miss Adams, can we re-notice that? And Miss Underwood, can you get a hold of him then?
Thank you.
All right, thank you, Miss Underwood.
And when we can get Mr. Maps, Your Honor, Ms. Berta and I and Mr. Maps are already on that.
And I'm just waiting for the jail to bring him in.
Thank you.
All right. Okay, so this is in the matter of the people of the state of Michigan versus Hassan A. Singleton. File number, file number 24-21731FH. Mr. Singleton, looks like you were picked up on April 29th last week. And you had requested court-appointed counsel. We put it out for today. And Mr. Phelps is here. Okay. So Mr. Singleton and Mr. Dagger-Margosian, I did receive a report from Mr. Stevenson dated May 10 of 24 that we received it. Let me see here. And basically it alleged Mr. Singleton failed to show for his PSI interview on March 4 and March 7. He confirmed both appointments, so he was in contact with Mr. Stevenson, but he was unable to complete the PSI set for sentencing on May 10. Mr. Stevenson, now that we have him in custody, would like to prepare the pre-sentence report. Is Mr. Stevenson here today?
He's zooming on in the other court.
So Mr. Dagger-Margosian, I realize he's been in jail for about 8 days, but I'm gonna guess Mr. Stevenson did not have enough time to prepare a pre-sentence report. So I'm going to reset this for sentencing, Mr. Dagger-Margosian. Ms. Adams, I'm looking for a sentencing date about 6 weeks out.
All right, June 21st at 8:15.
Mr. Dagger-Margosian.
That's fine, Your Honor.
All right, so Mr. Singleton, Mr. Stevenson from the Michigan Department of Corrections is gonna come over. You talk to him on the phone. He's gonna come meet with you and he'll prepare a report. We'll get the report to Mr. Dagmar-Gosian and then we'll see you back on that date for sentencing, okay?
Can I get a PR bond so I can, I'll do whatever, but I can't sit in here. I come and do a piss test, whatever I have to do, but I wasn't in town when I had to do the piss test, but I'll do whatever I have to do to come and do whatever. But I can't sit in here for that long, please. I've been in here for 14 days. I've been in here since last month on the 27th, 28th. But I'll do whatever to make sure I come and piss. But again, high habit, I will lose that to make sure I can see my grandma again, see my kids again. I'll do whatever. But being in here, I had the worst time ever.
Judge, when he initially was released, he failed a drug screen. Then I did meet him out in the hallway. We're going to do drug screening at a reduced rate. He still did not show. And then when he was finally arrested, he tested positive over at the jail for THC, meth, and also cocaine.
Yeah, and this time I won't.
So, Mr. Singleton, I had released you and set up testing and everything so that you could do the things that you were just talking about, and you failed to comply with any of our requirements. So I do feel that you are a risk and that you will not appear. I'm not going to release you on a bond. You will stay in jail until we come back for sentencing. Thank you.
Your Honor, may I speak? I understand the court's room. Can I just speak with him in a breakout room?
Sure. All right, Mr. Singleton, I'm going to open up a breakout room with you and Mr. Dagmar-Gosian. And then you're all set.
Thank you, Judge.
All right, so we do have Mr. Phelps. So Mr. Phelps, why don't you come on up?
Your Honor, still got that Singleton or whatever in there?
Hassan, yeah, we're done with him, so.
Oh, you are? Okay,
yeah.
I'll get him out of there.
Okay, thank you.
Thanks.
Bye. Mr. Singleton, you're outside. You can go.
I'm not gonna last in here 6 weeks. I'm not a person that goes on a run.
Mr. Singleton, we're done. I'm gonna mute you and you go ahead and go back to your block. All right, the record should reflect and this is back to sign copy of the notice of right to appellate review. Just having a seat in the hallway. And Mr. Singleton, go on. So Mr. Phelps, just wait in the hallway and we'll see you back. And Mr. Post will come speak with you.
Mess it up one time, I get 6 weeks, bro. This shit don't make no sense. I'm not gonna
Well, you should have showed up when you were supposed to. Okay, I got another. So you got the phone number?
Yep.
All right. So Miss Holly has the phone number for you, Miss Walsh.
I've got someone here as Irene's phone. Could you join us, please?
Sorry.
All right. Have I got Antonio and Ana Lopez?
Yes.
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 Okay.
I'm sorry. Can you hear okay?
Yes.
Okay.
This case is Ally Bank versus Ana
Yes.
and Antonio Rodriguez Lopez. Vivian, you're on mute.
Thanks for reminding me. Este es el caso de Ally Bank versus Ana y Antonio López. Rodriguez Lopez.
The file is 211102GC.
El número de caso es 21-110-2 GC.
With us this morning is certified court interpreter Vivian Montero.
Con nosotros esta mañana está la intérprete jurídica Vivian Montero.
This case has a very long history
Este caso tiene un historial muy largo
of problems,
de problemas.
and Ms. Montero, I think, has been here to help us in the past.
Y creo que la señora Montero estuvo con nosotros anteriormente para ayudarnos.
I'm going to take a moment and swear her in as an
Voy a-
interpreter.
Voy a pedir que ella preste juramento como intérprete.
Do you swear or affirm to the best of your ability you will interpret these matters from Spanish into English and English into Spanish?
I do.
All right, this matter is scheduled for 11:30 this morning.
Este caso está programado para las 11:30 de la mañana.
I scheduled the hearing
Yo programé la audiencia
when the defendants filed a motion for installment payments.
cuando los demandados presentaron un pedimento para pagos a plazos.
As I said, this case has a long history.
Como mencioné anteriormente, este caso tiene un historial muy largo.
And I'm going to just wait here. I'll put you each in the waiting room. We have to wait for the law firm that represents Ally Bank to appear. And that's in the next 7 minutes.
Tenemos que esperar el abogado que representa Ally Bank en los próximos 7 minutos. Les voy a colocar en la sala de espera.
So don't go away.
No se vayan.
I'm going to put you in a waiting room, and as soon as they appear, I'll bring you back.
Les voy a colocar en una sala para grupos pequeños y tan pronto que lleguen ellos, les voy a traer nuevamente.
Thank you, Vivian.
You're welcome.
This is file number 211102GC.
Este es el número de caso 211102 GC.
It's entitled Ally Bank
Está titulado Ally Bank
versus Ana Lopez and Antonio Rodriguez Lopez.
versus Ana López y Antonio Rodríguez López.
They are both present by Zoom.
Los dos están presentes por Zoom.
Also present is our certified interpreter, Vivian Montero.
También está presente nuestra intérprete certificada Vivian Montero.
They were here a little early,
Ellos llegaron aquí un poco temprano.
so I set forth the introduction of the case.
Ya presenté el caso
And had Ms. Lopez sworn as an interpreter. Excuse me, Ms. Montero sworn as an interpreter.
y la señora Montero prestó juramento como intérprete.
Joining us now is attorney Natasha Dixit.
Que nos acompaña hoy licenciada Natasha Dixon.
Dixit.
I'm sorry, Dixit.
Good morning.
Buenos días.
This case has a long history.
Este caso tiene un historial largo.
It has 7 pages of notes
7 páginas de apuntes,
going back to 2021.
retrocediendo o remontando al 2021.
The original debt was pretty large for district court.
La deuda original fue bastante grande para el Tribunal de Distrito.
$18,174 was the amount of the claim.
El reclamo fue por el monto de $174.
The judgment actually entered in 2022 in March,
Se asentó la sentencia el marzo de 2022
in the amount of $16,514
por el monto de $16,514
and 65 cents.
y 65 centavos.
It took a long time to get to that point.
Se tardó bastante tiempo para llegar a ese punto.
There was a consent judgment with repayment agreements.
Hubo una decisión por consentimiento con un acuerdo de pago.
There was a previous payment plan for $50 a month.
Hubo un plan de pagos anteriormente de $50 al mes,
which is quite generous on a debt of this size.
que es muy generoso por una deuda de ese tamaño.
And the defendants kept failing to make the payments.
Y los demandados no realizaban, no efectuaban los pagos.
And the plaintiff filed an affidavit of non-compliance,
Y la demandante presentó una declaración jurada de incumplimiento,
which set aside the installment payment agreement
que suspendió el acuerdo por pagos.
that may have happened more than once.
Eso pudiera haber pasado más de una vez.
So the plaintiff began garnishing somebody's wages at Precision Speed Equipment.
Entonces, la demandante empezó a embargar el salario de alguien, el Precision Speed Equipment.
And nobody likes a garnishment. No defendant likes a garnishment.
Nadie le gusta que le embargan el salario. Ningún demandado quiere que le embargue el salario.
Because it takes a large portion of your net wages
Porque quita o saca una gran suma de los ganancias netos
and leaves the defendant with not much money for anything else.
y deja el demandante sin mucho dinero para otra cosa.
It's good for the plaintiff
Es bueno para la persona presentando la demanda
because it makes regular and substantial payments on the judgment.
porque impone pagos con regularidad sobre la decisión del caso, el monto.
Ms. Dixit, thank you for joining us. I scheduled this hearing.
Licenciada Dixon, gracias por acompañarnos. Yo programé esta audiencia.
Thank you, Judge. And you're able to join us by Zoom, so I'm not dragging you all the way out here to Centerville.
Y puede unirse con nosotros por Zoom, así que no tiene que presentarse en persona aquí en Centerville.
But I thought it would be safest to have a hearing
Yo creía que sería mejor tener una audiencia
because the defendants enter an agreement and then they fail it.
porque los demandados llegaron a acuerdo y no cumplieron.
We enter another agreement and they fail it.
Ingresamos en otro acuerdo y no cumplen.
And I don't really want them to be stuck with a very large garnishment.
Y no quiero que ellos tienen que quedarse con una embargación de salario muy grande.
With the assistance of their daughter, they did file a motion for installment payments.
Con la ayuda de su hija, presentaron un pedimento para un plan de pagos.
They offer $100 per month
Están ofreciendo $100 al mes,
which is $1,200 per year.
que es $1,200 al año.
And at that rate, it would take about 15 years to pay this debt off.
A esta tarifa tardaría 15 años en pagar esa deuda por su totalidad.
Ms. Dixit, do you know what the current balance on the debt is?
Yes, Judge.
Licenciada Dixit, ¿usted sabe cuál es el saldo pendiente ahora? Sí, su señoría.
It is $13,393.02. I'll repeat that. It's $13,393.02.
13,393,02 centavos.
That's probably in part because of these garnishments.
Probablemente es así en parte debido al embargo de salario.
Yes, Judge.
So the plaintiff is now offering $100 per month. Excuse me, the defendant is offering $100 per month.
Entonces, los demandados están ofreciendo pagar $100 al mes.
What is your client's position regarding that, Ms. Dixit?
¿Cuál es la postura de su clienta referente a esto, licenciada Dixit?
Judge, we are fine with that.
Estamos bien con eso, su señoría.
We just ask them to make consistent payments.
Solo pedimos que ellos hagan pagos consistentemente.
Otherwise, we just go back to the garnishment, Judge. So
De lo contrario, vamos a pasar al embargo de salario nuevamente.
but the amount is fine with us, Judge.
Pero estamos bien con el monto, señoría.
Mr. and Mrs. Lopez,
Señoras López,
it's very important that you make these payments.
es de suma importancia que ustedes efectúen esos pagos.
Every time you stop making the payments,
Cada vez que dejan de efectuar pagos,
they pursue a garnishment again.
ellos proceden con embargar el salario nuevamente.
And if we enter this agreement again,
Y si llegamos a este acuerdo nuevamente
and it fails again,
y no cumplen,
I'm inclined to just leave the garnishment in place.
voy a estar inclinado a dejar el embargo de salario tal como es.
And that might cause you to declare bankruptcy,
Eso puede ocasionar que tienen que declararse en bancarrota
in which case the plaintiff wouldn't get any money.
y así la demandante no recibiría nada de dinero.
Whose check is this garnishment coming out of?
¿A quién está embargando el salario?
A mí, Antonio.
Mi, Antonio.
Can you make consistent $100 per month payments?
¿Usted puede efectuar pagos de $100 al mes de manera consistente?
Sí.
Yes.
Pero tengo otra pregunta.
But I have another question.
Yes.
Yo no tengo tarjeta de débito. Los pagos los puede hacer mi hija Irene.
I don't have a debit card. Can my daughter Irene make the payments?
Yes.
Que sí.
Ella los
But
quiso
a simpler thing to do would be to set up what's called a wage assignment with your employer.
Lo más fácil sería hacer lo que se llama, es parecido al embargo, pero que viene directamente del empleador los pagos.
And your company could just take $100 a month out of your check and send it to the plaintiff.
La compañía podía retirar $100 de su cheque y mandarlo directamente a la demandante.
Do you get paid every week or every 2 weeks?
¿Usted cobra semanal o quincenal?
Semanal.
Weekly.
¿Se puede hablar?
May I speak?
Yes.
Sí.
¿Se puede hablar mi hija por mí tantito?
Can my daughter speak on my behalf for a little bit?
Yes.
Que sí.
Hi, I'm Irene.
Hi.
Well, my father's not gonna work anymore. He has health issues right now, so he stopped working last week. He has heart failure, congestive heart failure. I have been trying to do payments on their behalf. They don't have a debit card or credit card, nothing. So when
Well,
I called payments.
All right, stop. This was all in English and we didn't interpret any of it.
Okay, do you want me to say in Spanish?
No,
the interpreter took notes.
well, just a minute, we'll start from here. You can make the payment for them each month.
Usted puede efectuar los pagos por parte de ellos cada mes.
The plaintiff doesn't care where the money comes from as long as it's paid each month.
La demandante no le importa de dónde viene el dinero con tal de que se pague cada mes.
But every time I try and make a payment, they say it has to be a card with either Antonio or Ana Maria's name on it.
Cada vez que va a efectuar un pago, dice que tiene que ser una tarjeta con el nombre de Antonio o Ana encima.
Can you help us with that?
Licenciada.
I think that does seem correct, that one of them has to be on the account.
Creo que eso es correcto. Uno de ellos tiene que estar en la cuenta.
We can accept a check. It will be a third-party check.
Podemos aceptar un cheque de una tercera parte.
Or a certified check or money order?
Yeah.
O cheque certificado o money order.
Yes, Judge.
Sí, señor.
Could Irene be added to their account?
Irene puede ser agregado a la cuenta.
Te pregunto.
As far as the payments go, Judge, I mean, we do have authority to talk to her.
En cuanto a los pagos, su señoría, tenemos la autoridad para poder hablar con ella.
Well, money order is fine.
Money order is fine?
Yes.
Se puede pagar con money order.
Yes, money order is fine.
All right. Very well. I'm going to sign this order that says they can pay $100 per month.
Que dice que pueden pagar, efectuar pagos de $100 al mes.
Pero ya no van a quitar del cheque. Ya no van a quitar nada de su salario de mi esposo.
So they're not going to take out any money from my husband's check anymore?
Correct.
Así es.
Oh, también nos quitaron el de las taxas de las taxas de la ciudad del otro año, las taxas del estado del otro año y de este año.
So they also there was a garnishment on our taxes from our state taxes from last year and this year.
They can continue to garnish your state taxes.
Ellos pueden seguir embargando los impuestos estatales.
But they cannot garnish wages.
Pero no pueden embargar el salario.
And they can choose not to do the garnishment of the taxes, but under the law, they have authority to do that.
Ellos pueden optar por no embargar los impuestos estatales, pero bajo la ley ellos tienen derecho de hacerlo.
I'm going to start this June 7th.
Esto va a tener fecha de inicio 7 de junio.
First Friday of each month.
Primer viernes de cada mes.
Está bien.
That's fine.
Yes, this will stop the garnishment of your wages.
Esto va a parar el embargo de salario.
Anything that's previously been seized will be applied to the debt.
Cualquier otro monto que había sido embargado anteriormente será aplicado a la deuda.
Está bien.
That's fine.
Is there anything else we need to put on the record?
Tenemos que incluir en actas.
Where would I send this and under, like, to what name?
¿A dónde voy a enviar esos pagos? ¿Bajo el nombre de quién?
Ms. Dixit, go ahead.
Be Ally Bank, ALLYBANK. So anything like checks would be made payable to them.
Todos los pagos se pone remitible a Ally Bank, ALLYBANK.
¿Y a qué
And where do they
dirección?
send it?
¿Y a
Yes,
qué
so
dirección?
I'm sorry, go ahead.
¿A qué dirección?
Our address is P.O. Box 5016. So that's P.O. Box 5016, Rochester, Michigan 48308. So that's Rochester, Michigan 48308.
And
La direc-
that address is on the order.
La dirección también va a aparecer en la orden judicial.
And put the file number, which is 211102, on the checks.
Cada pago que efectúa tiene que colocar el número del caso encima, que es el 211102.
So the first payment is due the first Friday of the month, and for June, that is June 7th.
Entonces, ellos tienen que recibir el pago el primer viernes de cada mes. Para el mes de junio, que es el primer mes de pago, tienen que recibirse antes del 7 de junio.
Mr. and Mrs. Lopez or Irene, do anyone have any questions?
Señores López o Irene, ¿alguien tiene alguna pregunta?
No, ya quedó claro. Muchas gracias.
No, everything is clear. Thank you so much.
Anything further, Ms. Dixit?
Judge, if I may, I do want to add two things, Judge.
Licenciada Dixit, ¿hay algo más? Sí, su señoría. Hay dos cosas que me gustaría agregar.
The file number is with our office, just so we can allocate the payments
All right.
properly.
Okay.
It's 820-255. So that's 820-255.
Para que podamos aplicar los pagos a la deuda, por favor, utilice nuestro número de expediente o número de caso cuando va a enviar los pagos. Es número 820255.
Está bien.
Okay, that's fine.
And the last thing, Judge, if I may, I just want to leave our phone number with Mr. and Mrs. Lowe and Irene as well.
Su señoría, lo último es que me gustaría dejar nuestro número de teléfono con los señores López y con Irene también.
The reason being our recovery department.
La razón es porque nuestro departamento de recuperación de pago,
They can help you with any issues you have with payments, making payments.
ellos pueden ayudarles si experimenta algún problema con los pagos.
And you can discuss more payment options with them as well as needed.
Y puede hablar con ellos sobre opciones de pago también.
Okay. So our phone number is 800-451-7992. I'll repeat that. It is 800-451-7992.
Nuestro número de teléfono es 1-800-451-7992.
I wrote that number on the order.
Yo apunté ese número también en la orden judicial.
Very good.
Muy bien.
Vivian, thank you for your help.
You're welcome.
You're all free to go.
Ya se pueden retirar. Gracias.
Gracias. Gracias.
Thank you.
USA, people find themselves in court.
Okay,
Okay.
all right. All right.
Thank you.
Thank you. Court does call the case of Arbor One versus Tatiana Tedder.
Cheryl, walk up on behalf of the plaintiff.
She's here, I know, because she's
Yes.
always here. All right. Miss Tedder, good morning.
Good morning.
All right. How much is owing on this one?
Total including court costs $2,956.10.
Miss Tedder, how are you going to get that paid?
Well, I'm working with DHS and I'm working with another place. But the thing is, Your Honor, I have a tax return check would have been in the mail if my mailbox door would have been fixed. I've been without a mailbox door for over 60 something days, and so all my mail is getting returned back to the place, back to the company. So I'm not getting my mail on time. I just got my court summons on last Thursday in the mail, and I've been seen to coming through the mail weeks ago. So I'm having a hard time with that situation.
Your Honor, just for clarification,
yes.
How are you getting, because that's not atypical that you received on Thursday. Are you saying yesterday you received the papers for today?
No, I'm not saying yesterday. I'm saying last Thursday.
Okay. I mean, that doesn't surprise me, but how are you?
I've been seeing I don't know if you know what the USPS mail system thing is on your phone, but you can see your mail coming to your mailbox before it gets there. And I see my mail coming, but I won't get it because I haven't had a mailbox door for over 60 something days. So they're sending my mail back to the
What do you mean?
So Your Honor, were you saying something? I couldn't hear you.
No, I was wondering,
Oh,
she says she doesn't have a mailbox door. I don't know what that means.
So we have mail. I just moved in here February. When I moved in here, I haven't had a mailbox door for 60 something days. They put the mailbox door on. I had to wait an extra 3 weeks after that to get a key. Now my mail is still not coming like it's supposed to come. So all my mail that I've been getting, I haven't been getting my mail from DHS or anywhere. So, that's putting me in a hard spot to pay anything when all my stuff is coming through the mail is being resent back to the place because they don't want to come and fix the mailbox. Everything is on their time. And then go ahead.
I just want to understand, you're saying on one hand that you don't have a mailbox door, but then you were saying that they fixed the mailbox door, and then you're saying you're not getting mail, but you're saying you received this in the mail. So I'm just trying to understand so I can help you.
Okay, so ma'am, when they send you the mail, it takes long to get the mail. Then I have to wait for them to send the mail back to the company, and then the company resends the mail again. You
Okay, but hold on,
Miss
Tedder, I think what's being asked is, do you have a mailbox?
Yes, I do currently. Now I do have a mailbox door, but I have to wait for them to resend the mail over and over again to even get the mail. I would have had my rent paid if I would have had the mailbox door, but with them sending my mail back every time it comes, I can't get the mail.
All right, so ma'am, you're indicating that there was a tax check you were supposed to receive?
Yes, and my bridge card, I couldn't get that.
Well, hold on.
Hardly anything.
Hold on, ma'am. And you were going to use the tax check to pay the rent?
Correct, because I'm currently just stopped working. Because I'm 8 months pregnant, so I'm just stopped working.
All right. Okay, ma'am, here's what you're going to have to do. You're saying you have proof that it was delivered to your mailbox?
I have proof that a lot of mail have been. Yes.
But the one I want to see is that the tax check came to your mailbox. So you should be able to print that email and send it to the court.
It's not an email.
It's a nice picture of that check.
It's not a picture of the check. It's just a picture with Stan from the Treasury Department. It's like a real picture of the mail.
No, I know. I know what it is. I'll see the
Okay.
envelope.
Okay, yeah, and then and then I had something else as well. I don't know if it's like Arbor One on here as well.
Pardon?
I said it's Arbor One on here as well.
What do you mean, are they on here?
Like, because I've been having issues. I've been having issues with them coming to fix my property, period. I have black mold growing under my sink. I have a sick child in here who has a heart condition already. My kitchen floor is so wet from every time I turn my dishwasher on, turn my kitchen water on.
Miss Tedder, here's what we're gonna do. Miss Tedder, you need to submit to the court. I want to see a copy of the email that shows that your tax check came or either wasn't delivered, but I want to see proof that it was headed to your mailbox.
Okay.
And then you're going to need to file an answer if you're claiming that there are repairs that aren't done. Did you submit a request for repairs?
I have submitted so many requests. I have went to the office so many different times.
All right, here's what you're going to have to do. You're going to have to put all of that in writing. You're going to have to send the court a copy of the repairs that you're requesting, as well as a copy to the attorney for Arbor One.
Okay.
Miss
I need that in
Tedler.
writing. I need that in writing to the court by next Thursday.
Okay. And like I said, I am working with DHS and stuff too, because now I don't know how long it's going to take for them to reissue the check and stuff. So I did call so I can at least have something going on.
What check? DHS issued, you say they issued you a check?
No, I'm saying I'm working with them because I don't know when I will receive the check again through the mail.
Okay, I need proof that you're working with DHS also.
Okay.
So you're going to need to get all of that to the court and a copy to counsel. If I don't get this stuff, then I'm going to grant them a judgment. Understood?
Yeah, how will I send it in?
Pardon?
How do I send it in?
It can be brought to the court anytime.
Okay.
We're open every day from 8 till 4.
Okay.
Turn this out to the 17th, 2024. What time? 3 p.m. Okay, thank you. Arbor One versus Nicole Parrish. Whitaker Oaks versus Anthony Williams. And
Daniel Landman for the plaintiff. I do see Anthony and Christina Williams, or at least one of them.
All right, where are you folks? If you can speak up, you got them.
We're here, Your Honor.
Okay, there you are. Both of you are there?
Yes.
All right. And what is the claim in this?
Your Honor, my client is showing a balance of $2,212.95, as well as costs of $214 for a grand total of $2,426.95.
All right.
Your
And
Honor.
folks, yes, ma'am.
It's confusing because they brought us paperwork and my balance shows 1,085, but they have us connected to all of the paperwork they sent us in the mail is somebody else's lease. It's somebody else's total stuff, but I was told 1,085 and I did try to take partial payment, but I was told by Chloe until you tell her she has to, that she can't accept partial payments.
Okay.
Because we were in court with you in February, sir, and I lost my job because I was in court. So I've been working for 2 weeks and I have $600 right now to give them. And then next week I can give 400.
And we'll just continue, to pay. But I have cancer. I don't work, and she lost the only employment we had from going through this last time. And now she's just,
So you can pay 600 today.
Yep.
And
then
then you say you have
400.
400. What day will you have 400?
On Friday.
Of next week?
Yeah.
Yes.
Okay.
Then we know we still have 12.
But I'm not sure where the 2,000 and something came from. The balance on my paperwork I have from
Okay,
the
hold
court.
on, hold on.
I'm sorry.
It's all right. The paperwork that you're probably looking at, because it's at $1,087.59.
Yeah.
Yes.
Okay, so that was the complaint that you're looking at, but May's rent has clicked in.
Right. I
Okay,
understand that. And
okay.
I will have that before the end of May. I'm just doing my very
Okay, all right,
best.
all right, Miss Williams.
Yeah.
Let's try to take it one step at a time. You guys are going to basically get $1,000, and then we'll try to see and try to figure out the rest. Okay.
Yes, sir.
Okay.
Okay. So, Miss Williams, you all right?
Yeah.
Okay. Let's do this. You've got the 600 today, right?
Yes.
Okay, Miss Williams, get that over to the landlord. Mr. Landman, direct your client to accept her partial payment.
I will do that, Your Honor.
And they really should be doing that anyway.
As well as the
And
others that
then-
you've ordered today.
Yes. And Miss
And you're-
Williams,
Yes.
Miss Williams, then I'm going to adjourn your case out to May 17th, 2024 at 1 p.m. When you have the other 400, right? Don't wait to come to court for me to order it. You take it right over there to them.
Okay.
no
I will.
problem.
Most definitely.
All right. And then what we'll do is we'll take a look at where you are next week and see what we can arrange.
Okay.
Thank you.
You're welcome. All right. We'll see you then.
Thank you.
Thank you. You'll have to
Hello, I
unmute.
am here. Yep. Hello, I am here.
Okay. Hello. All right. What is the claim on this case?
Your Honor, the total balance, $2,241.10.
Ma'am, how are you intending on getting this paid?
One, I'm working, so my check comes in on the 23rd. As well as I would like an adjournment. I am seeking legal assistance through LSCM. And I'm already speaking with a legal assistant there. And I would like time to apply for rental assistance as well as an adjournment to get more legal assistance and be able to have time to fill out a written non-payment answer form and return it to the court.
You read that very nicely.
I'm not reading anything, but there's a lot of problems. We've had a hole in our bathroom, and our bathtub has been unusable now for 2 months, and they have been well aware of this situation. And it was not
All
our.
right, ma'am, I'm going to grant your adjournment for a week.
Okay.
May 17, 2024, 3 p.m.
Thank you.
All right. And if you're going to have an answer in or any financials, you need to have it to the court by this Wednesday.
Okay.
Understood?
Understood.
$5.10. The total redemption figure, $2,520.16 with a date of May 20th, 2024.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue 10 days. Arbor
Thank you.
One versus Darius Gibson.
Cheryl Walkoff on behalf of the plaintiff.
Here, Your Honor.
All right, Mr. Gibson. What is plaintiff's claim in this?
Your Honor, total amount due, including court costs, $2,806.10.
Sir, how are you intending on getting that paid?
I actually paid $1,100, and it's on my paperwork, 1,125. I literally just paid that within the past 3 days. I get paid this Monday, and my girl get paid this Friday, so I will have the rest.
All right, hold on. You're saying you paid around $1,100 this past week?
Yeah.
Okay, hold on. Do you see that, Ms. Luckoff, or?
I'm looking right now, Your Honor. No, the last payment I am seeing is on April 3rd for $400.
It should have been 500, and I just paid. Like I said, I just paid within this current week. I just gave him $900.
Hold on a second. You told me 1,100. You got 900. What did you pay to them?
Okay, my bad. I'm sorry about that. This current week I paid 900, and before I got on the video call, I just dropped off $230. My bad. I was sorry about that. I left that out.
Okay, so we're not going to see the $230. We don't also see the 900. So you're saying you paid 1,100, basically 1,100 of this.
Yeah.
Has been paid in the past week.
Yes.
And then you say the rest of it is going to be paid when?
Basically this upcoming Friday.
The 17th?
Yes.
So here's what I'm to understand. You paid 1,200. There's about 2,806.10, I think, or maybe that's the exact amount. You paid 1,100, so you have about 1,700. Is that right?
Yes.
There'll be about 1,700 that would need to be paid. That's going to be paid on the 17th?
Yes. Okay. Hold on one second, because I'm grabbing my paperwork. My paperwork said I would have to pay. Sorry about that. 1,128, unless this month's rent has got added to the balance.
It has.
Okay, so I paid that 1,128, so I just owe this month.
Okay. And are you going to have all of that paid by the 17th?
Yes.
All right. Maybe over the objection to plaintiff, I'm going to give him a week. The balance has to be paid. Sir, if the balance isn't paid, we're not even going to talk about it. If the 1,100 doesn't show up and the balance isn't paid by the 17th, there's going to be nothing else to talk about. I'm going to grant them a judgment. We're done.
Yeah.
Understood?
I understand. Quick question real quick, Your Honor. Would it not show up because the $900 check was in my girl name?
I don't know. You're telling me you dropped off $900 to them. They ought to have the 900.
Yes.
They're not showing the 900. You only dropped off, and you dropped off 200. You said this morning. So
Yes.
there's $1,100 over there. So it's going to be your responsibility to go over to the landlord and double check that.
Okay.
But that's going to have to be paid. The balance is going to have to be paid by the 17th. So this case should be dismissed on the 17th. If not, I'm granting them a judgment.
Okay. And you said what was the balance due again? Sorry about that.
I had 2,806.10.
Okay.
Then you subtract out whatever you say you paid, and that's the balance that needs to be paid by the 17th.
Okay. Thank you.
May 17, 2024, 3 p.m.
Thank you.
Cusisto?
Cheryl Luckoff on behalf of the plaintiff. Your Honor, plaintiff moves to dismiss this without prejudice.
Okay. Got it. Case is dismissed without prejudice. Then I have Six Trails versus Lisa Sabo. I think she's here.
Cheryl Luckoff on behalf of the plaintiff.
Sabo, you unmuted?
Yes.
There you go.
Yes.
Okay. And what's the claim on this case?
Your Honor, total due is $2,264.
You're at 64. And Ms. Sabo, how are you intending on getting that paid?
I am currently on a leave of absence taking care of my mother. I applied for assistance with Hawk and DHS. I have an appointment with someone from Hawk on May 24th. And DHS is supposed to contact me on Monday.
Okay. First of all, I would need your application for your DHS application. That it would have to be in the court by Wednesday.
Okay.
I would also indicate to you that it may I can't go to the 24th. My understanding is that Hawk may be out of funds. So I can't, that appointment's not going to do us much good.
So I'll need some time to hear back from DHS.
Okay. And ma'am, so that you understand, how many people are in your apartment?
Just
with you?
me. Me.
Just you?
Yes.
All right. So that you understand, the most you're going to get from DHS if they give an award is going to be $410.
And I applied with it says Celine Social Service. Worker is supposed to contact me on Monday around 10 o'clock in the morning. She is setting up an appointment for me to go in, submit, and take her all the paperwork that I have. She's not sure how much she'll be able to help me with.
Okay, so you contacted Celine Social Services.
Yes.
Okay. All right. If all of that falls through, there's not really a backup plan for you, is there?
I go back to work. I'm scheduled to go back to work at the end of the month.
Okay. All right. Well, I know sometimes Celine Social Services come through with some funds, but I mean, even if you get everything you possibly qualify for DHS, you're still going to be about $1,800, a little over $1,800, about $1,850 you'll need. So you might want to tell the people at Celine Social Services that if that one part comes through, that's where you are.
Yeah, she said she's gonna, once she goes over all my paperwork, she's gonna see what I am qualified for, what they can help me with.
Right. But what I want you to let them know is the total amount that you're behind, which is the $2,264, but also that DHS is only going to come through at best with around $400. So that's the amount you're short. Okay. It's important for them to know that.
Yeah.
Okay. I know they're going to indicate what you're qualified for, but they need to know how much you're in need also.
Okay, I'll let her know that.
All right, I'll give you a shot. Let me adjourn it to the 17th, see what you can come up with. You got to get the form for DHS into me by Wednesday.
Can I do that today before I leave?
Pardon?
Can I do that today before I leave?
You can do that today. Do you know how to use a QR code?
Yes.
All right, there's a QR code on the screen that will take you to the form that you need to file, the rental assistance form that you need to file with the court.
Okay.
Okay.
Thank
I'll
you.
adjourn it to the 17th, 2024, 3 p.m.
So do I come in court in person that day?
You can come in person or Daniels. You guys are here.
Just so you know, this is actually
Second. Yeah, I see that.
Your Honor, plaintiff.
Your name?
Gerald Davis.
All right. Where are we on this? You guys are trying to work with each other, I think, and
Yeah, we met yesterday. He paid 600 and we agreed he owes another 345. That's 225 in rent and 120 in costs. I can
if you the three, what'd you say, Mr. Hunter? 3, 4. So if he pays that, we're good.
I can pay that by Thursday, depending on the money coming my time, talking my job. If it basically Friday, but I pay it by Thursday.
Of next week?
Yes.
You sure?
Yes. I can pay it every week.
And you believe it? I don't know. All right, now listen. Yeah.
They contacted me yesterday that they had money for me.
They did?
Yeah. And so I have they said it would be by today they would have money. Because a lady from Friends and Need was willing to take on this situation to just take care of it.
Okay, hold on a second then. Amy, are you there? I know that sounded like a call of distress.
Good morning, Your Honor. I've been here.
Okay.
That was the 5 I needed.
Do you know anything about Mr. Daniels?
Your Honor, I would like a minute to look up his
Okay.
Thank you.
That's fine.
Could I just clarify who his caseworker was? That he's
Do you know who your caseworker was?
I can't remember the name.
He can't remember the name.
is it Autumn or Alicia?
I think so, because I
Autumn or Alicia?
yeah, I faxed him all the information.
Okay.
Email it.
Mr. Daniels, those are alternatives. Is it Autumn or is it Alicia?
Maybe Alicia.
Maybe Alicia. He's not sure.
Right here.
We gave him a choice of 2 and he still can't get it.
One more question. What is just the year of your date of birth, sir?
The year of your date of birth?
1966.
1966.
Right, Mr. Daniels, I have permission to share some information that may be of some relevance to this case today and in the court.
Sure.
Okay,
Said sure.
Okay, thank you. So he was supposed to be working with Alicia and looks like there's been some issue with actual document sharing. Which indicates that even if he is qualifying for the programming, I am not sure if the high funding ran out this week. So there may be one or two other things that Miss Alicia might be able to try to qualify for him. But whatever may have been indicated in terms of a larger amount of money, I do not believe that that is something that he can rely on for today.
Gotcha. All right. But you say you can pay it.
Yeah.
Okay, then let's not worry about it. Let me adjourn this out to the 17th, 2024 at 2 p.m. You guys, if you guys get it worked out, because you guys are working together meeting, if you get him paid, then I just need a dismissal, or if you guys don't show up, then I'll know that I'm just going to dismiss it out. How's that sound? All right. Thank you, folks.
Thank you.
And Amir, is it Batish versus Matthew Nash? Good morning. Your name? All right. And Matthew Nash or Melissa Nash? Plaintiff's motion without. Court does call the case of Nation Star Mortgage versus Vicky Christie. And Jack.
Good afternoon, Your Honor. Andrew Cates, P78292, standing in for counsel of record and representing Nation Star Mortgage in this matter.
All right. And hello. Okay, who do I have here? You're Vicky? Okay. All right. Where are we on this case?
Your Honor, we reached a consent agreement. Basically, the defendants have vacated the property already. So I just put that they needed to be out by the 21st of May on the consent judgment. They're payment there, so that's a point.
Okay. Ladies, is that correct?
Yes.
All right. You moved out and you've gotten yourself someplace else? Okay. Did you need the judgment to secure the premises, I guess? Is
Well,
that?
there's some personal property left in there that's like a couch. That
What?
Well, actually, Your Honor, if you'll give me another second, and we could actually do a conditional dismissal.
That's what I'd like to see, lady, so that you understand. That would be a judgment. That would be something that somebody could look at on your record. What I think this case might be suited for is a conditional order dismissal. That way the case looks as though it was dismissed. You've already vacated the premises, and that way nothing appears on your record. And I'd prefer to do it that way if we could. Okay?
Okay.
Would that work?
I will
Okay.
write up the document right next.
Thank you, counsel. Put it past that matter. Really? From here, you can sit right there. Will that work for you? Okay, I'll just yell. Okay? All right, thank you. What? All right, where are we?
Your Honor, we've agreed to a conditional dismissal in this case. Obviously, the plaintiff wants the property. The defendant, I've given the defendants until 10th of June to move their personal property out because there is some larger pieces like a couch and a bed that need to be.
Okay.
Obviously,
They're
they have a little
trouble trying to get it done.
Yeah, so I gave them till 6:10 to get that accomplished. And after they did that, then they dismissed this case.
All right. And you're checking for a B so that if they fail to do that, you can submit a judgment, a writ with the judge. Okay. Folks, is that correct? Okay. Do you have any questions regarding that conditional order dismissal? Okay. I need you to understand that if you fail to vacate the premises by the 10th of June, then the plaintiff can file without notice and without a hearing. They can file what's called the judgment for possession as well as the order of eviction for immediate signing by the court. You understand that? Okay, all right. I know. I have to advise you, but you understand that? Yes. All right. Also, since this is a conditional order dismissal by consent, I do have to advise you, since you're underrepresented by attorneys or by counsel, that you have 3 business days to think about this. If you believe that there's some legal reason, some confusion on your part, or some right you didn't assert, you'd have to file a motion with the court or a request that the court do something to set that aside. You understand that? Got it? Yes. Did I speak loud enough? Yes. All right. Do you have that, counsel? I do. Have you guys signed off on this? Yes. All right. This case is conditionally dismissed. I've signed it. You're all set. You guys were much more pleasant than the last group. All right. Thank you. Thank you. Is that good morning. Your name? All right. And Matthew Nash or Melissa Nash?
Yeah, here, Your Honor.
Where? Oh, they're right there. Okay. All right. Sir, how much are you claiming is this is a termination?
Month of April and the month of May, court costs a total of $3,470. Termination of the lease ends in 3 weeks. May 31st, it was a 12-month lease. Signed in June.
Well, hold on a second. So why are we here now?
We're here now because the month of April.
Okay, so hold on a second. Here's a problem. We got a problem. You filed a notice to quit, or the notice for non-payment of rent. Okay. The complaint that you filed is for termination of tenancy. So you have the wrong complaint.
Okay, then why don't we just keep it notice of termination?
Keep what notice of termination?
Oh, I'm sorry.
It's okay. It's okay. So the only way to correct this is that if you want them terminated from the thing and not care about the back rent, then you'd have to dismiss this case and start over. Or what you can do is file an amended complaint for the non-payment of rent. And you could do that today before you left the courthouse. I'd adjourn it out a week and then we'd proceed.
Okay, I'm sorry.
It's okay. Which way do you want to do it?
I will file an amended complaint. That will.
Okay. Then you file the amended complaint when you go to the counter. Folks, so that maybe we can get started on it a little bit, because he's going to file an amended complaint, so the case won't go away. So what, how are you intending on getting this paid, if you are?
But right now, I'm waiting to hear back from my caseworker at the VA. As far as
You're a veteran?
Yes, sir. I'm a disabled veteran.
Which branch, young man?
United States Army, sir.
All right. All right. Well, I'll just say this. Thank you for your service.
Thank you, Your Honor.
Because of you, and is your wife with you?
Yes, sir.
All right. They probably serve more than you guys do, so I'll thank her also. Because of you guys, I get to do what I get to do, so I am always appreciative. All right.
Thank you, Your Honor.
You're so you're waiting to hear from the VA?
Yeah, I've been in contact with the program at the VA. I have actually, and I've been in contact with the county VA services too. So I'm just waiting to hear back from one of the two.
Okay. Did they say when they might get back to you?
Deetra was the lady I spoke to at county. She didn't give me really a time frame. I talked to her yesterday. She said she would get back to me as soon as possible. And Carol's the other woman the lady that I talked to at the VA in Ann Arbor, and I'm supposed to hear back from her either today or Monday. So,
okay. So let's do this. So usually the VA is pretty good about. Yeah, go ahead.
So honestly, the only reason that I put this gentleman and his wife in my space was because he was a veteran, and the Veterans Office gave him a $2,000 security deposit and the first 2 months rent.
Okay.
Then the rent was never paid on time. So then in January, he was behind January, February, and March. The VA office gave me at the beginning of April 3 months of rent. So then
Beginning of April of
this year.
this year.
So far the VA has helped to 5 months of rent.
Okay.
$2,000 in security deposit. He's been very blessed to have a VA. And I've been.
Well, we've been very blessed to have his service. So I don't know what it is about the VA. I don't.
And I like both of them.
Okay.
You know, I've been incredibly nice, honorable, as much as I can possibly be. And then in April, I received the check for 3 months. And I thanked them, let them know, and I said, please, can you pay the April rent? I heard the same excuses. So then here we are now.
So what do you want me to do?
Well, I'm sorry, I didn't file the right.
No, you didn't.
No. And I've been a tenant for 36 years in a commercial building. I've never been in front of a judge like this, and I apologize about that. So what I'd like to do is file the amendment, and then going forward, the lease ends in a couple weeks here. I just need to move on. My banker needs me to move on.
So I don't know what you want me to do. You can
Your
file a
Honor.
non-payment. If they pay the non-payment, they're there. If you want to file a termination to have a move out, you have to refile it.
So I will file the amendment.
You got to file the amendment, and then you got to make sure a copy gets mailed to them and served on them. Well, a week, if you can get it to them within a week, yeah. Okay. Mr. Nash, you wanted to say something, sir?
Yeah, so I just wanted to let Mr. Bashir know, I'm just trying to secure, we plan on being out the 1st of June. We plan on moving anyways, because like you said, our lease was up. I'm just trying to secure the back rent for him. I'm not trying to pay him so I can stay or nothing. We plan on moving by the 1st of June. So he doesn't need to file for a termination or anything like that. We already have the plan set and forth in motion. I'm just trying to secure the back, the back rent for him. So when the VA paid it,
Gotcha.
Some got messed up with the controller, because usually how they do it is they pay whatever back and then some forward. Well, there was a mistake with the paperwork that was filled out between me and Mr. Bashir and everything. Well, they didn't, I had sent a message to Mr. Bashir to let him know that I wasn't sure if they were going to pay the April and stuff to let me know. Well, I only found out on the 16th when he filed for the notice to quit. That's how I found out about it. I've sent multiple messages to Mr. Bashir. I don't know why he doesn't respond.
Okay, love.
But
here's what it is.
I plan on being
here's what we're going to do, folks.
Yes, sir.
You need to file the amended complaint. I'll see you guys next week.
All
May
right, thank you,
17th, 2024 at 2 p.m.
Thank you, Your Honor.
We'll see exactly where we are. All right, thank you.
Thank you.
Yes. That's it for us. Thank you. That's it. 14A stands in recess. Westbrook Apartments versus Malu North.
No, we're here.
Okay, do you have a camera? As well as
Yes.
Isra Bazi. Thank you. Right, yeah. All right. And where are we on this case? There was supposed to be $1,600 paid.
We have not received any payments since.
Well, hold on. I may be looking. No, that's right. That's right.
Might have received no payments since a $200 payment was made on April 24th, which preceded our last appearance.
All right. What happened, folks?
My check was delayed. I can make 600 payment now. We did also get approved from Michigan Bridges for 500, and we have a hawk appointment the 14th.
Okay, but last time we were here on the 26th, you had indicated you were going to pay $1,600.
I said $400 for a week, and that same day I said 100. I didn't say 1,600.
My note reflects 1,600, but how much what do you have as the current balance?
Judge, presently showing $4,560 unpaid rent, $187 in court costs. Total to retain will be $4,747 even.
4,007. Say it again.
$4,747. 0 cents.
4747.
Yes.
4747.
All right, folks. I mean, I don't know. You said you had what, DHS, an SER payment?
Yeah, they approved us for $500.
And Hawk, we have an appointment the 14th.
The 14th, but
Yes, so 4 days.
well, right. But the problem is that with Hawk, that's county money and they're out of it at this point. Their funds are depleted, but I mean, there may be other agencies which will pay, but I don't see how we're going to do this. And, you know, you said your check was delayed, but even if you paid the 600, that's still, we're at 4,100 at that point. And you got the 500, but you'd have to make up before that 500 from DHS is paid, you have to pay the balance. So the reality is, even if you qualified, I can't even tell you if you did. And if they had money, you'd get 3,000 from there. You'd have 500. You pay the 6. We're still short.
I mean, we're both working now. It was just Ezra working for a while. We're both working. We can make as best payments as we can.
No, young ladies, I understand what you're indicating, but the problem is I can't even if I could cajole counsel and the plaintiff to do something different, I can't even go to them with that because I can't make the math work. I just can't. I think I'm pretty good at it, but I just can't make it work where you would even be able to get this clear before the end of the month. If I were even thought of trying to find a way to work that out, and then how much is your monthly rent?
1,600.
So
And that's one of our concerns. It's right back to square one coming.
yeah, I mean, well, or even worse, because this other amount's not going to be paid.
Unfortunately, this has been an ongoing issue for a number of months, Your Honor.
All right.
Even preceding this court case, we were here previously in another situation. So this has been ongoing for long over half a year.
All right. Young ladies, if I issue a judgment to them and you guys can't pay it, what are you guys going to do?
I mean, I don't know what that means, to be honest.
Okay. So that you know, the way that this
with the
go ahead.
I was just gonna say, I don't know how much time would the judgment give.
Okay, normally what the judgment gives is 10 days. So if I gave them a judgment today, they could attempt to, well, they wouldn't be able to do anything for 10 days till the 20th of this month. But then after that, they could file what's called an order of eviction with the court for my signature. And then once that's signed, the best I can tell you is that you're operating on borrowed time.
Judge, I can say this. I just spoke, I have a representative for my client here, and I just spoke with the judge. I could extend the writ date out to May 30th. I can give them an additional 10 days beyond the 10 days.
Gotcha. All right, look, I think, young ladies, it's time. I don't know the current situation that you're in. I don't think you can afford to live where you're living. I mean, I hate saying that to people, and I hate telling them that, you know, you may have to move and whatever, but I think that's where we are with this case.
Okay, I appreciate your honesty. I just have a question.
Yes, ma'am.
Let's say we do move by May 30th. Can I ask what would happen after that?
What do you mean?
Like, we have till May 30th to pay it or move. Is that what that means?
Yes, you would, if they've graciously given another 10 days, you would have till the end of the month, in essence, to pay or move.
Would it be an eviction after, like on our record, if that's the case, or
If I issue the judgment, yes, there's going to be an eviction on your record. It won't be so that you know they didn't request. There won't be a money judgment, something that necessarily follows you around, but the eviction, the judgment itself would follow you.
I will indicate for the record, I can't make any promises, but frequently my clients, if they can recover possession, are not disagreeable or are sometimes agreeable to setting aside a judgment if possession is turned over on a recorded date that's been agreed to and it's turned over in good condition. So the possibility exists. I can't make any promises to you ladies, but if you do vacate by the 30th, don't require my client to incur additional court costs and the property is turned over in good condition, my client may be willing to set aside the judgment so that it's not in your record any further. You could reach out to my office after you vacate and I can talk to my client.
You understand that?
Kind of.
Okay,
I'm sorry.
what don't you, I want to make sure you understand, huh?
his voice was a bit too far, if you could
I'm
let us
sorry?
know. Your voice is clearer, if you could let us know.
Oh, okay.
Yeah,
So
it's kind of
here's
glitching.
what they're willing to do, which I have to thank counsel and the representative here because it's impressive. Not many landlords are willing to do this. But instead of, if I grant them a judgment today, instead of your move out date being the 20th, they're willing to make it the 30th. Okay. So that gives you additional time to try to get yourself situated. And then your next question was whether or not there would be a judgment on your record. But counsel's indicated that he can't commit his client to that. But sometimes what they've been willing to do is to, if you move out on time, leave the place in good condition and, you know, turn over the keys and do everything in the right way, that they're willing to then set aside the judgment so that you then don't have a judgment on your record. He can't commit to that because you haven't moved out. But then he said that you should reach out to his office after you moved.
Okay. And where's his office's information for us to reach out?
That should be on the pleadings that you received, the paperwork.
Oh, it's right there. Okay, we see it. All right, thank you.
Are you guys going to be, you're going to be able to get yourselves situated, do you think?
If it's by the end of the month, yes, we should be able to.
You should be able to.
That would be great.
Okay.
We should be.
Well, you can thank the plaintiffs for that. I might have been giving you more time, but I don't know that I would have been as generous as they have been in this. All right. So let's do this. I'll do this. I'll indicate that there's no triable issue. I'm going to issue a judgment for possession. The total amount is $4,747. that would have to be paid on or before the 30th of May, 2024, or writ or order of eviction could issue. Okay?
Okay.
Any other questions you have? Oh, you muted yourself. Okay, you're good now. You have any other questions?
We're good. Thank you.
You guys are welcome. All right. And I wish you all the best. Okay.
No.
Thank you.
Good luck, ladies.
Thank you, Council.
Oh,
You do the same. That's where I was sitting. Nope. Got it. Okay. Thank you. Court does call the case, People of the State of Michigan versus James Whitley.
Your Honor, for the record, my name is Jeffrey Dunn. I'm very glad to have Mr. Whitley stand to the right. Sir, please state your name.
James Dennis Whitley.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people.
Anything additional from the defense?
Nothing. Yes, Your Honor. One thing additional is that if the court finds that money bail is necessary, I believe that based on this case, an appropriate bail would be something like a $10,000. The current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think, address what the primary concerns are in the report. He was intoxicated, and of course, he should not be around here. But the reason I think primarily that the $150,000 insurance bond is excessive is he has no history of any violence whatsoever. In fact,
well, can I just stop you there, because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment, and my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea Lanes to make sure she got home safe because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty. Well, let's put it this way. According to what I have, he shouldn't have been driving. That's number one.
He wasn't tested. The allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed, my understanding is his license is revoked with restrictions, and that his activities in going there that night would not have been within his restrictions on his license.
Okay.
Right? Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may have been intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving with this habit, then an added condition that we can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events as you're telling me they may have existed at that time.
She was intoxicated at Chelsea Lanes. He wanted to try to drive her home. She refused. She drove her cell phone. I haven't seen the alcohol test. I don't know whether or not she passed or not. He followed her home to make sure she got there okay. The parties he had generally, I believe, according to the report, it's spent most nights there. Then they got into an argument and he tried to leave, couldn't find his keys, and that's when the incident with the bed, the phone, and the glass break began. I think, in my opinion, those sort of discrepancies are only, I guess, the absolute truth, I guess, would be relevant to the bond, but they decrease the likelihood of conviction when you have the alleged victim saying that her statements weren't entirely accurate and wishing to recant, and him saying he was looking out for her. When the argument got loud, he had asked her to keep it down so her children wouldn't hear them arguing, because he was concerned about trauma they experienced from a prior abusive relationship. And telling her to calm down actually escalated the fight, and that's when the incident happened in the bedroom, which there's a disagreement about what that was. That, at the end of the day, resulted in the injuries that were sustained by the alleged victim to her wrists, our arms, and a head. I would clear up, since you gave me a chance, there were actually, I believe the people said there were 3 CAT scans, there were 4, there were 3 x-rays. I was able to do what they provided. But I think that the key issue in this bond is somebody who is a close friend, the alleged victim, has known Mr. Whitley for 20 years and said he's not violent, that this has never happened. So, regardless of whether or not there's a conviction for purposes of bond, he does not pose.
Well, if I consider him a danger, yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving, in violation of his restricted license, breaking the law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now, as you're relating to me, that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving? And then, you know, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level because he's not this law-abiding person that you say he is, because he's obviously driving. I mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night, at least. So, I don't know. Sparoso, was there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't know. I get that he was driving. It's violating his restriction. It doesn't warrant $180,000. I do think that some cash bond is appropriate. This one. I think it should be something that powers, especially in case that the likely sentence is probation.
Understood. And what I am additionally indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What were you going to say?
I was just going to say that sounds like testimony.
Oh, I'm sure it certainly will, but I don't have that at this. It normally would during a bond hearing. I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion, how she'd know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's funding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions that she set in place. I will set the defendant's bond in the amount of $35,000 cash surety. Defendant remanded. Afternoon.
They have your admin wife, Paula. She's not here today. She's on appointment.
All right, Eric Cassidy and Paula Cassidy.
And actually, you did retain a lawyer.
I know, where is she?
She could not be here today. She's available next week, but you know, we're happy to go forward, but she's available next week, next Friday.
Okay. Go ahead, your name.
Donato, appearing on behalf of Alec Jerome and Caroline Jerome, who are the landlords and owners of 3270 North Maple. In our summons and supplemental complaint, I gave you the numbers that were owing from as of April 15th. I have updated those.
Okay, so
Yes.
I'll just stop you.
Okay.
Did you receive the answer and affirmative defenses?
In the hallway.
But they are substantially the same as what was filed.
So
This was dismissed about.
No, I know.
I mean, I've looked through them. They're not signed and they're virtually the same.
Okay, so.
Filed in the case to be dismissed.
Yeah, I know. Okay, a couple of problems. First of all, you're represented by counsel, they're not here. Okay. That's the first thing. The second thing is, rather than taking a lot of time, I've got another problem with your filing. Okay. You gave a new notice, right? Okay, for 30 days, right? Like we had talked about.
That was on May 3rd.
Right. Problem is you filed the case before the notice expired.
I knew that that I wouldn't be heard until after that May 3rd date.
I know, but you can't. I follow what your intentions were, but you can't file. I want to say this. You're giving them 30 days to move out. They have to do something before a cause of action arises. So they either have to move out or some way do something. The problem is that you filed the case before their period in time to do whatever you were telling them to do, which was move out.
Paid as well.
Okay, either way, they had a time period on which to do that. I know they didn't, but you filed a case before that.
It wasn't heard or answered until after that date. So you're going to dismiss this again?
I am not going to do that. I'm saying that's a problem I have. Here's the other problem, the other part of the problem. And I'm not sure where it would end up. If I dismiss your case, their case, the case doesn't go away because they filed a counterclaim and a request for declaratory relief and an answer. So I would have one side of the case pending, right? And I wish counsel were here because counsel would understand exactly what I'm saying. So I'd have the one side of the case pending. I'm presuming that then what you would do is you can use the same notice that you have here. You'd refile. And then what would happen is I would have two cases pending at the same time that I'd have to join together.
Okay.
So if counsel were here, I would suggest to her that she not move to dismiss, waive whatever may come from that, and just keep this going and everybody kind of head into the direction that we're going. Okay. But she's not here, so I can't ask her that. So you said she's available next week?
Yes, I'm sure she wants, because we don't, on Friday.
Yes. Well, they're always on Friday. So what I'm going to do is not dismiss your case at this point. Okay, but that doesn't mean next week it might not happen, right?
We still have.
Well, right, but I'm just suggesting a quicker way to get, well, not around it, but to get everything moving. And so I'd prefer to give it a week, let that happen, see what counsel says, and then we move. The worst thing that's going to happen is I dismiss your primary claim, you file again. You don't have to wait on the notice because now the notice has expired. And then I'm going to set this other case out until that other case catches up, because that's what I'm going to do for judicial economy. So, got it?
Yes.
I know you don't like it, but it's what I have to do.
No, I like whatever you can do so that this case does move forward, because the stalling of it has raised it over now. They want it dismissed because it's over $25,000. Well, that's because they haven't paid anything since September. So.
Oh, that is incorrect.
What is incorrect?
Yeah.
Okay,
They've been in affairs.
folks, I cannot litigate this today.
No, I know. I'm not unhappy, and I'm not, I'm very pleased that you are able to create a way forward.
Well, let's hope. Okay, well, you're welcome for that. May 17th, 2024, what time?
2 p.m.
At 2 p.m. We'll see you guys then.
Just briefly, Ms. Miller did file a very short motion of other issues that she has for the case. It's with your file.
She did what?
She filed.
I know, she gave me a whole tree.
Yes.
So what?
On the inside cover of the tree is a motion that lists 5 different issues that she wants to raise with you next week, if you want. And she also filed this issue. Inside cover of that.
Got it. We'll see you guys next week.